everyone
to
and we're equal.
explain your situation.
If there's an engineer here
Kung gusto
or a
po ninyong
doctor and they talk
mag-explika
about medical
ng inyong
principles,
mga saloobin,
I have to either
problema,
study and argue
maaari
on
naman po
medical
ninyong
principles.
gawin yan sa
Hindi ko
labas
pwedeng
po
sabihin,
ng
hindi,
oras
ganito
ng
lang yan,
impeachment
logic
court.
lang yan, etc.
Maaari
Diba?
pong sa press
So, ang
conference,
legal
nandiyan naman
principle
po ang
natin
Senate
today is
media.
simple.
Anytime
Integrity
po,
ng
nandun
court.
sila sa Senate briefing
So,
room,
allow me to
press briefing room.
mention
Maaari
that
din
to the
po sa
people and help
Facebook
educate
o
my
sa
colleague
YouTube
here.
magpaliwanag. Wag
The
po natin
integrity of the
gamitin
court
ang oras ng
and the
impeachment
justices or
court
judges
sa
is
pagpapaliwanag o
always
sa
relevant.
pagtatanggol ng ating
So if
mga
the Supreme
sarili
Court or
simula pa po
COMELEC, Court of
noong
Tax
nakaraang
Appeals,
linggo.
Sandigan Bayang is being heard,
Because the
and the
time
judges
we
are being
waste here
threatened,
to defend ourselves,
you give them time.
defend what we
So we cannot
believe
take
or
the
what
impeachment
have
out of
you,
context. May
is an
nangyayaring flood
injustice
control
to the
scandal. May
Vice
nangyayaring gulo sa Team
Yung oras
Unity na
po na
hindi na
ito
united
dapat
ngayon.
ilaan natin sa pakikinig, sa
we consider
depensa
Senator Marcoleta
ng
and
Vice
Senator
Presidente, sa mga akusasyon
Jinggoy
laban sa
political
Vice
prisoners,
Presidente,
weaponized
hindi po
yung Blue Ribbon Committee at
pagdidepensa sa mga
weaponized
sarili
yung
natin
So
kung
Mr.
tayo
President, hindi tama
inaakusahan
na
ng
sabihin
kung anong mga ahensya,
na I wasn't,
kung tayo po
after
ay may
we
mga kaso, may mga
brought up the
investigasyon.
problem with NBI, they doubled
This
down
is
na gumawa
not
pa
the
ng
right
task force.
forum, Mr. Presiding
I
Officer,
mentioned two colleagues
Mr.
sa sala and I
President,
didn't
Senate
accuse them.
President.
Sabi ko lang,
This is not
just
the
like
right
Vice
place.
President Sara,
This
just because
court
tumaas ang SALN,
was
can we already
established, was
ask
created,
for the
impeachment
BIR,
court
for the
Vice President
AMLA
and Vice
the,
President only. This should be
bank
her
accounts.
time. This should
So
be
sabi
her
ko, yan ang
forum,
i-discuss
not
namin sa
our
Monday.
forum
Nag-react na,
here
nag-accuse. I did
na
not
ilabas
take
natin
up
ang
your
saloobin
accusations
natin, mga sagot natin sa mga
here today.
akusasyon, mga kaso laban sa atin. And this
Secretary
is not
Vince
also
Dizon,
the time,
tatlong
Mr.
beses na
President.
nag-verify sa Taguig.
Mr.
Sinabi na
Presiding
tatlong beses
Officer,
na walang ghost.
nahanapin yung
Ngayon,
mga kasama
i-verify
natin
ulit.
nawawala,
I wasn't going to bring
nakakulong.
that up. But
Dapat
then
po doon
i-question
sa
ninyo si
Senado
Senator
natin,
Padilla.
sa session natin.
It was all over
and
the
not
news na hindi
here
niya
in this,
inintindi
court,
or he
Mr.
snubbed
Presiding
the
Officer,
ombudsman. I was
Mr.
going to stand
Senate
up
President.
before Senator
Kaya
Erwin stood
pakiusap
up
ko
just to
lamang
say
po, sana,
may registered mail.
sa ating
So
mahal
nung
na
una pa lang,
Presiding
5
Officer
minutes
and
si
Senate
Senator
President.
Tulfo. So I'll take
Let
the
us
5 minutes also. if you
follow
don't
the
mind.
rules. May rules ho tayo.
gentleman may proceed
Kung
and
hindi naman
kindly be
ho
mindful of the time.
patungkol
Yes,
sa
I will
Vice
now.
President
So,
na
I'm just
sasabihin
saying,
natin,
Senator
hindi
Padilla
naman po
just stood up to
patungkol
say,
sa ikang
sumusunod siya sa
depensa
batas, tapos.
o
Kaya humaba to.
prosekusyon
Dahil nga,
ng
hindi
Vice
importante
Presidente
ata
natin.
dito yung integrity
Then,
ng judge.
Wag na
Lastly,
ho natin
kaya
payagan na
sinabi kong
magsalita
it's
pa po
useless
dito
to
because
argue a
nasasayang.
legal point.
Because
Ilang beses
every
ko na narinig
minute,
dito,
every hour
it's our
that
job
we
to
waste
clear or prosecute
away from the defense or from the
Vice
prosecution
President.
of the case of the
It's
President,
our
Vice
job to
President,
try and to
it is
decide.
injustice.
It's the prosecution's
It is
job
called
to try to
injustice
prosecute,
to the Vice
and it's the
President,
defense
to her family,
job to convince
yung
us
anguish,
na wala. Our
yung
job is to
kanyang
try
sama ng
and
loob,
to
yung oras na nakabinbin ang
decide.
kaso
And
na
when you
ito.
decide, you
Let
acquit
us
or you
do
convict.
this
Why is that
impeachment
important?
trial
These are
as
legal
quickly as
terms.
possible.
Hindi pwedeng nanonood
If we
na
have to clear the
law
Vice
student
President,
ngayon
then let's
sasabihin,
clear her.
trabaho pala ng
If we have
judge
to
to clear
prosecute,
or
then
to prosecute.
prosecute her
Thank you,
with
Mr.
the
Presiding
evidence kung
Officer,
meron.
Mr. Senate President.
Not waste
Thank you,
our
Senator
time
Judge
kung
Alan
ano-ano
Cayetano. His
sinasabi
remarks are
natin
noted.
dito
Senator
to
Judge
protect ourselves,
Soto
to
thereafter.
defend ourselves.
Senator
This
Judge
is not the
Padilla
right forum,
thereafter.
Mr.
The
Presiding
presiding
Officer.
officer kindly wind up.
Mr.
Senator
Senate
Judge
President,
Erwin Tulfo.
this
You may
is
proceed,
not
sir.
the
You have 2
right
minutes.
forum for us to defend ourselves.
Thank you, Mr.
Bring it
President,
somewhere else. Bring it to the press. Bring it to the social media, but not here. Thank
I
you,
do
Mr.
not have
President.
4 years of
The remarks of
law,
the gentleman are noted.
but I have 29 years
Earlier,
of
Senator
lawmaking.
Judge Alan asked to
And
be
I
recognized.
move
Are you
that the
yielding in favor of
manifestations
Senator
that
Judge
we have heard
Padilla?
be referred to the Senate proper.
And thereafter, Senator Judge
will act on it
Soto,
at the proper
thereafter,
time,
Senator
Your
Judge
Honor.
Padilla,
Thank
before
you.
the
Your
chair
remarks are
makes a
noted.
ruling on the
Senator
matter.
Judge,
Yes, Senator Judge
Padilla is
Alan
recognized.
Cayetano
You may
is recognized.
proceed, sir. You have 2 minutes.
You may proceed, sir.
I'm happy I finally heard
Tagapamahalang hukom.
Senator Judge Erwin Tulfo is
Ito
concerned
pong
about
kasuotan
the
natin sa mga oras
justice
na
or
ito.
injustice to Vice
Hindi
President
lamang po
Sara.
ito
That's good
nare-represent
news.
ang impeachment
Regarding the waste of
ng
time
ating
here,
pangalawang Pangulo.
sabi ni
Ang
Senator Joker
nire-represent po
Arroyo,
nito
it is
ay
useless
ating
to
karapatan
argue a
bilang
legal
mga Pilipino
point with a
at
non-lawyer.
unang-una na ang due process.
When Senator
po yun
Marcoleta
ang
brought
ibig
that
sabihin.
up here,
Kaya ikaw
nagkaroon
ay
ng
pangalawang
commotion.
Pangulo, ikaw ang
Senator
Pangulo,
Miriam
ikaw ay
stood up
Senator
here
Judge,
many
ikaw ay
times and said,
magsasaka, ikaw ay
kaya ka
mangingisda.
nagpo 4 years na law school
Kailangan may due
at nagbabar.
process.
So let me give
Yung
my
pong
own
nangyari sa
interpretation.
akin, na ako po
The
ay
impeachment
nahusgahan
court
na
is
kaagad
formed
bilang
with
Senator
lawyers and
Judge
non-lawyers.
ang
And we
pinaglalaban
Counter
po
Act
natin
and it's for
integridad
everyone and we're equal.
ng korte na ito
But
at
if
ng
there's
mga
an engineer
senator
here
judge.
or a doctor and they
Kaya
talk
sana po,
about
wag nating
medical
kalimutan.
principles,
ang
I have
bawat
to either
Pilipino
study
ay may
and argue
karapatan,
on medical
lalong-lalo na
principles.
sa usapin
Hindi ko pwedeng sabihin,
na
hindi,
ikaw,
ganito lang yan, logic lang
ako,
yan, etc.
sa oras
Diba?
na ito, ay
So,
Senator
ang
Judge.
legal
Yun lamang po,
principle natin
napakaiksi
today
lang.
is simple.
Due process,
Integrity ng
mga
court.
mahal kong kaibigan,
So, allow
mga
me
mahal
to
kong kababayan,
Mention
maging
that to the people
prosecution,
and help
maging
educate my
defense,
colleague here.
sa ating lahat, huwag nating
The
kalimutan.
integrity of the court
Pantay-pantay
and
tayo
the justices or
sa batas.
judges is
Maraming salamat
always
po.
relevant. So if the
Senator
Supreme
Judge
Court or
Pangilinan, what is your
COMELEC,
pleasure,
Court
sir?
of Tax Appeals, Sandigan Bayan is
quick
being heard,
manifestation,
and the judges are being
Mr.
threatened,
Presiding Officer. Earlier,
you give them
Senator,
time. So
former
we cannot
Senate
take
President
the
Soto,
impeachment out of
moved
context.
that this
May
matters be
nangyayaring
referred
flood
to the,
control
Senate.
scandal. May nangyayaring
This is President
gulo
actually,
sa Team Unity na
during
hindi na
the
united
Estrada
ngayon.
impeachment trial,
We
the
consider
father of
Senator Marcoleta and
Cayetano
Senator
Rene Cayetano
Jinggoy
made a
political
manifestation
prisoners,
regarding a case that was
weaponized
supposedly
yung Blue Ribbon
being
Committee
prepared,
at weaponized
criminal
yung
case to
ano.
be filed against
So Mr.
him.
President, hindi tama
It
na
was raised in the
sabihin
impeachment court,
na
but ultimately
I
the
wasn't,
impeachment court
after we
agreed that
brought
the
up the
manifestation
problem with NBI, they doubled down
was
na
referred
gumawa pa ng task force.
to the Senate.
I
as a
mentioned two
legislative
colleagues sa
body. So,
Salian. I didn't
there is
accuse them.
precedent for
Sabi ko
this.
lang, just like Vice
Yes,
President Sara,
the court allowed
just because
Senate,
tumaas ang
Senator
Salian,
Rene
can we
Cayetano to
already
make his
ask
manifestation, but
for the
eventually it was
BIR,
resolved
for the,
that the matter be referred
AMLA
to the
and
Senate
the
as a legislative body. So
bank
we
accounts.
share.
So sabi
We
ko,
move
yan ang
for the
i-discuss
previous-
namin sa Monday.
Yes, we move,
Nag-react
we
na,
call for the
nag-accuse. I
previous
did not
question, Mr. President.
take up your
Senator
accusations
Judge Cayetano.
Here today. I think the Secretary Vince Dizon, tatlong beses na nag-verify sa Taguig, sinabi na tatlong beses na walang ghost. Ngayon, i-verify ulit. I wasn't going to bring that up. I have to question ninyo si Senator Padilla. It was all over the news na hindi niya inintindi or he snubbed the ombudsman. I was going to stand up before Senator Erwin stood up just to say may registered mail. So nung una pa lang, 5 minutes si Senator, and in the rules of the Senate, whenever the senator
gentleman may
feels
proceed and
threatened
kindly be
or
mindful
anything
of the time.
happens,
Yes, I will not.
whether
So,
pinatayan
I'm
ng
just saying,
aircon,
Senator
whether may
Padilla just
nakatutok
stood
na
up to
barel
say,
or sinara ng
sumusunod siya
pinto,
sa batas.
he
Tapos,
can rise
kaya
on a
humaba
point
to.
of
Dahil nga, hindi
personal and
importante ata
collective
dito yung integrity ng judge. Lastly,
privilege.
Kaya
We
sinabi
didn't
ko
do
it's
that
useless
para
to
argue
argue
a legal point.
Now, if we're
Ilang
going
beses
to
ko na narinig
argue
dito,
today, rather
it's
than
our
ask
job
them
to
about
clear
due
or
process,
prosecute
with
the
the simple
manifestation
Vice
from
President
Senator
po,
Padilla,
it's
na
our
hindi
job to
totoo,
try and to decide.
binabastos o
It's the
binabaliwala
prosecution's
ang
job
ombudsman
to try to
registered
prosecute,
mail lang,
and
kaya
it's the
hindi pa
defense
nadagdag
job to
So,
convince us na
hindi
wala.
kami ang
Our
nagwe-waste
job
ng
is to
time.
try
We can
and
have the
to,
focus, we can talk about it. You wanna debate
decide.
that now?
And when you decide,
With the
you
permission
acquit
of,
or you
with
convict.
the
Why is that
permission of
important?
Senator
These are
Judge
legal terms.
Pangilinan,
Hindi pwedeng yung
to
nanonood
abbreviate the
na
proceedings,
law student ngayon sasabihin,
President, because I
trabaho
was,
pala ng judge to
I was
clear or to
alluded to, Mr.
prosecute.
President.
Thank
Yeah,
you,
just very
Mr.
quickly,
Presiding
Mr.
Officer,
President.
Mr.
Rule
Senate
6
President.
Thank you,
on,
Senator
may
proceed,
sir.
Alan Cayetano.
Thank you, Mr.
His remarks are
President. Rule
noted.
6
Senator Judge
of our impeachment,
Soto, thereafter,
rules,
Senator
Mr.
Judge
President,
Padilla,
which was quoted
thereafter
by
the
Senator
presiding officer
Cayetano
shall make
as
a ruling.
being Suppletory.
You may proceed, sir. You
Mr.
have 2 minutes.
President, that refers to
Thank you,
evidence,
Mr. President. The
rulings
presiding
on
officer.
evidence in the
I,
impeachment trial. It does not refer to
I
privileged
do not have 4 years of law,
Therefore,
but I have 29
the
years of
supplementary nature
lawmaking.
of the rules of court,
And
as well
I
as the
move
Senate
that the
rules,
manifestations
refer
of,
to
that we have
matters
heard
pertaining
be
to
referred to the
evidence
Senate
and no
proper.
other, Mr. President. But
We will act on it at the proper time,
in the
Your
spirit
Honor.
of liberality,
Thank you.
we
Your
will
remarks
allow
are
that.
noted.
That's
Senator
precisely
Judge
why
Padilla
we
is
did not
recognized.
object
You
when,
may proceed, sir. You have 2
earlier
minutes.
Maraming salamat po,
spoke last
aming,
week. But let us not
tagapamahala mo
abuse
po.
the liberality of this
Ito
court,
pong
Mr. President.
kasuotan natin.
With the permission of
Sa mga
Senator
oras na
Judge
ito.
Tulfo
Hindi
Erwin,
lamang
the
po
chair will
ito
make a
nire-represent
ruling. Because I believe it is also his
impeachment
position not
ng
to
ating pangalawang
prolong this
Pangulo.
matter in discussing
Ang
collateral
nire-represent po
matters
nito
not pertaining
ay
to the
ating
articles of impeachment
karapatan
that we are
bilang
hearing
mga
and trying
Pilipino.
before the impeachment court.
At unang-una na, ang
The
due
chair
process.
rules that
Ito
the
po yun,
manifestation
ang
of
ibig
Senator
sabihin.
Judge
Kaya
Padilla
ikaw ay
shall remain
pangalawang
in the
Pangulo,
records.
ikaw ang Pangulo,
We
ikaw ay
cite as a
Senator
President
Judge,
to the
ikaw ay
President mentioned
magsasaka, ikaw ay
by
mangingisda.
Senator Judge Pangilinan,
Kailangan
where the
may
speech
due
of former Senator, the late former Senator
pong
Rene
nangyari sa
Cayetano was
akin,
not expunged for the
na
from the
ako
record,
po ay nahusgahan
but
na
referred
kaagad
to the Senate
bilang
impeachment,
Senator Judge,
Senate
ang
rather as a legislative body
pinaglalaban po
where it may
natin
be taken up.
integridad
I ask the
ng korte
indulgence
na
of
ito
the parties
at ng
to this
mga
case.
Senator Judge.
Wala po kasi kaming session.
Kaya sana
Ito
po,
lang
wag
po ang
nating
pagkakataon
kalimutan.
na nakapagsalita at
Ang
nagkikita-kita kami
bawat
habang
Pilipino
recess kami.
ay may karapatan,
Pero umaasa
lalong-lalo
ako,
na sa usapin
within hearing
na
distance
ikaw,
of my colleagues,
ako,
na kapag ka
sa oras
nag-resume
na
na
ito,
po ang Senado
ay
sa susunod na
Senator
linggo,
Judge. Yun lamang
matapos
po,
ang sono ng
napakaiksi
Pangulo,
lang.
may
Due
pagkakataon na
process,
po ang
mga
bawat
mahal kong
miyembro ng
kaibigan,
Senado bilang
mga
senador,
mahal kong kababayan,
hindi bilang senator
maging
judge,
prosecution,
na may labas
maging defense,
yung mga hinaing
sa
o
ating
anumang
lahat,
nais nilang
huwag
sabihin
nating
kaugnay
kalimutan.
sa anumang nagaganap o
Pantay-pantay
nangyayaring
tayo
hindi tama
sa
sa
batas.
kanila o ginagawa
Maraming salamat
laban
po.
sa kanila. And that I think is the proper
Senator
forum
Judge
for
Pangilinan,
us
what is
to
your pleasure, sir?
ventilate, discuss,
Just a
look
very quick
into, and if necessary,
manifestation,
investigate the allegations and or accusations
Earlier,
against Senator Judges in their
the
capacity
former Senate
likewise
President
as
Soto,
senators.
moved
So
that
ordered.
these matters be referred to the
What is the
Senate.
pleasure of Senator Judge
Mr.
I will just
President,
manifest, I
actually,
correct myself, it was
during
stamped,
the
not registered
Estrada
mail.
impeachment trial,
And since I agree with the ruling, I will not
the father of
anymore
Senator
argue
Cayetano,
the other rule that
Senator
correlates
Rene
with Rule
Cayetano
6.
made a
Thank you, sir.
manifestation
Noted
regarding
that it was
a
stamped.
case that was supposedly being prepared.
The
criminal case
Senate
filed
President
against him.
thereafter,
It was
Senator
raised in the
Judge
impeachment court, but
Erwin
ultimately
Tulfo.
the impeachment
Thank you,
court
Mr.
agreed.
Presiding Officer.
Hopefully we
that
can move
the
on after
manifestation,
the manifestations to
was
the
referred.
gentleman.
Let me
to the
appreciate
Senate,
and thank,
as a
and thank
legislative
the
body. So,
ruling of the
there is
presiding
precedent
officer
for this.
to refer the manifestations
yes,
as well
the court
as the
allowed
comments of our
then Senator
colleagues
Rene
to the
Cayetano
Senate
to make his manifestation,
acting
but
as
eventually
a
it was
legislative
resolved
body.
that the matter
8
be
days
referred
na lang po ay
to the Senate
magkukonvene na ang
as a
Senate
legislative
at
body.
doon rin ho
So
natin
we shared.
pag-uusapan itong mga
We move
mahalagang
for the
bagay
previous.
na
Yes, we move. We call for the
na-
previous question, Mr. President.
napag-usapan
Senator
ho
Judge
natin
Cayetano.
ngayon at kanina po ay
I think
narinig ko po
the
yung
presiding
komento
officer
ng
ruled
ating
that
kasamahan
we will
si
take it
Senator
up
Robin
later on. But
Padilla.
if
At ito po
Senator
yung mga
Judge
bagay
Pangilinan
na
will insist,
dapat rin po natin
then I have
talakayin
to
pag nagbukas na po
object
ang
on a point
Senado
of order.
in 1 week's time.
Rule 6
So with the
says,
indulgence of our colleagues,
the last part,
importante
the provisions
ho
of
yung
the rules of
oras
the
ng
Senate and the
trial
revised rules
sa
of
mga
court
darating
shall
na panahon.
apply
Nasabi ko
supplementary
nga nung
whenever
mga ilang
applicable. And in the
araw
rules
na
of the
mahaba pa
Senate,
yung ating
whenever
dadaanan. Ito ay
the
7th
senator
day pa
feels
lang
threatened
out of
or
the
anything
102
happens,
days
whether
na dadaanan
pinatayan ng
po natin.
aircon,
Kaya bawat
whether
oras,
may
bawat
nakatutok na
segundo ay
barel or
napakahalaga.
sinaran ng pinto,
At
he can
nagpapasalamat
rise
po
on
ako
a
sa
point
ating mga
of
kasamahan dahil po sa
personal
kanilang
and collective
masusing
privilege. We didn't do that
participate
para
dito sa ating
umikli.
impeachment. Pero
Now,
dadating
if
rin
we're
po tayo
going to
doon sa
argue today
pagtatalakay
rather
nitong
than ask
mahalagang
them
issue
about due
pagbukas po
process
ng Senado.
with a
Maraming salamat,
simple
Mr. Presiding
manifestation from Senator
Senator Judge
Padilla
Erwin
na hindi
Tulfo,
totoong
briefly, sir,
binabastos
so that we
o
can proceed
binabaliwala
to the
ang
matter
ombudsman,
on hand.
registered mail
Very
lang kaya
quickly,
hindi pa
Mr. Presiding
nadagdag.
Officer, can we start now?
So, hindi kami ang
I was about to,
nagwe-waste
sir.
ng time.
Thank you, sir.
We can
We
have a
wasted
focus, we
26
can talk
minutes for
about
nothing.
it. You want to
Thank you
debate
po.
that now?
With the permission of Proceeding now to the matter on hand. The presiding officer already made the ruling, referring it to the Senate as a legislative body. Senator Judge Soto. Without expunging it from the records, let it remain there. You may proceed, sir. We will now proceed on the matter at hand. We now resume consideration of the prosecution's requests for the issuance of subpoenas duces tecum number 1 for the banks and the Anti-Money Laundering Council on the other, on one hand, and to the Bureau of Internal Revenue on the other. And as previously agreed and discussed, not only in caucus but also
as well as the Senate rules,
directly by the
refer to
presiding officer with
matters
some members.
pertaining to evidence.
Chair will
And
now
no other, Mr.
recognize,
President. But
as I understand, Senator
in the
Judge.
spirit of liberality, we will allow that. That's precisely why we did not object when he earlier
Senator Judge
he
Allen or
spoke
Senator
last
Judge
week.
Villanueva?
But
Or
let us
Senator
not
Judge
abuse
Villa, who
the
would want-
liberality.
No
of
one's
this,
raising their hand,
court,
so I don't
Mr.
know who.
President.
With the permission
Senator
of
Judge
Senator
Villanueva
Judge
is recognized.
Tulfo, Erwin, the chair will make a ruling.
You may proceed, sir.
Because I
Thereafter,
believe
Senator
it is also
Judge
his
Pia
position
Cayetano.
not to
Thereafter,
prolong
Senator Judge
this matter
Alan
in
Cayetano.
discussing collateral
You may proceed,
matters
sir.
Thank you,
not
Mr. President.
pertaining to
Thank
the
you,
articles of
Mr. Presiding
impeachment that we
Officer.
are hearing and
As much as
trying
I
before the
am
impeachment
more than
court.
willing to
The chair
give
rules
way to
that
our dear
the manifestation of
colleagues. But, Mr.
Senator
President,
Judge
before I make
Padilla shall remain in the records.
inquire and
We
pose
cite as a
some
precedent
questions
to the
the,
president mentioned by
prosecution and the
Senator
defense.
Judge
May I
Pangilinan,
also
where the speech
raise
of
something,
former
Mr.
Senator, the
Presiding
late former
Officer? Gusto ko
Senator
lang pong,
Rene Cayetano was not expunged from the
malinawan
record,
tungkol po dun sa
but referred to the
procedural
Senate
aspect,
impeachment,
Ginoong Pangulo,
Senate rather,
dun
as
sa
a
motion
legislative
na ito.
body.
Kasi
where it
sa
may be
regular
taken up.
courts,
I asked the
hindi
indulgence of the
naman po
parties to
unusual
this case. Wala po kasi kaming
na ang
session.
isa pong
Ito lang po ang
motion
pagkakataon
ay
na nakakapagsalita at
i-grant in
nagkikita-kita
part
kami habang recess
at,
kami.
i-deny
Pero
in
umaasa
part.
ako,
Depende po sa
within hearing
legal
distance of my
and,
colleagues,
factual
na
basis
kapag
ng
ka
bawat
nag-resume
relief
na po ang
na
Senado sa
hinihingi
susunod
po,
na linggo matapos
Ginoong
ang sona ng Pangulo,
So, pwede
may
ko po bang
pagkakataon na po ang
malinawan
bawat
lang,
miyembro ng
Mr.
Senado
Presiding
bilang
Officer,
senador,
tama po
hindi
bang
bilang senator
sabihin,
judge, na
ganun
may labas
din yung kapangyarihan
yung mga
ng
hinaing o
ating,
anumang nais nilang
impeachment
sabihin
court?
kaugnay
Maaari po ba
sa anumang
na,
nagaganap o nangyayaring hindi tama
suriin ang
sa kanila
bawat
o ginagawa
hinihinging sabina
laban sa
ng
kanila. And that, I
magkahiwalay
think, is the proper
at,
forum for us
magpasya
to
po batay sa
ventilate, discuss, look
legal
into,
at
and if
factual
necessary,
basis ng
investigate
bawat isa
the allegations
sa halip
and
po
or
na
accusations
tratuhin
against Senator
ang
judges
buong
in their
motion bilang
capacity
isang
likewise
all or
as
nothing
senators.
proposition.
So ordered.
Tatratuhin ng
What is the
hukumang
pleasure of
ito
Senator
bilang
Judge
nag-iisang
Judge
motion ang
Manifest, I
tag-isang
correct
motion na
myself,
inihain
not
ng
registered
prosecution.
ngayon.
They only
And
filed
since
two
I agree
motions,
with the
Senator
ruling, I
Judge
will not
Villanueva.
anymore
And the court
argue
will act on
the
these
other
two
rule that
motions
correlates with
separately,
Rule 6.
regardless
Thank you,
of
sir.
the number
Noted
of
that
issues
ito
or
stamp-
sub-issues underneath each motion. The reason is
The
simple.
Senate President
Because the court
thereafter
should be a
Senator
passive body.
Judge
By
Erwin
amending
Tulfo.
the motion
Thank
into
you,
several
Mr.
parts and
Presiding
voting
Officer.
on it, we can move
Voting on
on
it
after
separately.
the
We are
manifestations
essentially
to the
acting
gentleman.
as if we were one of the
appreciate and thanks-
parties.
and thank the
In voting
ruling
for
of
or
the
against the
presiding
grant of the
officer to
motion, we should
refer
take into consideration
the
all of the
manifestations
factors
as well as the comments of our colleagues to
that
the
may be
Senate,
raised for or
acting
against it.
as
And
a
it may be
legislative
cited
body.
by the Senator Judge
8
in
days na lang
explaining his
po
vote
ay
or voting
magpo-convene
for
na
or against
ang
it.
Senate.
Pangalawa
At doon
po,
rin ho
bilang
natin
mga hukom,
pag-uusapan itong
hindi
mga
tayo pwedeng
mahalagang
masyadong
bagay
aktibong
na,
makilahok sa paraan ng mga motion, which is essentially a relief being asked for by a party.
Kanina po ay
sa pamamagitan ng paghahati
narinig ko po
ng mga
yung
motion na yan para pagbotohan
komento ng ating kasamahan
hiwa-hiwalay.
si Senator Romy
And there
Padilla.
is precedent
At ito po yung mga
insofar
bagay na
as this position
dapat din po
taken by the
nating
presiding
talakayin
officer is
pag nagbukas
concerned.
na po ang
And,
Senado in
and,
1 week's time.
impeachment
So
of
with
the
the
former
indulgence of
Chief
our
Justice,
colleagues,
late former Chief Justice Corona, where
importante
then
ho
Senate
yung
President,
oras
presiding
ng
officer
trial sa
Enrile
mga darating na panahon.
ruled that the
Nasabi ko
ruling
nga
of the
nung mga
chair on
ilang,
motions are
araw na
indivisible
mahaba pa yung
and may
ating
only be
dadaanan.
appealed in toto and
Ito
not in
ay
part.
7th day pa lang.
Thank
out
you,
of the 102
Mr. Presiding
days na
Officer.
dadaanan
And
po natin. Kaya bawat
it's clear
oras,
to me
bawat
now,
segundo ay
despite the fact,
napakahalaga.
Mr. Presiding Officer,
nagpapasalamat po ako sa ating mga kasamahan dahil
Your
po
Honors,
sa kanilang
that
masusing
if there would come a time na,
pag-participate ho
for
dito sa
example,
ating
sa isang
impeachment. Pero
sabina,
dadating rin po tayo doon
may
sa pagtatalakay
sinasabina
nitong
na
mahalagang issue.
sa
Pagbukas po ng
asawa
Senado.
o sa
Maraming
korporasyon
salamat,
o
Mr.
korporasyon
Presiding
na
Officer.
hindi naman relevant at
Judge
material
Erwin
doon sa kaso.
Tulfo,
Yun lang po,
briefly, sir,
Ginoong
so we
Pangulo,
can proceed
ang ating
to the matter on hand.
nagiging
quickly,
reservation
Mr. Presiding
tungkol
Officer,
po
can
dito.
we
Ngunit
start
naging
now?
malinaw po sa akin na
I was about to, sir.
magiging
Thank you, sir.
isang
We wasted
desisyon
26
lamang
minutes for nothing.
doon sa
Thank you po.
dalawang motion na inihain.
Proceeding now to the
desisyon
matter
sa
on
motion,
hand.
pero pwede
The
gaya ng
presiding
nasabi
officer
ng
already made a ruling
galang-galang
referring
na
it to the
hukom na
Senate as a
senador
legislative body.
pwedeng
Senator
hindi
Judge Sara.
ibigay yung lahat.
Without
ng
expunging
akordeng
it from
ito.
the records, let it remain
Pwedeng
there.
iba lamang, parte lamang,
We
at
will now
hindi
proceed on the
eksakto ng
matter
hinihingi niya.
at hand.
Pero yun ang magpapasyan
We now
na
resume
bilang isang
consideration
nag-iisang motion.
of the
Marami pong salamat.
prosecution's
Naging mas
request
malinaw
for the
po
issuance
sa
of
kinatawan na
subpoenas
ito
duces
ang,
tecum number 1
ruling
for
ng
the
ating
banks
presiding
and the
officer.
Anti-Money
May
Laundering
I
Council
start,
on the other on one hand and to the
raising
Bureau
some
of
questions,
Internal Revenue
Mr.
on
President,
the
Mr.
other.
Presiding Officer.
And as
To the,
previously agreed
to the
and discussed
to two parties,
not only in caucus
Mr.
but
Presiding
also
Officer, just for the
directly by the presiding
guidance of
officer
the court,
with
and I
some
think it's
members.
important that
Chair
we
will now recognize,
distinguish
as I
between
understand, Senator
two
Judge.
separate procedural questions. Una, kung dapat po bang
Ikaw ba, una?
i-produce
Senator
ang
Judge
hinihinging
Alan or
records,
Senator Judge Villanueva or
at
Senator Judge
pangalawa,
Villa who would want
kung
no
ang
one's
mga
raising their
records
hand, that's
na
why I don't
iyon
know.
ay magiging
Senator Judge
admissible
Villanueva is
at
recognized.
kung anong evidentiary weight
You may proceed,
ang
sir.
dapat
Thereafter,
ibigay sa
Senator
kanila.
Judge Pia
let me
Cayetano,
start by
thereafter,
asking
Senator
our
Judge Alan
lead
Cayetano.
prosecutor.
You may proceed, sir.
Thank you, Mr. President. Thank you, Mr. Presiding Officer. As much as I am more than willing
correct,
to,
sir,
to say
give
that
way to our
the issuance
dear colleagues.
of a
But,
subpoena,
Mr. President, before I
merely
make
compels the
inquire
production of
and
records
pose some questions to
and
the
does
prosecution
not
and the defense
by
May I
itself
also,
amount to a ruling
raise
that
something,
those
Mr. Presiding
records
Officer? Gusto ko
are
lang pong,
admissible malinawan tungkol po dun sa procedural aspect to evidentiary weight, Your Honor. Dun
Before
sa
the member
motion
of
na
the
ito,
panel for
kasi
prosecutors
sa regular
answers,
courts,
he's not the lead prosecutor.
hindi naman po
The question is
unusual,
addressed to the Honorable
na ang isa pong
Representative
motion
Chel
ay
Jokno, who is a
i-grant
member
in part
who is part of the
at,
panel of
i-deny
prosecutors who will
in
be
part.
answering your
Depende po
questions.
sa
And for the record,
legal
on the part of
and
the respondent, I
factual
think it's
basis
Attorney
ng
Poa
bawat relief
who will be answering.
na hinihingi
So
po,
that we don't need to identify
Ginoong
each one each
So,
time anymore
pwede
for
ko
the
po
record.
bang
The
malinawan
Honorable
lang,
Jokno
Mr.
may
Presiding
respond to the
Officer,
question of
tama po
Senator
bang
Judge Villanueva. You may
sabihin,
proceed, sir, when you're ready.
ganun din
Thank you,
yung
Your Honor.
kapangyarihan
Good afternoon
ng
to all the
ating
members of this
impeachment
honorable
court?
court.
Maaari po ba
May sagot na
na
po ata yan ni dating
suriin ang
presiding
bawat
Judge
hinihinging
Juan Ponce
sabina ng
Enrique
magkahiwalay
sa corona impeachment
at
case. And if I
magpasya
may
po
quote
batay
just a brief
sa
portion from what he
legal
said,
at factual
I would like
basis
to
ng
explain
bawat isa
that the resolution
sa
of
halip
this
po
court
na
was
tratuhin
simply to
ang
authorize
buong
the issuance
motion
of a
bilang
subpoena.
isang all or
And whether
nothing
those evidence subpoenaed
proposition.
are admissible evidence,
Tatratuhin
given the
ng
fact that
hukumang
they
ito bilang
apparently
nag-iisang
appeared in
motion ang
violation of
tag-isang
existing
motion na
laws,
inihain ng
is a
prosecution.
question that
They
must
only
be
filed two
resolved
motions,
in due
Senator
course.
Judge Villanueva.
So, ang ibig po
And the
sabihin,
court will
ang,
act on these two
ang hiling
motions
lang po ng
separately,
prosecution ay
regardless of the
may
number of
labas ang
issues or
ebidensya,
sub-issues
pero wala
underneath
pa po tayo
each
dun sa
motion.
punto
The reason is
kung
simple.
tatanggapin ba
Because
nitong
the court
hukuman
should be
ang
a
evidence
passive
na yun
body.
kung siya po ay
By
admissible
amending the motion into
salamat po
several
sa
parts and
inyong,
voting on it separately,
Representative
we are essentially
Jokno.
acting
Kaya
as if
po,
we were one of the
nilahad ko
parties.
po yan
In
nang sa
voting
ganoon,
for or
maitanong
against the
po
grant of the
natin
motion,
ang,
we should take into consideration all of the
defense
factors.
panel if that
That may be
distinction
raised
is
for
correct.
or against it.
Would the
And it
defense
may be
still
cited by
maintain
the senator
that
judge
the
in explaining his vote
mere
or voting
issuance
for or against it.
of a subpoena
Pangalawa po,
is
bilang mga hukom,
by itself
hindi tayo pwedeng
already
masyadong aktibong makilahok
prejudicial to the
sa paraan
respondent even
ng mga
before the
motion,
court has ruled
which is
on
essentially a relief
admissibility
being
or
asked
weight.
for by a party.
Yes, Your Honor.
Sa
Good
pamamagitan ng
afternoon,
paghahati
Honorable Senator
ng mga
Judges.
motion na yan para
Yes,
pagbotohan
while we
ng
agree
hiwa-hiwalay.
with the position
And
of the
there is precedent
prosecution na hindi pa naman
insofar as this
pinag-uusapan
position
ang
taken by the presiding
admissibility sa
officer is
puntong ito.
concerned.
What
In
we are
the-
questioning
in the
is really
impeachment of the
yung
former Chief
subpoena
Justice,
mismo po.
late former
Dahil
Chief
sa
Justice
atin, sa
Corona,
ating pananaw,
where then
ang isang
Senate
subpoena,
President,
at hindi
presiding
lang sa ating
officer
pananaw, but even under
Enrile
jurisprudence,
ruled
meron
that
pong
the
requirements,
ruling of the chair on
bago tayo
motions are
makapag-issue ng
indivisible
subpoena para maging
and may
valid
only be appealed
yung
in
subpoena na
toto
yun. At
and
yun
not
po
in
yung
part.
napag-usapan natin nung
Thank
nakarang
you,
linggo
Mr.
na
Presiding
definiteness,
Officer. And,
and relevance.
It's clear
Ngayon,
to me
yung twin
now,
requirements na
despite
yun,
the fact, Mr.
para po sa pananaw
Presiding
ng
Officer,
depensa ay lacking in this case.
Your Honors,
And that is why we
that
maintain our position
if there would
as regards
come a time
opposing
na,
itong request
for
ng
example, sa
prosecution
isang
sa
subpoena,
pag-issue ng subpoena.
may sinasabi na
at least
malinaw po no
sa
ang
asawa
pag-issue
o
ng
sa
subpoena
korporasyon
not
o korporasyon
necessarily
na hindi naman
opening of
relevant at
records
material
una,
doon sa
pangalawa,
kaso, to
yun
be
lang po
presented
Ginoong
in
Pangulo
court,
ang
at
ating
pangatlo, to be admitted as evidence by this court. Before I go dun sa requirement,
po dito
let me
ngunit
ask
naging
the,
malinaw po sa akin
panel
na
of prosecutors,
magiging isang desisyon lamang
Representative
doon
Jokno,
sa dalawang
doon po sa
motion
pananaw
ng depensa
Isang
o
desisyon
na
kada
alleged,
motion, pero
fishing
pwede gaya ng
expedition.
nasabi
Just
ng
for the guidance of
pagagalang-galang
Senator
na hukom na
judges,
senador na
this representation would
pwedeng
like
hindi
to
ibigay yung lahat
clarify
ng
one
korteng
procedural
ito.
matter.
Pwedeng
We
iba
understand
lamang, parte
that,
lamang at hindi eksakto ng
the
hiningi niya.
concern
Pero
raised
yun ang
by the
pagpapasyan
defense that
na
the
bilang
subpoena
isang
may be
nag-iisang motion.
overly broad. Marami pong salamat.
And
Naging mas
at the
malinaw
same
po
time,
sa
we also,
kinatawan na ito
recognize
that the court has a
ruling
duty
ng
naman
ating,
to
presiding
determine
officer.
whether
May I
the
start,
records being sought are
raising some
sufficiently
questions,
relevant and
Mr. President,
material
Mr.
to the
Presiding
issues
Officer.
before us.
So,
Representative Jokno, maaari po ba ninyong
ipaliwanag
for the
kung paano
guidance of the court, and I think it's
ninyo
important that
tiniyak
na ang hinihinging mga records ay
two separate
hindi po
procedural
simpleng
questions.
paghahanap
Una,
lamang ng
kung
posibleng
dapat
ebidensya o tinatawag na
i-produce
fishing
ang
expedition
hinihinging records,
kundi ito
at
po ay
pangalawa,
mga partikular na
kung ang mga
dokumento na sa
records
tingin
na
po
iyon
ninyo ay mayroon
magiging
pong malinaw
admissible
at
kung
direct
anong
kaugnayan
evidentiary
dito
weight
po sa
ang
mga
dapat
articles
ibigay
of
sa
kanila. So,
Thank
let
you,
me
Your Honor.
start by asking
Ang
our
hinihiling po namin sa
lead
mga subpoena ay kaugnay sa Article 2, which
Congressman
involves charges of unexplained
dear
wealth.
Congressman, would it be
Kung
correct,
titingnan
sir,
po natin yung
to
mga
say that
jurisprudence
the
pagdating sa
issuance
unexplained wealth,
of a
klarong-klaro
subpoena
po na sinabi
merely
mismo ng Korte
compels
Suprema na
the
kailangan
production
makita
of records
yung buong larawan
and
hindi
does
lamang po
not
ng mga SALN
by itself
na final ng
amount
isang
to a
lingkod bayan,
ruling that
kung hindi
those
lahat ng kanyang
records
kinita,
are
both
admissible,
what we would call lawful and if
relevant,
there is
or entitled
illegitimate
to
income.
evidentiary weight, Your Honor.
Ang
Before the
SALN po
member of
kasi
the panel
ay
for
parang
prosecutors
snapshot lang
answers,
po
he's
yan.
not the lead
Year
prosecutor.
end, kung
The
ano
question
yung
is
mga
addressed to
assets, liabilities, and
the
net
Honorable
worth ng isang
Representative
government
Chel
official.
Jokno, who is a
Ang
member
ITR din
of the
po
who is
ay
part
parang
of the
short
panel of
video lang po
prosecutors
yan
who will be answering your
ng mga
questions.
transaction
And for the
ng
record
isang
too, on the part
taxpayer
of the respondent,
sa
I think it's
kabuuan ng
Attorney
taon na
Poa
yun.
who will be answering.
Makikita lang
So
po
that we
natin
don't need to
yung
identify
larawan
each one each
pag
time anymore
natin
for the
ang
record.
mga bank
The
records.
Honorable
Kasi
Jokno
doon
may
po
respond to the
yung
question of
day-to-day
Senator Judge
na
Villanueva. You may proceed, sir, when you're ready.
pumasok sa
Thank
isang
you, Your Honor.
account
Good
ay
afternoon to all
mabubuo
the
po
members of
natin.
this honorable
And
court.
in fact, in the
Naisagot
case
na
of
po ata
yan na ni dating
DOF
presiding
versus
judge Merencilla, ito lang pong portion ang babasahin ko.
And if I may
Sabi
quote
ganun
this
ng
brief
Supreme
portion
Court
from what he said.
The
I would
failure
like
of
to
the
explain
complainant
that the
to take
resolution
into
of this
consideration
court was simply
respondent
to
Rafael's
authorize
net
the issuance
worth
of a subpoena.
from the time he
And whether
entered
those
government
evidence
service
subpoenas are
and
admissible
the failure
evidence,
to
given
take
the
into
fact that they
consideration
apparently
all of his
appeared in
possible
violation of
sources of
existing
income
laws,
in
is a
relation
question
to
that
his
must
real
be
and personal
resolved in due
properties.
course.
Do not
So, ibig po
support
sabihin,
the
ang
conclusion
ang
that he
hiling
has
lang po ng
unexplained
prosecution
wealth,
ay
considering
may labas ang
that his
ebidensya,
true net worth
pero wala
was
pa po
not
tayo dun sa
determined.
punto
Ito po
kung
ay
tatanggapin ba
sabi
nitong
ng Supreme
hukuman
Court,
ang evidence
Ombudsman,
na yan kung
hindi
siya
nyo
po ay
nagawa yung inyong
admissible o
trabaho.
hindi.
Kaya
Maraming
ayaw
salamat po
namin
sa
tumulat
inyong
sa nangyari
tugon,
kay Ombudsman dito sa kasong
Representative
ito.
Jokno.
We want to
Kaya
see
po,
the entire picture.
nilahad ko po
Kaya
yan
po namin
nang sa ganoon,
hinihingi
maitanong po natin
yung
ang
BIR records,
defense
pati yung mga
panel
bank records,
if
and even
that
the
distinction
Anti-Money Laundering
is
Council
correct.
records.
Would
Para
the
makita
defense
po
still
natin yung
maintain
buong
that the
story as
mere
far as
issuance
both
of
the
a subpoena
assets, liabilities, and net
is
worth are
by
concerned,
itself
and
already
the lawful,
prejudicial
and
to
if
the
there is unlawful
respondent even
income
before the court
acquired
has
by the
ruled
respondent.
on admissibility or sa prosecution. No?
Yes, Your Honor. Good afternoon,
Sir,
Honorable
binanggit po
Senator
kanina
Judges.
nung
Yes,
defense
while we
panel
agree
yung
with the position of the prosecution
requirements which
na hindi pa
should
naman
be,
pinag-uusapan ang admissibility sa
relevant
puntong ito,
and,
what we are questioning
specific,
is really
and,
yung subpoena mismo
kinikilala po
Dahil
natin dito sa
ating
korte
pananaw,
na yung
ang isang subpoena, at hindi lang sa
is an
ating pananaw,
important
but even
tool
under jurisprudence,
na available
meron
po
pong
dito sa
requirements
impeachment court in the
bago
search for
tayo
truth.
makapag-issue ng
Pero
subpoena para maging
kinikilala din po
valid
natin
yung subpoena na yun. At
ang
yun
mga
po yung
records
napag-usapan
na
natin
ating
nung nakarang
hinihingi ay
linggo
may
na
tinatawag na
definiteness,
statutory
and relevance.
protection
Ngayon,
under
yung twin
our
requirements
laws.
na
Now, in
yun,
this regard,
para po sa pananaw
Your
ng
Honor,
depensa
bago po
ay lacking in this
ninyo
case.
hiniling
And that is why we
ang,
maintain our position
compulsory
as regards
production ng mga
opposing
confidential records
itong
na ito.
request ng prosecution
May we
sa
know what
pag-issue
led
ng
the
subpoena.
prosecution to conclude
At least malinaw
that
po,
the
no? Ang pag-issue ng
subpoena
of
not necessarily
is the least
opening of records
intrusive
una,
and most
pangalawa,
appropriate
to be
means
presented in
of,
court,
obtaining
at pangatlo,
the
to be
information
admitted as
sought.
evidence
In other
by this
words,
court. Before I go
Your
dun sa
Honor,
requirement,
paano po
let me
ninyo
ask
masasabi
the,
na itong subpoena is
panel
not
of
only
prosecutors,
relevant,
but also
Representative
necessary,
Jokno,
dun po sa pananaw
proportionate
ng
under
depensa
these circumstances.
on alleged
Ang subpoena po ang
fishing
tanging
expedition.
paraan
Just for the guidance of
para
Senator
makuha ng itong
Judges,
hukuman
this representation
ang mga
would like
kinakailangan
to
po natin na
clarify
datos at
one
impormasyon
procedural
at
matter.
dokumento.
We
At
understand
hindi naman
that
po siya intrusive
the
dahil
concern
tulad na nabanggit
raised
ko po
by the
kanina,
defense that
ay
the subpoena
hindi
may
naman
be
ito question ng
overly broad.
admissibility.
And
Ang
at the
kailangan
same
lang ay
time, we
ma-produce
also
sa
recognize
korte
that the court
yung mga
has a
dokumentong
duty
hinihingi.
naman to
The issue of
determine
admissibility
whether
will
the
come later,
records
and
being
the
sought are
defense will have
sufficiently
sufficient
relevant
opportunity to
and material
object
to the
and to
issues
oppose.
before us. So,
Ngayon po, as far as the
Representative
particular
Jokno,
records
maaari
that
po
we
ba
are
ninyong
requesting are
ipaliwanag
concerned, ito ay
kung
nakabatay
paano
nga sa nabanggit ko pong
ninyo
desisyon ng Supreme Court
tiniyak
na pag
na ang
tinitingnan natin ang
hinihinging mga
issue ng
records
unexplained
ay
wealth, hindi lang
hindi
po
po
pwedeng
simpleng
snapshot
paghahanap
ang
lamang
titingnan natin.
ng posibleng
Kailangan mula sa
ebidensya o
unang
tinatawag
araw ng
na fishing
paglingkod ng
expedition.
isang lingkod bayan,
Kundi
yung
ito
kanyang
po ay
final na
mga
SALN,
partikular
lahat ng
na
mga kinita
dokumento
niya
na sa tingin
ay
po
makita
ninyo
natin.
ay meron
And that
pong
will be
malinaw
shown both
at
by the bank records that we
direktang
are requesting
kaugnayan
to be produced,
dito po sa
as
mga
well as
articles of
the
impeachment.
BIR
Thank you,
and
Your
tax
Honor.
records that we
Ang
are
hinihiling po namin
Thank you.
sa mga
Thank you very much. Sa
ay
depensa po,
kaugnay sa Article 2,
binanggit
which
niyo
involves
kanina yung
charges of
relevance and
unexplained
if I
wealth.
recall it right
Kung
last week,
titingnan po natin yung
the
mga
good gentleman Gentleman, Attorney
jurisprudence
Poa
pagdating
made
sa
mention
unexplained
about
wealth.
the questions
Klarong-klaro
on
po
confidentiality,
na sinabi mismo
sir,
ng
no?
Korte Suprema
And
na kailangan makita
this representation
yung
would like
buong
to
larawan,
better
hindi
understand the
lamang po
legal
ng mga salhem
basis
na
of the
final ng
defense
isang lingkod
position
bayan,
on
kung
confidentiality.
hindi lahat ng
We
kanyang
recognize
kinita.
that the law
both what we would call
places
lawful and if there is
premium
illegitimate
on
income.
protecting
Ang
confidential
salarin po
information.
kasi ay parang
At the same
snapshot
time,
lang po yan.
we are also
Year
dealing
end,
with a request
kung ano yung mga
made
assets,
in the course
liabilities,
of
and
a
net worth ng
constitutional
isang
proceeding
government official.
before this impeachment
Ang ITR
court.
din
At,
po,
bilang
parang
mga
short video
senator
lang po
judges,
yan
it's our
ng mga
constitutional duty
transaksyon ng
to
isang
try and
taxpayer
decide on
sa kabuuan ng taon na yun.
cases.
Makikita lang po natin yung buong larawan pag
Mr.
nailabas
Defense
natin
Counsel,
ang mga bank
yung
records.
Section 8
Kasi doon po, yung
-A
day-to-day
of the,
na
Anti-Money
lumabas at
Laundering Act,
pumasok sa
binanggit
isang
niyo po ito
account
last time,
ay mabubuo
which
po
prohibits
natin.
the
And in
disclosure
fact,
of confidential
in the case
information.
Of,
How
DOF
should
RIPS versus
this apply
Merencilia,
to
ito lang pong
records
portion ang
sought
babasahin
through
ko.
a subpoena
Sabi
issued
ganun ng
by the
Supreme Court.
impeachment court? Because
The failure of the complainant
as I read,
to take
Your
into
Honor,
consideration
Section
Respondent
8-A,
Rafael's net worth
it imposes
from the time
confidentiality,
he
but
entered
it
government
does not
service,
expressly create
and the failure to
an
take into
absolute
consideration
privilege
all of his
against
possible
the
sources
subpoena.
of income in
There is
relation
a
to his real
distinction
and personal
between
properties do not support
an authorized
the conclusion
disclosure and
that he has
production
unexplained
pursuant
wealth,
to a
considering
lawful order
that his
of a
true net worth
constitutional
was
body.
not determined.
So, again, my
Ito po
question,
ay,
Your Honor,
sabi ng
where
Supreme
exactly
Court,
in
Ombudsman,
Section
hindi nyo
8A
nagawa yung inyong
does it
trabaho.
say that
Kaya ayaw po namin
AMLA,
tumulad sa
AMLC
nangyari
may
kay
refuse
Ombudsman dito sa kaso
a,
nito.
lawful
We want
subpoena
to see
from this court,
the
Your
entire picture.
Thank
Kaya
you
po
for that
namin
question, Your Honor. Unang-una,
hinihingi
sagutin ko lang po yung
BIR
pretense
records,
ng inyong tanong.
pati yung mga bank
Sabi niyo,
records,
this is
and
a
even the
constitutional
Anti-Money
body,
Laundering
hindi po ba?
Council records.
And as we
para
all know,
makita
there
po
is an
natin
old
yung
legal maxim
buong
that the spring
story
cannot
as
rise
far as both
over
the assets,
the source.
liabilities,
No?
and net
Ibig
worth
sabihin
are
po nun,
concerned. And
while the impeachment
the lawful,
court is a
and if there
constitutional
is unlawful
creation,
income
it cannot go
acquired by the
over and
respondent.
above the
Last question
Constitution
sa
itself.
prosecution, no?
And when we talk about
Sir,
the impeachment
binanggit po
court
kanina
under
nung,
Article 11,
defense
we cannot
panel
read that in
yung,
isolation. We have to
requirements
also give due
which
regard
should
for
be,
all other provisions of the Constitution,
relevant
specifically
and,
the Bill of Rights, kung
specific
saan due
and,
process ay isang bagay
kinikilala
na
po natin
nakatatak po
dito
doon.
sa korte na yung
pinapakita doon, ano bang ibig sabihin
subpoena
ng
is
due
an
process?
important
Due
tool
process is
na available po
kasama
dito
po sa kalakip ng
impeachment
due
court in the search
process
for
ay
truth.
ang
Pero
bawat
kinikilala din po
nasasakdal
natin
ay meron
na
ding
ang mga records
pribilehiyo
na ating
maging
hinihingi
ano,
ay
no,
may
ma-protect o
tinatawag na
maproteksyonan ng mga
statutory
batas
protection
na isinagawa
under
ng
our
mismong
laws.
Kongreso.
Now in this regard,
so now let's go on
Your Honor,
to
bago po
Section 8A.
ninyo hiniling
No? As you can see,
ang
Your Honor,
compulsory
that is an
production
at
ng
least
mga
for our
confidential
position, it's an
records na
absolute
ito.
prohibition.
May we know
Unlike
what
other
led
laws
the
where they created, for
prosecution
example,
to
in the bank
conclude
secrecy law, meron
that
nakasulat
the
doon, aaminin
issuance
natin, in
of
cases of
subpoena
impeachment,
is
is an
the
exception.
least
Pagdating po
intrusive
dyan,
and most
wala po
appropriate
ni isang
means
exception. It
of
could have been
obtaining
easy, especially
the
since this is
information
a
na sought. In
2021
other words,
amendment.
Your Honor,
It could have
paano
been
po
easy
ninyo masasabi
for
na itong
Congress
subpoena is
to
not
have cited
only
impeachment
relevant,
as an
but
exception
also
if it did not, if
necessary
it did actually wish
and
to do so. But it did not,
proportionate
Your Honor.
under these
And
circumstances.
it is our
Ang
position
subpoena po ang
that if we
tanging
were to
paraan
compel and issue a
para
subpoena
makuha ng
against these
itong
AMLAC
hukuman
records,
ang
we're
mga
actually
kinakailangan
compelling
po natin na
officials
datos at
to violate
impormasyon
this
at
very
dokumento.
section of the law.
At hindi naman
And that
po
is
siya
why we are
intrusive
saying
dahil
na
tulad
pagdating
na
sa
nabanggit ko
8A,
po kanina,
absolute po
ay
yan.
hindi pa
It does
naman
not
ito
say,
question
that
ng
there's any
admissibility.
exception.
Ang kailangan
If any
lang ay
court
ma-produce
processes are actually
sa
issued
korte
to compel
yung
the
mga
production
dokumentong
of these
hinihingi.
documents.
The issue of admissibility
Precisely
will
because
come
ang
later
nasa loob
and
po kasi
the
ng mga records ng
defense will
AMLAC
have
are
sufficient opportunity
intelligence.
to
And that's
object
why
and to
it's
oppose.
confidential.
Ngayon po,
And once,
as far as the particular records
once
that we
AMLAC
are
determines
requesting
that
are concerned,
they find
ito ay
out that
nakabatay
certain
nga sa
transactions
nabanggit
are
ko pong
subject to
desisyon ng
money
Supreme
laundering
Court,
or should be
na pag
actually filed in
tinitingnan
court,
natin ang
the end
issue
result
ng
is the
unexplained
complaint
wealth,
itself
hindi lang po
and not the
pwedeng
raw
snapshot
data. And
ang
that is why,
titingnan
Your
natin.
Honors, as to the raw
Kailangan
data or the
mula sa
information
unang
that they
araw
receive,
ng paglingkod
ayan
ng
po
isang
ay
lingkod
strictly
bayan,
confidential
ang kanyang
under
final
8A.
na salin, lahat ng mga
Thank
kinita
you for
niya
that.
ay makita
Again, I
natin. And
would
that
like
will
to
be
put on
shown
record
both
that,
by the bank records
I
that
was
we are
trying to look
requesting
at
to
that
be produced,
particular,
as well as
section,
the
Section
BIR
8A,
and tax
and,
records that we are requesting.
Thank you very much. I don't see anything that says this court would not have any relevance, and if I recall it right last week, whether or not we can mention bank records. But let me move forward, perhaps, sir, no? This could be my last question. This representation would like to better understand the legal basis of the defense position on confidentiality. To we recognize that the law places a confidentiality premium on protecting the freedom of confidential information. At the same time, which promotes we are also dealing with a request public made accountability in the course of a constitutional proceeding. So, before this impeachment court. Gusto ko lang pong malinawan for the benefit Senator judges, this representation and our dear colleagues here, deciding Senator impeachment. May legal distinction po ba between disclosure of information to the general public -A of the limited anti-money laundering act? Binanggit niyo po ito last time. Which prohibits the disclosure of confidential exercise of its constitutional function. This apply because we understand that the a subpoena issued by the freedom of information is rooted in transparency and public Your Honor, Section 8, especially po when the it imposes confidentiality, of a public officer it does not under constitutional scrutiny. An absolute privilege against confidentiality is the there concern. Is a distinction. Would you agree, Attorney Powa, an authorized disclosure and production pursuant to a lawful order of a constitutional body and disclosure? So, again, my question, Your Honor, the records, where exactly kung maaari lamang po na kung maaari naman po na AMLA, AMLC may refuse ang impeachment court a lawful subpoena from this court, Your Honor.
Thank you
Sapat
for that
po
question,
na
Your Honor.
safeguards
Unang-una, sagutin
upang
ko lang po
mapanatili ang
yung,
confidentiality
pretense ng
ng mga
inyong
records.
tanong, no? Sabi niyo,
Bakit
this is
po
a
dapat maging
constitutional
hadlang
body,
ang
hindi po ba?
confidentiality
And as we all
sa
know,
isang
there is
impeachment
an old
court
legal
upang
maxim that the
suriin
spring cannot
ang mga
rise
impormasyon na
over,
maaari nga pong may
the
kinalaman
source, no?
sa mga
Ibig
issue
sabihin po nun,
nararapat nitong
while the impeachment court
resolbahin
is a
bilang
constitutional
isang impeachment
creation,
court.
it cannot
Para
go
sa atin po,
over and
no,
above
kung ano man
the
pong
Constitution
hakbang
itself.
ang pwede
And when
o
we
hindi
talk
pwedeng
about
gawin ng
the
isang
impeachment
impeachment
court under
tulad ng
Article
nasa harap
11,
natin na
we cannot
ngayon,
read that in
it must
isolation.
be confined
We have to also
to
give
the
due
limits
regard for
imposed by
all
the
other provisions
Constitution
of the
and the
Constitution.
laws.
Specifically,
So,
the Bill of
kahit
Rights,
sabihin
kung
po
saan,
natin,
we
due
are not
process,
against
no?
transparency.
Ay isang bagay
I just
na
want to make that
nakatatak
clear, Your
doon.
Honors.
At
We are not against
pinapakita doon, ano bang
accountability.
ibig sabihin ng
But
due
again, as
process?
I've mentioned
Due process
last year,
is, last week,
kasama
rather,
po sa kalakip ng due process,
hindi naman
ay maporket po
ang bawat
that,
na
we are all looking for accountability
ding
and transparency.
pribilehiyo
Ay isasantabi na lang po natin
ma-protect
kung ano ang mga karapatan
ng mga batas
hindi lang
na
para sa
isinagawa ng
impeachable
mismong
officer,
Kongreso.
pero para kahit
So now,
sinong
let's go on
Pilipino na nakasaad
to
sa batas,
Section
including
8A,
absolute
no?
confidentiality
As you can see, Your
in terms
Honor,
of AMLAC
wala-
reports, which we are
that is an
pointing to.
at least for our
So
position,
para po
it's
sa
an absolute
atin,
prohibition.
unlike other
Nakikita
laws
ko
where
yung
they
punto po
created,
ng
for
ating,
example, in the bank secrecy law,
na
meron nakasulat
paano
doon,
kung
aminin
mag-impose
natin
tayo
in
ng
cases of
certain
impeachment
conditions.
is an exception.
However, Your Honor,
pagdating
those
po
certain
dyan,
conditions may
wala
be
po
allowed
ni isang exception.
for other
It could have been
records,
easy,
pero pagdating sa
especially
AMLAC
since this
po,
is a
absolute po
2021
kasing
amendment.
prohibition.
It could have been easy if we were
for Congress
to have cited impeachment as
or
an
at least
exception
suspend
if it did
the
not,
provision
if
of
it did
8A,
actually wish
then
to
it
do
is
so.
as if this
But it did not, Your
honorable
Honor,
court
and
is
it
actually
was
doing
in
some
position
sort of judicial
that if we were to
legislation,
compel, no,
and
because
issue a
we are
subpoena
technically
against this AMLAC
suspending
record,
this law
we're
for
actually
a specific
compelling
official
person
to
na hindi
violate
natin pwedeng
this
gawin
very
sa iba.
section of the
That
law.
is why,
And that
ang
is
sa
why
akin
we
lang
are
po,
saying
ang sa amin sa
na
punto ng
pagdating sa
depensa,
absolute po yan. It does not
Paano
say
po yun?
no, that there's
Meron
any
po bang
exception
instances na
if any
papayagan
court
na lang natin
processes
isang
are
tabi natin yung
actually
batas
issued to compel
at
the
merong
production
instances
of
na
these
hindi.
documents. I think, Your
precisely
Honors,
because
we feel,
ang nasa
the
loob
defense
po kasi
feels,
ng
Your
mga
Honors,
records ng
that
AMLAC
in the
are
search for
intelligence,
truth,
transparency,
and that's why it's
accountability.
confidential.
And once,
we must still work within a framework.
Once
which
AMLAC
determines
which means that
we must
they
work
find out that
within the
certain
limits
transactions
imposed
are
by the
subject to
Constitution,
money laundering,
the laws,
or should
and the
be
rules of
actually
the
filed
land.
in court. The end result is the
Salamat po,
complaint itself,
Attorney,
and not the
Mr.
raw
Presiding
data.
Officer,
And
just
that is
a
why,
few
Your Honors,
seconds,
as to the raw
just to
data
put
or the
on
information
record,
that they receive,
ang Senado po
ayan po
ay
ay strictly
nasa
confidential
plenaryo
under
na po
8A.
yung proposed bribe
Thank you for that.
Maraming sumuportang mga kasamahan natin.
On record that,
Ito kasama po dito yung amendments
I was trying to look at that particular
circumstances
section,
under
and
which bank records, financial transactions may
I
be
don't
lawfully
see anything
accessed
that
by
says,
competent authorities.
this court would
Subject
not have
always, of
any,
course, Mr. President, to appropriate
prerogative
safeguards
as
and
to,
due process. So gusto ko lang
whether
pong
or not
banggitin that
we
indeed
can,
confidentiality is an
bank
important
records.
but
Legal,
let me move
protection,
forward pero hindi din
perhaps
po ito
this could be
dapat
my last,
maging
question,
dahilan naman
Your
para
Honor, Mr. Presiding
manatiling
Officer.
mailap po ang pananagutan.
Constitution
Ang mabuting
recognizes
batas ay
two equally
important kayang pangalagaan ang privacy ng hindi
confidentiality
po nasasakripisyo
on one
ang
hand,
accountability.
our laws
and the
must be
freedom
able
of
to protect
information
both
Mr. Presiding Officer. Maraming salamat po, Ginoong Pangulo. Maraming salamat po, and public accountability on the other.
Thank you, Senator Judge Villanueva. Your remarks and
Attorney Poa,
responses there
gusto
too
ko
are
lang
duly
pong
noted and entered into the
malinawan for
record.
the
Senator
benefit
Judge
of
Pia Cayetano
this
is
representation
next, I
and
believe.
our dear colleagues here,
You may proceed, ma'am, when you're
Senator
ready.
Judges. May legal distinction po ba between disclosure of information to the general public and the limited production of records solely to this impeachment court in the exercise of its constitutional function? Because
I'm ready to
we
proceed,
understand
Mr.
that
Presiding
the
Officer.
principle of freedom
I'd like
of
to start this
information
discussion with a
is rooted
question
in transparency
that,
and public
hopefully will allow our
accountability,
kababayans who are
especially po
watching,
when the
listening, to
conduct of
understand the
a
situation. Of
public
course, I pose it
officer
also to
is
the
under
parties.
constitutional scrutiny.
If the government
Now, if confidentiality is
had
the
in mind
concern,
that there's
would you agree, Attorney
business-
Poa, that
a business and, of course,
that this impeachment
a
court
particular
can
businessman or
impose
businesswoman who
safeguards
is violating
on the use
a lot of laws
and
pertaining
disclosure
to the operation
of
of their business, be it
the records?
customs
Kung
law,
maaari lamang po
BIR,
na, kung maaari naman po
regulations,
na
can they just
magpatupad
proceed
ang impeachment court
and
ng
pwede ba silang basta na lang mag-request ng
sapat
dokumento
po na
o mag-file
safeguards
ng kaso
upang mapanatili ang confidentiality
na
ng mga
requiring
records?
the
Bakit
businessman
po
and
dapat maging
the corporation
hadlang
to
ang
produce those
confidentiality
documents?
sa isang
Pwede ba?
impeachment court
So,
upang
yun ang pag-isipan
suriin
natin, no? Kasi
ang
yun ang
mga
tanong
impormasyon na
Similarly,
maaari nga pong may
ginagawa ko lang
kinalaman
ng
sa
ibang
mga isyung
analogy,
nararapat nitong
para maintindihan
resolbahin
ng kababayan
bilang
natin.
isang impeachment court.
Para
So,
sa
this is
atin
the
po,
essence,
kung ano man pong hakbang ang pwede o hindi
dear
pwedeng
colleagues,
gawin ng
parties,
isang impeachment court
of the
tulad
principle
ng
of
nasa
due
harap
process.
natin na ngayon. It must be
This is ingrained
confined
in our
to
Constitution.
the limits imposed by the
Totoo po
Constitution
na
and
may
the
karapatan
laws.
ang gobyerno
So,
at obligasyon
kahit
ng
sabihin po
gobyerno
natin, we are
patakbuhin ng
not
maayos ang
against
gobyerno.
transparency. I
But
just
it's
want to make that
always
clear, Your
with due
Honor.
respect
We
to
are
the
not
rights of
against
the- of
accountability.
every
But again, as I've
individual
mentioned
Filipino,
last
that is
year,
the right to
last
life,
week rather,
liberty, and property. So, bago
hindi
mo
naman
sagasaan
porket po
yung
that
right to
we are
life,
all looking
liberty,
for
and property,
accountability at
siguraduhin mo
transparency.
lang na may basehan ka.
Isasantabi
Yun
na
lang
lang
naman
po
ang sabi.
natin
So, of course,
kung ano ang mga
gusto ko
karapatan,
talaga na
hindi lang
maayos
para sa
ang patakbo ng
impeachable
gobyerno
officer, pero para kahit
if somebody's
sinong
life is
Pilipino
also
na
in danger,
nakasaad
then
sa
government has
batas,
to step up and
including
prevent
absolute
somebody's liberty. Kasi
confidentiality
nga,
in terms of AMLAC reports,
sinasagasaan
which
niya
we are
yung life
pointing
and
to.
liberty ng ibang
So,
tao.
para
So
po
it's
sa
a
atin,
balance, no? I think we can all agree it's a balance.
Nakikita ko
So I want to
yung
go
punto
straight
po
into a
ng ating
landmark case
hukom,
and I will
na
ask both
paano kung
parties for
mag-impose na
their
lang tayo ng
legal
certain
opinions on
condition.
it. Kasi ito sa
However,
legal
Your Honors,
proceeding.
those certain
Pero gawin nyo
conditions
lang
may be
simple,
allowed
para hindi,
for other
hindi
records,
masyado
pero
complicated
pagdating
para
sa
sa mga
AMLAC po,
nakikinig sa atin.
absolute po kasi yung prohibition. And if we
So in
were
the landmark
to
case of Stonehill versus Diokno,
amend
1967
or at least
pa po ito,
suspend
karamihan
the
ng
provision
mga
of
lawyers
8A,
hindi pa
then it is as if
pinapanganak.
this honorable
The importance
court
of due
is
process
actually
was
doing
highlighted,
some sort
and the
of
Supreme
judicial
Court discussed
legislation, no?
points.
Because we are
General warrants
technically
are void.
suspending this
Sabi ng
law
Supreme
for
Court,
a specific
a warrant must be issued
person
on probable
na hindi
cause
natin
for one
pwedeng gawin sa
specific
iba.
offense
That
and
is
must
why
particularly
ang sa
describe
akin
the
lang
thing
po, ang
being
sa
seized.
amin
So,
sa
kailangan
punto ng
particular
depensa
ang description dun sa
paano po yun?
warrant.
Meron po pong instances na
Warrants that
papayagan
leave
na
it
lang
to the
natin isang
discretion
tabi
of the
natin yung
officer
batas
serving them to
at merong
decide what to
instances na
seize
hindi.
or general warrants
I think, Your
outlawed
Honors,
by the
we feel, the
outlawed by
defense
the
feels, Your
Constitution
Honors,
because they place
that
the sanctity
in the search for
of the home and
truth,
privacy at the mercy
transparency,
of prosecutor.
accountability,
So sinabi dito
we must still work within a
kailangan specific.
framework,
Take note
which
warrant ito ha. So
which
naman ang
means that we must
pinag-uusapan natin.
work
Alam ko po yun.
within the limits
Pero I'm pointing
imposed
it
by the
out kasi ang
Constitution,
magiging tanong
the
ko
laws,
later on
and the
is kung
rules of the
relevant
land.
ito sa kaso.
Yun lang po, Your Honor.
Salamat po,
The
Attorney.
other
Mr. Presiding
principle that
Officer,
was
just a
established
few
in Stonehill
seconds,
versus
just to
Diokno
put on
was the
record,
exclusionary
ang
rule.
Senado po
Evidence
ay
obtained
nasa
through an
plenaryo na
unconstitutional
po
search is
yung
inadmissible for
proposed
any
right
purpose
act
in any
natin
proceeding. Ito
na
po yung
maraming
tinatawag na the
sumuportang
fruit
mga
of the
kasamahan
poison tree.
natin.
Pag nakuha
Ito
mo
kasama
yung
po dito yung
information
amendments to AMLA
dun
to put
sa
in black and white the circumstances
paraan,
under
kung ano yung
which bank
information mo,
records, financial
bawal
transactions
pakita yun.
may
And
be
this is
lawfully
where
accessed by
I
competent
need to get
authorities,
guidance from
subject
the
always, of
presiding
course, Mr.
officer.
President, to appropriate
If
safeguards
I'm
and
allowed,
due process.
I don't have to
gusto ko
name
lang pong
names,
banggitin that
to
indeed,
share the
confidentiality
discussion
is an
that we
important
had
legal
in focus,
protection, pero hindi din po ito
para
dapat
lang mabanggit
maging
ko
dahilan
na ito
naman
yung mga provisions
para
of law na napag-usapan.
manatiling
Am I
mailap
allowed
po
to do that?
ang
Would you like me to
pananagutan.
approach you?
Ang
Please
mabuting
let me know.
batas
Because I will abide.
ay kayang pangalagaan ang privacy
Basically,
ng
because
hindi
ang
po
nangyari is we had our own
nasasakripisyo ang
discussion
accountability.
and I want
Our
to
laws
mention
must must be able to protect
provisions
both,
of law that
Mr.
we discussed.
President,
I don't
Mr.
have to
Presiding
mention
Officer.
names.
Maraming salamat po, Ginoong Pangulo. Maraming salamat po, our
The lady
counsel.
may proceed.
Okay, thank you.
Thank you, Senator
So-
Judge Villanueva. Your
Tungkol
remarks in
dito sa
response thereto are
exclusionary
duly
rule,
noted
ulitin
and
ko,
entered into
fruits
the
of the
record.
poison
Senator
tree.
Judge Pia
Yun nga sa
Cayetano
aming
is
very
next, I
open
believe.
discussion, and I thank many
You
of
may
our
proceed, ma'am,
colleagues
when you're
who
ready.
were I think we engage in a fruitful discussion for some, not for all. I think yung iba talagang gustong makipag-debate at di-debate kasi gusto ko rin matuto, no? I think all of you will attest na I also wanted to learn from all of you kung anong perceptions nyo sa batas, kung ano din yung sinasabi ng mga abogado nyo. So dun sa fruits of the poison tree,
I'm ready to
sabi
proceed,
ko,
Mr.
kung
Presiding
yung
Officer.
pinanggalingan ng mga dokumento,
I'd like to start this discussion
bawal
with a question
na kunin ng
that,
basta-basta.
hopefully will
Then,
allow
paano mo
our kababayans
gagamitin?
who are watching,
And meron
listening,
kasing
to understand the
observation
situation.
na
Of course, I
lumabas
pose it
na
also
kasi
to
yung
the
documents
parties.
na yon sa House. So
If
nakita
the
na ng publiko
government,
sa House. So sabi ko, pero
had in
if
mind
I will
that there's
look at, and this is where I will pose the
business-
question to all of you,
a
no?
business
Medyo
and,
layered
of
eh.
course,
So pasensya na sa
particular
medyo
businessman or
complicated.
businesswoman who is
Yung
violating
isang concern
a
ng
lot of
defense
laws
na nabasa
pertaining
ko
to the
is that
operation of their
hindi
business, be it,
nag-allege ng ultimate
customs law,
facts. Hindi
BIR,
klaro kung ano yung
regulations.
naging kasalanan
Can they just
at hindi
proceed?
na-identify ng maayos
And
itong facts na to that lead
Pwede ba silang basta
to
na lang
a conclusion
request ng dokumento
of law.
o mag-file
So, wala
ng
daw
kaso,
yun. Later on, I will ask both
na
parties again to
requiring
also
the
clarify that.
businessman and
But the point
corporation
is,
to produce
kung
those documents.
walang
Pwede ba?
basihan
So, yun
yung
pag-isipan
paglabas
natin,
ng
no?
ebidensya
Kasi yun
na
ang
yun.
tanong eh.
Similarly,
It is the fruit of the poison tree, then you
ginagawa
cannot
ko lang ng
use
ibang
it,
analogy. So yun yung
para
importante
maintindihan ng mga kababayan
dito.
natin.
Kasi, so this is
I'm
the
sure
essence.
nakita nyo na
Sa korte, kahit sabihin nyo pong sa mga
your
legal
colleagues,
drama na na-throw
parties,
out, the case is thrown
of
out
the principle of due
because
process.
na-violate ang due process.
This is
So
ingrained
that's
in
the
our
discussion I want to
Constitution.
have. I want to hear both
Totoo
ha,
po na
wala
may
akong
karapatan ang
kinikilingan
gobyerno
dito.
at obligasyon
I'm just
ng
explaining na
gobyerno
yun yung argument ng
patakbuhin ng
defense
maayos ang
na walang
gobyerno.
due process,
But it is
kulang,
always
at
with due
why
respect to the
prosecution
rights of
would
the
you
po-
say
of
na nasusunod
every
yung due
individual
process? And before I
Filipino.
give the
That is
floor to the
right to
parties,
life, liberty, and
yung
property.
sinabi
So
kong
bago mo
kaso na
sagasaan
Stonehill versus
yung
Diokno,
right to
very
life,
interestingly
liberty, and
involves
property,
the esteemed
siguraduhin mo
father
lang na may
of
basihan
our
ka. Yun lang
colleague,
naman ang
Congressman.
sabi.
So of course
Prosecutor
ako,
Chel Diokno,
gusto ko talaga na maayos ang in the
patakbo ng
case of
gobyerno
Stonehill versus
para
Diokno,
if somebody's life
is
is
also
also
in
in
danger, then government has
the
to step
father
up and
of,
prevent somebody's liberty.
Congressman
Kasi nga,
Diokno was the Secretary of
sinasagasaan niya
Justice.
yung life
And
and
in this
liberty
case,
ng
the
ibang
government
tao. So
through
it's
the
a balance.
secretary
No? I think we can
and
all
other
agree sa
prosecutors
balance.
suspected
So I want to
that
go
Harry
straight into a
Stonehill
landmark case,
and his
and I will
associates
ask
and several
both
corporations
parties
that
for
they
their
control
legal
were
opinions on it.
violating
Kasi it's a
central
legal
bank
laws,
tariff and
Pero
customs
gawin nyo
laws,
lang simple.
para hindi
Internal Revenue Code
hindi
and the
masyado
revised
complicated
penal code.
para
So
sa mga
nagsampa sila,
nakikinig sa atin.
nag-request sila ng issuance of
So
search
in the
warrant.
landmark case of
At ang
Stonehill
gusto nilang
versus
tingnan
Diokno,
is books of accounts,
1967
financial
pa po ito. Karamihan ng
records,
mga lawyers hindi pa pinapanganak.
vouchers,
The importance of
receipts,
due process was
ledgers,
highlighted.
etc.
And the Supreme
And other
Court
documents.
discussed 2 points. General warrants
showing
are void.
all
Sabi
the
ng
business
Supreme Court,
transactions.
a warrant must be issued on probable cause for one
Stonehill
specific
and the other
offense
petitioners
and
filed a
must
petition
particularly
before the
describe
Supreme
the thing
Court,
being
arguing
seized. So
that the
kailangan
search warrants
particular
were general
ang
warrants
description
because they
dun
did not
sa,
particularly describe the things
warrant.
to be seized. So
Warrants that lead
general
into the
papalayon
discretion of the officers
books of
serving them
accounts,
to decide
financial
what to
records,
seize,
receipts,
or general warrants outlawed by the
general
Constitution,
papalayon,
outlawed
and
by
the Supreme Court
Constitution
ruled
because they
that
place the
indeed
sanctity
general
of the
warrants
home and
are
privacy
void.
at the mercy
Warrants
of
must
prosecutors.
be
So sinabi dito
based on probable
na
cause.
kailangan
Sabi ko na yun,
specific.
ano?
Take note
And then
warrant
that
ito
case
ha.
also
Hindi naman
adopted
ang
the
pinag-uusapan natin.
exclusionary
Alam ko
rule,
po yun.
holding
Pero
that
I'm pointing it
evidence
out kasi
under
ang magiging tanong ko later on is kung relevant
is
ito sa kaso.
inadmissible.
Okay?
So,
I
the
now pose my
other
questions.
principle that was established in Stonehill versus
Applicable
Diokno
po ba
was the exclusionary
ang,
rule.
kaso na ito,
Evidence
Hill versus
obtained
Diokno,
through
as far
an
as the,
unconstitutional search is inadmissible
prosecution
for
is
any
concerned,
purpose in
and
any
then also
proceeding.
for
Ito po yung
defense
tinatawag na the
applicable.
fruit of the
Take
poison
note,
tree.
I've read
Pag nakuha
most
mo
of
yung
the pleadings.
information,
Well, all of the pleadings,
dun sa
mahaba sila,
I kind of
bawal
know
na
your answer.
paraan.
Kung ano yung
But sa dami,
information
I like
mo,
to hear it again, and
bawal
I think,
ipakita yun.
of course,
And this
karamihan
is
ng kababayan
where
natin did not read it.
I need to
So
get
explain natin
guidance
sa kanila
from the
because this is a
presiding
landmark
officer.
case. Kung ikaw
If
ay law
I'm
student
allowed
na magbabar,
I don't have to name
ito yung
names,
mga kasong titingnan
to
mo.
share
So
the
malay mo,
discussion
matanong
that
yan
we
sa
had
bar. So nakatulong
in
man lang
focus.
tayo dun sa mga bar students na
Para lang
maliwanagan sila.
mabanggit
Baka
ko
mamit
na ito
question
yung mga
to.
provisions
Is
of
it
law
applicable or not?
na
That is my
napag-usapan.
question. I will sit
Am I
down
allowed to do
and then I
that?
will
Would you
come
like
back
me
for
to
my next.
approach
Thank
you?
you.
Please let me know.
Thank you, Your Honor.
Because
If
I
I
will
may be
abide.
recognized.
The member of the
Basically,
panel of
because ang
prosecutors
nangyari
may
is we had
proceed
our own
to give his
discussion.
answer.
And I
Thereafter,
want to mention
the counsel for respondent may do so as well.
provisions of law that we
Iba
discussed.
po
I
ang
don't have to mention
konteksto ng
names.
search warrant. na naging
The lady may
main
proceed.
issue
Okay, thank you.
sa Stonehill versus Jokno.
So,
sa konteksto po natin
tungkol dito
na
sa
subpoena ang
exclusionary rule,
pinag-usapan.
ulitin ko, fruits of the
Ang
poison
search
tree.
warrant po, ang
Dun nga sa
governing
aming
law
very
po
open
dyan ay nasa
discussion,
Bill
and
of
I
Rights
thank many
natin,
of our
Article
colleagues
3,
who
Section
were
3.
very,
At
I
kaya
think
siya
we engaged in a
nandun
fruitful
dahil
discussion for
very
some, not for
invasive
all.
po ang
I think
search
yung iba
warrant.
talagang
Pag ang
gustong
isang judge ay nag-issue ng
makipag-debate
search
at
warrant,
di-debate kasi gusto ko rin
pwedeng
matuto, no? I
pasukin yung
think
opisina
all
o
of
yung
you will
bahay ng
attest
person
na I
involved,
also wanted to
pwedeng
learn from all of
halongkatin
you
yung
kung
lahat
anong
ng mga
perceptions
gamit
nyo
niya
sa batas,
dun sa
kung
kanyang
ano din yung
opisina
sinasabi
o sa
ng mga
kanyang
abogado
bahay.
nyo.
Kaya
So
po
dun sa fruits
naglagay
of the
ng
poison
maraming
tree,
limitasyon
sabi ko,
ang ating
kung yung
konstitusyon
pinanggalingan
dahil
ng
marami
mga
ng pang-aabuso, marami ng mga halimbawa ng pang-aabuso
bawal
na
na
nangyari
kunin ng
kahit
basta-basta.
noon pa.
Then,
Iba po
paano mo
ang pinag-uusapan
gagamitin?
natin ngayon. Ang
And meron
pinag-uusapan
kasing
natin ngayon
observation
ay
na
subpoena.
lumabas na kasi yung
Hindi po
documents
ito,
na yun sa House. So nakita na ng
license
publiko
to
sa
enter an
House.
office
So sabi
or to
ko,
search
pero
any place.
if I will
Ito po
look
ay
at, and this is
mismong
where I will pose the
humihiling
question
lang
to all of you,
ng
no?
mga
Medyo layered eh, so
dokumentong
pasensya na
nakasulat
sa
sa loob
medyo
ng
complicated.
subpoena.
Yung
Therefore,
isang
the
concern ng
contexts are
defense
very
na nabasa
different.
ko is
When
that
we speak of a
hindi
search warrant, I
nag-allege
do
ng
agree there
ultimate
should be
facts. Hindi
very
klaro
specific
kung ano
limitations on
yung
how that
naging
warrant can be
kasalanan
enforced.
at hindi
Pagdating naman po sa
na-identify ng
subpoena,
maayos
meron din
itong
po yan,
facts na to
but
that
that is
lead
not governed by the
to
Constitution.
a
It's
conclusion
governed by
of
Rule
law.
21 of the
So,
Rules of
wala
Civil
daw yun.
Procedure,
Later on, I will
which
ask both
basically
parties again
provide
to also
that for a
clarify that.
subpoena to be valid,
But the
it
point
must be
is,
relevant and it must be definite.
walang basihan
Ibig po sa relevance
yung
ay
paglabas
may
ng
kinalaman na
ebidensya
may
na yun.
kaugnayan
It
yan
is
sa
the fruit
mga
of the poison tree. Then you
kailangan
cannot use
patunayan
it.
ng mga facts.
So yun
At
yung
pagdating naman sa definiteness ay klaro
dito,
kung
kasi
anong mga iba't ibang dokumento
I'm sure nakita
ang
nyo na
hinihingi.
sa korte,
In our
kahit
case,
sabihin
we
nyo po sa mga
respectfully
legal
submit, Your
drama
Honors,
na
that
nato-throw
we
out.
have
The case
met
is thrown
both
out
the
because
standards of
na-violate
relevance
ang
and
due
materiality.
process. So that's the
The
discussion
PIR
I want to have. I
records,
want
the
to hear
bank
both, ha?
records, and the
Wala
records of
akong
the
kinikilingan
Anti-Money
dito.
Laundering
I'm just
Council are
explaining na yun
relevant
yung
to the
argument
facts
ng
in
defense
issue
na
pertaining
walang
to
due
the
process,
charges of
kulang,
unexplained
at
wealth.
why
Hindi po
prosecution
natin
would you
malalaman
say na
kung talagang
nasusunod yung due
merong
process. And
unexplained
before I give
wealth
the floor to
ang
the
Vice
parties,
President kung hindi natin
yung
mabubuksan
sinabi kong kaso
yung
na
kanyang mga
Stonehill
bank
versus
records,
Jokno,
kung hindi
very
rin natin
interestingly
makikita
involves
at
the
may
esteemed
lalatag
father
ang
of our
anti-money
colleague,
laundering
Congressman
at PIR
Prosecutor
records
Chel
po nila.
Jokno.
And insofar as
In the case
definiteness
of
is
Stonehill
concerned,
versus
we have
Jokno,
specified
the
the particular documents
father
that we
of,
are requesting. And we
Congressman
have
Jokno was the
included
Secretary
as
of
well an
Justice.
explanation
And
of
in this case,
why
the
those are
government through the
important.
Secretary
Kaya sa
and other
aming pananaw po
prosecutors
ay,
suspected that
we
Harry
have satisfied
Stonehill
the requirements
and his
for a
associates and several
subpoena to
corporations
suspend.
that they controlled were violating central bank laws, tariff and customs laws, internal
Mr.
revenue
Presiding
code, and the
Officer,
revised
before
penal
we,
code. So
recognize
nagsampa
the
sila,
defense,
just a quick
follow-up
request sila
question.
ng issuance of search warrant. At
Bigyan
ang
ko
gusto
ng
nilang
time na
tingnan
bulungan
is
muna
books
siya
of
ng kasama.
accounts,
I'm sorry.
financial
Okay na kayo?
records. No, it's okay.
Senator Judge Pia,
Vouchers,
would you like the council for
receipts,
respondent to answer?
Ledgers,
Not
etc.
yet. Okay.
And other documents. Ask a follow-up question.
You may proceed,
Thank
ma'am.
you. Showing for that, I
all the
appreciate
business
His Honor's
transactions.
response. May I simply point
Stonehill
out,
and
and the other
again,
petitioners
please give
filed
me
a
your
petition before the
explanation,
Supreme Court,
arguing
tama
that
ho
the
yung
search
pagkabanggit
warrants were
nyo na
general
nature
warrants
ng search
because they
warrant
did not
very
particularly
describe
describe
the things to be seized.
because
So, general
it,
pa pala yun. Books of
requires
accounts,
that
financial
pasukin yung
records,
bahay,
receipts,
halugugin yung gamit.
general pa pala yun. And the
Hindi
Supreme
kaya
Court ruled that
invasive
indeed,
din yung
general warrants are
paghalugog
void.
ng records.
Warrants
Is that
must
not
be
extremely,
based on probable cause. Sabi ko
parallel?
rin, ano?
I mean,
And then
is
the
it
case
not
also adopted the
very
exclusionary
similar in
rule,
the sense
holding
that,
that evidence seized
whether
under
is
an
being
unconstitutional
questioned
warrant
now
is
are
inadmissible.
the very
So,
essence of somebody's
I now pose my questions.
savings, earnings.
So, which
applicable
we have
ba
to agree. I
ang,
think there's no
kaso
doubt
na
that
ito
that is
Hill versus
protected.
Jokno as far
But
as
in
the,
fact, His Honor is saying that
prosecution is
it
concerned,
would fall
and then
under
also for
the police power.
applicable.
So,
Take note,
imbis na
I've
papasukin
read
mo sa
most of the
bahay
pleadings.
na nandun yung
Well,
mga
all of the
dokumento,
pleadings,
mahahaba sila,
you will
I do the
kinda know
same
your answer
by asking
but
these
sa dami, I like
agencies
to hear
whether
it
is
again,
the
and I think,
BIR, the
of course,
banks,
karamihan ng kababayan natin
or
did not read
to now
it.
reveal
So explain natin
these
sa kanila because
documents.
this
So
is
that's
a
my
landmark
question.
case. Kung
Is
ikaw
it-
ay
is
law
it
student
in
na
the
magbabar,
prosecution's,
ito yung mga kasong titingnan
is
mo.
mo. So malay mo, matanong yan sa bar. So nakatulong man lang tayo dun sa mga bar students na maliwanagan sila. Baka mamaya trick question to. Is it applicable or not? That is my question. I will sit down and then I will come back for my next. Thank you.
Counsel for the panel for
Thank you,
prosecutors.
Your Honor. If I
May
may, Your
answer. As if a member of the panel of prosecutors may proceed to give his answer. Thereafter, the counsel for respondent may do so as well.
sa court. And that is now considered as evidence by the court that issued the search warrant.
Sa Stonehill
Iba po ang
versus
subpoena, dahil pagka naglabas ng isang hukuman ng subpoena, Itong mga records ay hindi po siya considered yan nasa Bill of Rights natin. Yan po ay ipoproduce lang, dadalhin lang po sa korte. And now it is up to the parties, and I refer to both parties, pag ang isang judge ay nag-issue ng search warrant, pwedeng pasukin yung opisina o yung bahay ng person involved, pwedeng harungkatin yung lahat ng mga gamit niya. Yung pong nakikita po natin sa subpoena, kaya po naglagay ng maraming limitasyon ang ating constitution dahil marami ng pang-aabuso, marami ng mga halimbawa ng pang-aabuso nangyari kahit trial pa. Iba po ang pinag-uusapan natin ngayon. Ang pinag-uusapan natin ngayon, the admissibility of those documents, hindi po ito will only be determined after license to enter an office or to search sa aming mga pananaw ay malaking-malaki ang pagkaiba mismong humihiling lang ng mga dokumentong nakasulat sa loob ng subpoena.
Your Honor, maybe...
Therefore, with the permission of the lady Senator Judge, counsel for respondent may now give this answer to her query. You may proceed, sir.
Very specific limitations on how that warrant can be enforced. Pagdating naman po sa subpoena, meron din po yan, but that is not governed by the Constitution. It's governed by Rule 21 of the Rules of Civil Procedure, which basically provide that for a subpoena to be valid, it must be relevant and it must be definite. Ibig po sa relevance ay may kinalaman na may kaugnayan yan sa mga kailangan patunayan ng mga facts. At pagdating naman sa definiteness ay klaro kung anong mga iba't ibang dokumento ang hinihingi.
Katulad ng isang search warrant,
we respectfully
the
submit,
things
Your
that
Honors,
we are
that
asking
we
for
have
through a
met
subpoena
both the
must be
standards of relevance
particularly
and materiality.
described. Kanina po, nabanggit po ng aking kagalang-galang na opposing counsel na particularly described na po yung kanilang nasulat. However, the defense
hindi po
does
natin
not
malalaman
agree with
kung
that
talagang
proposition
merong unexplained
because
wealth
if we look at it,
ang Vice President.
tama naman po,
Kung hindi natin
nakasulat po
mabubuksan
dito ng
yung
hinihingi
kanyang
nila
mga bank
ay
records, kung
account
hindi rin natin
opening and
makikita,
maintenance records,
mailalatag
KYC
ang,
documents,
anti-money
information
laundering
files,
PIR
signature cards, all
po nila.
account and
And
transaction
insofar as
records, ledgers,
definiteness is
journals.
concerned, we have
Basically, Your Honors,
specified
this is
the
everything.
particular documents that we are
Ibig
requesting.
sabihin,
And we have
specify lang
included as
nila
well an explanation
ang
of
nilalaman
why those are
ng
important.
lahat ng bank
Kaya sa
records
aming
ng
pananaw po
respondent.
ay
So in
we
our
have
view, Your
satisfied
Honors,
the requirements
while
for a
they
subpoena
took
to
pains
suspend.
to specify each and every document, the truth of the matter is they're asking for everything.
Mr. Presiding
Ngayon,
Officer,
pagdating
before
sa
we
subpoena,
recognize the
even in the case
defense,
they cited,
just a quick
yung Rocco
follow-up
versus
question.
Contreras, no? Nakasulat po doon that
Bigyan ko
for
ng time
subpoena
na
to be
bulungan
validly
muna siya ng
issued,
kasama.
when we
sorry.
talk about
Okay na kayo? No, it's okay.
particularly describing
Senator Judge
yung
Pia,
kung ano yung
would you like
hinihingi,
the counsel for
it has
respondent
to
to
be
answer?
evidence that is both,
not yet. Okay.
that is both relevant and material.
You may proceed,
So, ang
ma'am.
tanong
Thank you for
namin,
that. I
saan ba
appreciate
dito
His Honor's
yung
response.
relevant or material?
May I
Kasi
simply
lahat na po ng
point out, and
records
again,
hiningi
please
eh.
give me your explanation.
So, and this bolsters
Tama ho yung
our
pagkabanggit
theory,
nyo na yung
of course,
nature
with all
ng
due
search
respect
warrant,
to the
very
opposing
invasionary,
side,
di ba?
na
Because
kaya namin tinatawag o kaya namin
it,
natawag na fishing expedition na
requires
to.
that pasukin
Kasi
yung bahay,
lahat na ng
haluhin
records
yung
hiningi,
gamit.
pero hindi naman
Pero
matukoy.
hindi kaya
Which would actually
invasive
be
din
relevant? Which
yung
would actually
paghalugog
be
ng records? Is that not
evidentiary to
extremely,
the accusations
parallel?
they have
I
made
mean,
under
is
the
it not
articles of impeachment.
very similar
So,
in the
pero
sense
dito,
that,
hinihingi natin 20 years
what is
worth
being
of
questioned
records.
now
And then, paano po
are
yun?
the very
Hihimayin
essence of
natin?
somebody's
Maghahanap tayo
savings,
ngayon kung may
earnings.
relevant
So,
o wala?
which
brings me
we
back
have to agree.
to
I
yung
think there's
BIR
no doubt
records.
that is
Nakaseal
protected.
po yung box.
But in fact, His Honor is saying
So I would
that,
say, both
it would
parties,
fall
hindi natin
under
alam kung anong nasa
police
loob
power.
nun.
So,
Yet,
ibis na papasukin mo
we're
sa
hoping
bahay,
na somehow,
nandun
pag
yung mga
nabuksan yung box
dokumento,
na yun, meron po tayong
you will do
makikitang
the same
ebidensya. And that's
by
why,
asking
again,
these
with all due
agencies
respect, we
whether
called
it is
it
the
a
BIR,
fishing
the banks,
expedition.
or
Kasi
AMLA
hindi
to
naman
now
na-identify
reveal these
kung
documents.
ano mismo
So that's
doon
my
yung
question.
pwedeng
Is it-
ebidensya
is it
laban sa
in
sinasabing
the
unexplained wealth
prosecution's,
umano ng
is it the point of view of the
vice-presidente.
prosecution
So,
na iba yun?
with the
Iba
question,
invasive yun? Kayo
for us,
gumamit
yes,
ng word na invasion tayo ng
the
talis,
Stonehill
invasive.
case, Stonehill versus
Yeah.
Diokno,
Anyway, please
directly
answer and
applies
then we'll
to
give the
the
floor
current
to
proceedings.
the, defense,
Kasi nga po
Mr.
doon,
Presiding
sinasabi talaga
Counsel for
na
the panel
dapat
for prosecutors may
specified
answer.
yung hiningi, particularly
As it is.
described
Yung
and
pong search
relevant.
warrant,
But
kung
as
ano
of
man
this
ang
point,
makuhang ebidensya
they're
doon,
asking your honors
ay direktang
for all of
binibigay
these
po
things.
yun sa court.
And
that is
again,
now considered
while
as
they
evidence
specified
by the court
each and
that
every
issued
document,
the search warrant.
kung
Iba po
babasahin
ang
niyo po
subpoena,
ng mabuti
dahil
ito,
pag
they're
naglabas ang
actually
isang
asking
hukuman
for
ng subpoena,
bank
itong mga records ay
without,
hindi po siya
in fact,
considered
telling
yet
us
as evidence.
which
Yan
transaction
po
is
ay
relevant to their
ipoproduce lang,
accusation,
dadalhin lang po sa
which
korte.
transaction
And now
will
it is up to
actually
the
support
parties,
their
and I refer to
accusation.
both parties,
Yun po yung
to
aming
decide
pananaw
which
dito
of those
sa
documents
tanong ng
may
ating
be
kagalang-galang
relevant
po.
in terms
Thank you
of
po.
the evidence that
Your
they
Honor,
are,
please may be allowed to
that they
respond.
need to present. Yung pong nakikita po natin sa
hold on,
subpoena,
counsel,
it is
for
not
the
in
panel of
any way
prosecutors. Senator
invasive.
Judge P
Because
is
as
the
I
one
mentioned
asking the
earlier,
questions.
and as pointed out by
Unless
Senator Enrile when he
it's
was
not a
the
debate
presiding
between
officer
the two
in the Corona
counsels. You're merely
trial,
responding to
we
answers
are
from
simply
questions
having
by
those
Senator
documents
judges.
produced.
I actually
The
prefer not,
admissibility of
pero
those
alam mo na,
documents
baka sabihin naman na may
will
bias
only
tayo
be
pag di ko naman
determined
pinayagan.
after
Payagan,
no,
if offered by the parties.
I defer to...
Kaya po sa aming mga
Senator Judge
pananaw
Pia, you
ay
asked the question,
malaking-malaki
they
ang
answered.
pagkaiba
It is not for
ng
the
search
opposing
warrant
counsel to
sa
answer
subpoena.
points raised. They had that chance when they did their
Your Honor,
oral arguments.
With the permission
rebuttal
of
and
the
surrebuttal.
lady
You may
Senator
proceed with your
Judge,
question,
counsel
Senator Pia.
for respondent
Sige,
may
my
now
question
give this
is, what is
answer
your
to her
question?
query. You may proceed,
Or
sir.
what is your comment?
Thank you,
Go
Your
ahead.
Honor. Your Honor,
But
ang
keep it
posisyon
brief.
po ng
Keep it brief.
depensa dito
Thank you so much, Your
ay
Honor. I just wanted to
subpoena
point out
and a
that
search
this is
warrant
the first time
are very much
actually
similar
an
in
impeachment
that
court
both
is
are
faced
compulsory
with the challenge
processes.
of
So,
determining whether
yes,
the charges of
hindi tayo
unexplained
papasok
wealth
sa
are
bahay ng
valid
isang
or
tao
not.
o ng
Yung
nasasakdal.
previous
But it
Corona
will be
case,
intrusive
hindi po
because
pinayagan
you will be
ng
opening
impeachment
up
court, yung Article
all the
2.4
financial
ng
transactions
Article 2. At
for-
kung ang magiging batayan po natin
sabi nga dito,
ay yung
almost
naging mga
20 years
desisyon ng
of
ating
the
Korte
respondent.
Suprema,
Kaya po,
sinabi mismo ng
katulad
Supreme
ng
Court
isang
in several
search warrant,
cases,
the
na pag
things
ang
that we are
usapin
asking
ay
for through a
unexplained
subpoena
wealth,
must be
kailangan makita yung
particularly
kabuuan
described.
ng
Kanina po,
kinita
nabanggit
ng
po ng
isang
aking
lingkod bayan
kagalang-galang na
at yung mga
opposing
dineclare
counsel
niya sa sabi.
na particularly
Just a
described
very
na
short
po
portion,
yung kanilang
sabi ng Supreme
naisulat.
Court from the same
However,
case I cited
the
earlier.
defense
The
does not
Ombudsman's
agree with that
failure to
proposition
account for all
because
lawful
if you look at
sources
it,
of income,
tama naman po,
including
nakasulat
proceeds
po
from
dito
business
ng
ventures
hinihingi
and
nila
government
ay
benefits,
account opening
further
and
weakens
maintenance
the
records,
allegation
KYC
that Rafael's
documents,
wealth
information
was
files,
unexplained.
signature cards,
The
all
incomplete
account and
assessment
transaction
disregarded
records,
his
ledgers,
accumulated
journals.
assets over
Basically, Your
decades
Honors,
of public
this is
service,
everything.
making it impossible
Ibig
to
sabihin,
determine whether his property
ni-specify
and
lang nila
acquisitions exceed
ang nilalaman
his legitimate financial
ng lahat
capacity
ng bank records
and quote.
ng respondent.
Hindi lang
so,
naman
in
po
our view,
dito
Your Honors,
sa harapan nitong
while
hukom
they
na
took
ginagawa
pains
yung
to
pagtingin
specify
sa
each and every
kabuuan
document,
ng isang
the
lingkod
truth of the
bayan.
matter
The
is
Supreme
they're
Court
asking
has
for
done it
everything.
in this case
Ngayon,
where they
pagdating
looked
sa
at
subpoena, and
decades
even
of the
in the
financial
case they
records
cited, yung
of the
Rocco
person
versus
charged with
Contreras,
unexplained wealth.
nakasulat
And it has
po
also
doon that
happened in the
for
cases
subpoena
of
to be validly
Ragusa
issued,
and
when we
Bigot,
talk about
which were decided
particularly
recently by the
describing
Honorable Court.
yung kung ano yung
Thank you.
hinihingi, it has
Your
to be
Honor, may I at
evidence
least
that is
be
both
given
that is both relevant
1 minute
and
to
material.
respond to that,
So
Your
ang
Honors.
tanong namin,
But of course, I
saan
will
ba
submit
dito?
to
Senator
pleasure.
Judge
Of course, I
Pia,
yield. Of course, I
give you
yield.
the same
Lahat na po
opportunity,
ng
I'm
records
assuming.
hiningi eh.
Yes, Your Honors.
So, and this bolsters our theory, of course, with all due respect to the opposing side,
yung mga na-mention na case ng
kaya
ating
namin
distinguished
tinatawag o kaya
opposing
namin
counsel.
natawag na
However,
fishing
those
expedition
cases
ito.
do not
Kasi
involve impeachment.
lahat na ng records
And why is
hiningi,
that
pero hindi
relevant?
naman matukoy.
Because in impeachment,
which would actually
as we
be
have said,
relevant. Which
merong
would actually
allegation
be
ng unexplained wealth,
pero wala naman pong nakasuporta
the accusations
ng mga documents
made
para
under
makita
the
natin
articles
ano
of
ba yung basis na
impeachment.
naging alegasyon.
So, pero
Pangalawa
dito,
po, hinihingi
again,
natin
in
20
impeachment,
years worth
according to
of
the
records.
case of Duterte
And then
versus
paano
House
po yun?
Representatives,
Hihimayin natin,
meron po
maghahanap
tayong
tayo
tinitingnan
ngayon
kung ano
kung
ba
may
talagang
relevant
impeachable
o wala.
offense.
Which brings
At
me
yun
back
po ay
to
again,
yung BIR records
offenses or
na
acts or
po yung
omissions
box.
committed
While
while
I
the
would
public
say
officer
both
is
parties
occupying
hindi natin
the
alam kung
impeachable
anong nasa loob
office
nun.
and in relation
Yet,
to such office.
We're hoping
that enough, Your
na
Honors,
somehow,
is very
pag
clear
nabuksan yung
under
box
the
na yun,
decision.
meron
That
po
is all,
tayong
Your Honors.
makikitang ebidensya.
Thank
And
you,
that's why,
Counsel for responding.
again,
Senator
with all due
Judge
respect,
Pia,
we called
proceed.
it a fishing expedition. Kasi hindi naman na-identify kung ano mismo doon yung pwedeng ebidensya laban sa sinasabing unexplained wealth umano ng Vice Presidente. So, with the question, for us, yes, the the Stonehill case, Stonehill versus Diokno, directly applies to the current proceedings. Kasi nga po doon, sinasabi talaga na dapat specified yung hiningi, particularly described and relevant. But as of this point, they're asking your honors for all of these things.
Mr. President,
And
Mr. Presiding
again,
Officer, I'll go to my next
while
point,
they
but
specified
I
each and every
kind of
document,
overlap with this point as
kung
well.
babasahin niyo po ng mabuti ito,
bear with
they're
me.
actually asking for all bank records without, in fact, telling us which transaction is relevant to their accusation, which transaction
My next
will
point,
actually
Mr.
support their accusation.
Presiding officer and
Yun po yung
parties.
aming pananaw dito
is still
sa
on
tanong
due process.
ng ating kagalang-galang.
This is
po.
the
Thank you po.
requirement that every
Your
pleading
Honor,
must
please, may
allege
be allowed
ultimate
to
facts and must not
respond.
contain conclusions of law. So again, I'll
Hold
start
on,
with an
hold
example.
on, counsel for the panel of prosecutors. Senator Judge P is the
If,
one
for
asking
example,
the questions.
if there's a case filed,
Unless
no, and
it's not a
sabi,
debate between
si
the
Juan
two
robbed
counsels.
the house
You're merely
of Mario.
responding to answers from
So
questions
para
by
maintindihan ng mga
Senator Judge.
kababayan natin,
I
Juan
actually
robbed
prefer not,
the
pero
house of
alam mo na,
Mario.
baka sabihin naman na may
That is a
bias tayo
conclusion
pag
of
di ko naman
fact. Nangyari na
pinayagan.
daw yun.
Papayagan,
And if
I defer
there's
to-
another
to
allegation that
Senator
says
Judge Pia,
therefore
you
Juan
asked
is
the
guilty of
question,
robbery,
they
that is a
answered.
conclusion
It's
of law.
not for the opposing
So,
counsel to answer points
Again,
raised.
I try my
They
best
had
not to
that
be
chance
technical.
that
It's
they
in
did
my,
their
I would have wanted
oral
to be a teacher,
arguments,
if not
rebuttal and
a lawyer,
surrebuttal.
so
You may
I do
proceed
like
with your
to be able
questions,
to
Senator
explain
Pia.
things well.
Sige, my question is, what is your question?
So ang
Or what
hinahanap
is your
dito
comment?
is,
Go ahead.
bakit mo,
Keep it
gusto mo
brief.
patunayan
Keep it
yung
brief.
facts mo.
Thank you so
Yun
much,
yung
Your Honor.
kailangan sa ultimate
I just wanted
facts.
to point out
Kailangan mo patunayan,
that this
bakit
is
mo
the first
sinasabing
time actually
Juan
an
robbed the
impeachment
house
court
of
is
Mario.
faced
Sasabihin mo,
with
ang
the
ultimate fact
challenge
dyan
of
example is
determining whether the charges of unexplained wealth
si Juan ay
are
nakita dun sa
valid or not.
vicinity ng
Nung
bahay ni Mario.
previous corona
Tapos
case,
ito si Mario,
hindi po pinayagan ng impeachment
narinig
court,
na nagsisigaw
yung
na
Article 2.4
inanakawan kami,
ng
whatever.
Article 2.
Tapos
At
yun,
kung ang
meron
magiging
siyang
batayan po
testimonya
natin
na ano yung nawala
ay
sa
yung
kanila.
naging mga
Tapos may
desisyon ng
nakakita
ating Korte
na
Suprema.
kamukha ni Juan
Sinabi mismo
yung nandun.
ng Supreme
Tapos
Court in
namukha
several
nila,
cases
na-describe nila na 5
na pag
feet
ang
10,
usapin ay
medyo mapayat,
unexplained
gano'n. So yun
wealth,
yung mga ultimate
kailangan
facts na later on
makita
sa
yung
evidence,
kabuuan
patutunayan.
ng
That's just
kinita
very general,
ng isang
no?
lingkod bayan.
And then later
At
on,
yung mga
para nga
dineclare
mapatunayan
niya
yung
sa
robbery,
Senate.
i-allege
Just
na
to
yun
quote
yung
just a very short
elements of
portion,
the crime
sabi ng
that
Supreme Court,
constitute
from the same
robbery.
case I cited earlier,
Nung di pa ako
the
abogado, di ko naman
Ombudsman's
alam ang
failure
difference ng
to
robbery
account
and
for
theft.
all
Yung robbery kasi
lawful
qualified
sources
yan
of
eh.
income,
So pumasok siya sa bahay
including
using
proceeds from
violence. That's
business
what makes it
ventures and
robbery. So kailangan
government
i-allege
benefits,
yun.
further weakens
Sorry
the
to be a
allegation
bit technical,
that Rafael's
kung yan
wealth
ang,
was unexplained.
Phrase of the day.
The
Let's not be
incomplete
technical.
assessment
Phrase of the week, phrase of the
disregarded
month.
his
But
accumulated assets
we have
over
to be able
decades
to
of public service,
explain
making it
these things in a way that
impossible
people
to
understand
determine
without
whether his
forgetting
property
that,
acquisitions
these
exceed
are
his
rights
legitimate financial
of the defense
capacity
and rights
and
of
both.
the person
Hindi lang naman
who's
po
being,
dito
tried
sa harapan
here, and
nitong
kailangan
hukom
maliwanag yung ating
na ginagawa
accusation.
yung
So, my question
pagtingin
now
sa
goes
kabuuan
to both
ng
the
isang lingkod
prosecution
bayan.
and
The
the
Supreme
defense.
Court has done it in this case where they looked at decades of
I
the
know that the
financial
defense
records
in
of
their,
the person charged with unexplained wealth.
answer
And it has also happened in
questions
the
the
cases of
failure
Rabusa
of
and
the
Ligot, which
complaint
were
or the
decided
articles
recently
to
by the Honorable
allege
Court.
ultimate
Thank
facts,
you.
and therefore,
Your
I
Honor,
think
may
they
I at
filed the
least be
case before
given
the
just
Supreme Court. I'll give you your
1
time to
minute
answer
to
because
respond to that,
I
Your
don't
Honors.
really
But
recall
of
that
course,
I
I will
heard
submit
mention
to
that.
the
Of course, I
Court.
yield. Of course, I yield.
The same opportunity, I'm
As
assuming.
Yes, Your
presiding
Honors.
officer,
Again,
papasadahan ko lang naman na nabanggit ko yun
hindi ko
na
po
nandyan yan sa
tinutulugsa o ino-oppose yung
nandun sa
mga na-mention na
memorandum,
case ng
pero
aking
hindi ko
distinguished opposing
naalalang,
counsel. However,
I'm
those
just speaking naman
cases
for myself kung
do
ano mga
not
sinabi ko
involve
dun sa aming
impeachment. And why is that
meeting na hindi ko
relevant?
naalalang
Because in
nabanggit. Baka naman
impeachment,
nasabi, di ko lang
as we have
naalalang
said,
na-emphasize. Kasi nga
merong
limited yung time.
allegation
But
of
I do
unexplained
recall
wealth,
that
pero
it's
wala
in the
naman
complaint,
pong
it's in the answer,
nakasuporta
and then it's also in
na
the
mga
memorandum.
documents
So,
para makita natin
pinupursue
ano
nyo
ba yung
ito?
basis na naging
Kasi
allegation.
me as a
Pangalawa po,
judge,
again, in
importante
impeachment,
to, kasi,
according to the case of Duterte versus
paano ba
House of
didepensa ng maayos
Representatives,
kung
meron
hindi
po
nga
tayong
nag-a-allege
tinitingnan kung ano ba
ng-
talaga ang impeachable offense.
ng ultimate
At yun po
facts that
ay
go
again,
into the case.
offenses or
And
acts or
then,
omissions committed while
for
the
the
public
prosecution
officer
naman,
is occupying
may
the
I
impeachable
ask
office
you
and in
kung
relation
saan,
to such
without,
office.
because
That
bawal
enough,
ho na
Your
tanungin
Honors,
ko
is
for
very
you to
clear
state your
under the
case.
decision.
I cannot do
That is
that,
all, Your
no?
Honors.
But what I'm
Thank you,
asking is if
Counsel
you
for
can point
responding. Senator
out sa
Judge
inyong
Pia, may
articles
proceed.
kung saan doon yung allegations of ultimate facts. Kasi public document naman yan eh. Para lang maaral ko, naasan dyan yung allegations nyo of ultimate facts. And this is where, before I pass on the floor to the parties to answer, I want to go into the principle of fishing expedition. Nagkataon na I came across the trial
Mr. President,
that we had
Mr.
for,
Presiding Officer, I'll go to my
former
next
Chief
point, but
Justice
I
Corona. And
will kinda
lumabas lumabas
overlap
yung
with this
issue
point as
ngayon.
well.
Nasabi ko, eksakto ito yung pinag-aaralan
bear with me.
natin for today. Yung fishing expedition, and no less than the defense had to explain it in Filipino kasi sabi, baka
My
hindi
next
alam
point,
yung
Mr.
ibig sabihin ng fishing expedition.
Presiding Officer and
Pangingisda ba daw yun?
parties.
parang hindi naman daw yun yung
still on due
translation,
process.
no? Pero ito yung naghahanap
This
ka,
is the
naghahagilap ka ng
requirement that every
ebidensya.
pleading must
Kasi wala
allege
kang
ultimate facts
ebidensya.
and must not
So,
contain
I'll go
conclusions
back
of
to
law.
a case and
So,
sama niyo to
again,
sa
I'll
response
start with
nyo.
an example.
Doon po sa kasong Afluencia versus Metrobank
If, for example,
in 2014,
if there's a case filed, no, and sabi,
humingi
si Juan
dito ang
robbed the house
petitioner
of
ng
Mario.
motion for issuance of
So,
subpoena
para maintindihan ng mga
ad
kababayan natin,
testificandum,
Juan robbed
at sinabing
the house
padala
of
daw
Mario.
ng documents relative
That is
to
a
their loan
conclusion
to
of fact.
Metrobank,
Nangyari na daw yun.
as well as those covering
And if
extrajudicial foreclosure.
There's another allegation that
Sabi ng
says, therefore,
Supreme
Juan
Court,
is
this
guilty of
tantamount
robbery.
to
That is a
building their
conclusion
whole
of law.
case from the evidence of
So,
their opponent. Bawal daw
again,
yun.
I try my best not to be technical. It's in my...
I would have
nakabase
wanted the
lang dun
teacher
sa
is not
sasabihin
a
mo
lawyer,
dun
so
sa kabila.
I would
Labas
like
mo
to
nga
be
lahat
able to
ng meron ka
explain things
dyan.
well. No, your case has to be built. Yung
So, ang
evidence mo
hinahanap
has to be
dito
there.
is,
So I will also
bakit
ask
mo
both parties,
gusto mong patunayan yung
is
facts
that
mo? Yun yung
jurisprudence
kailangan sa
relevant to
ultimate
this
facts.
case?
Kailangan mo
For the
patunayan bakit mo
prosecution and then also
sinasabi
for the defense.
Juan robbed the house of Mario.
And then
Sasabihin mo,
let
ang
us,
ultimate fact dyan example is
also
si Juan
include
ay
a
nakita dun
discussion
sa
on
vicinity ng bahay ni Mario. Tapos ito si Mario,
why this is or is
narinig
not
na
a
nagsisigaw
fishing
na
expedition.
nanakawan kami.
Yun nga,
whatever.
napaka-importante po
Tapos
kasi
ito,
ito,
meron siyang
dahil,
testimonya na ano yung nawala sa
it
kanila.
is
Tapos may
ingrained
nakakita
in a
na
complaint
kamukha
na
ni
yung
Juan,
allegations
yung
mo ng
nandun.
ultimate
Tapos
facts,
makuha nila,
mapuprove mo
na-describe
ngayon
nila
with
na
the
5 feet
evidence.
10,
Hindi pwede
medyo
na
mapayat,
wala kang
ganon. So yun yung mga
ebidensya,
ultimate facts na
hihiling mo
later
lang
on
sa
nahihingin
evidence
by way
patutunayan.
of that's just very general,
Clear po
no?
yun sa batas. Kaya
And
nga
then
gusto
later
kong
on, para nga
ipaliwanag din sa akin,
mapatunayan yung robbery,
educate me.
i-allege ngayon yung
Why
elements of the crime
this
that
applies,
constitute robbery.
why this is not a
So,
fishing expedition,
nung
why
di pa
the
ako
case I
abogado, di ko
cited
naman alam ang difference
does not
ng
apply
robbery
because
and
I
theft. Yung
assume
robbery
that's the
kasi
position of the
qualified yan.
prosecution. And then
So,
for the
pumasok
defense,
siya
ano
sa
naman
bahay
po yung
using
position?
violence.
Salamat.
That's what makes it robbery. So, kailangan
The
i-allege
counsel
yun.
for respondent will give his
Sorry to
answer
be a
first
bit
with
technical,
respect to
kung yan ang,
the question
phrase
of
of the day.
Senator Judge
Let's not be
Pia
technical.
on
Phrase of the
ultimate
week, phrase of
facts
the month.
as
But
well as on fishing expedition.
have to be
Thereafter,
able
counsel
to
for the panel of prosecutors. You may
explain
proceed, sir, when
these
you're ready.
things in a way that people
Thank you, Your Honor.
understand without
Pagdating
forgetting
po
that
doon sa sinasabi
these
namin
are
na
rights
lack of
of the
ultimate
defense
facts.
and rights
Ito
of
po ay
the
nagsimula
person,
pa lang doon
who
sa
is
Committee
being,
on Justice
tried
when the
here, and
impeachment
kailangan
complaints
maliwanag
were
yung ating mga
filed.
accusations.
Because the
my
allegation,
question
and I'll
now
stick
goes to
just with
both
this,
the
I believe, Article
prosecution
2.
and the defense.
Pagdating po kasi doon, there was an allegation
I
of
know that the
unexplained
defense
wealth.
in their
Pero wala
answer
pong nakasulat
questions the
kung
failure
saan
of
nila
the
nakuha,
complaint or
ano
the
yung
articles
basehan
to
nung
allege
unexplained wealth na
ultimate
yun.
facts, and therefore,
Ano yung act
I
na
think they
ginawa
filed the
ng
case
Vice
before the Supreme
Presidente?
Court. I'll give you your time to answer.
Kailan
because
yun
I
ginawa?
don't really recall that
At
I
so
heard
sa
it
amin,
mentioned in the
para
oral
masabi
argument.
nilang
So,
nagkaroon ng
again, with the
unexplained
permission
wealth.
of the
Ang basic,
the presiding
if I may
officer, papasadahan
remember,
ko lang naman, na
was
nabanggit
really
ko yun,
just
na
the fact
nandyan yan sa
na
memorandum.
yung SALN
nandun
niya
sa memorandum,
ay lumaki
pero hindi
from
ko
2007
naalalang,
to
I'm just speaking naman for myself kung ano yung mga
2025.
sinabi ko dun sa aming
Which sa aming palagay,
meeting, na hindi ko
does
naalalang
not
nabanggit.
show
Baka naman
any
nasabi, hindi ko lang naalalang
factual
na-emphasize. Kasi nga limited yung time.
allegation
But I do recall
except for
that
the fact
it's in
that
the
it
complaint,
grew
it's in the
bigger
answer, and
over
then
a
it's also
span
in the
of 20
memorandum.
years.
So, pinupursue
Pangalawa,
yung pa ba
wala
ito?
rin
Kasi
pong
me as a
naka-attach,
judge,
which I mentioned in
importante
oral
ito.
arguments
Kasi,
last week, na kahit anong
ano ba didepensa ng
ebidensya,
maayos kung hindi na
or
nag-allege
kahit supporting document
ng-
man lang, huwag na nating tawaging
ng ultimate
ebidensya.
facts that
Supporting
go into
document
the case.
that will support
And
any
then,
allegation whatsoever of
for the prosecution
unexplained
naman,
wealth.
may
And that
I
is why,
ask you
nabanggit ko rin,
kung
na
saan,
after the
without, because
allegations
bawal ho
were
na
made,
tanungin
and
ko
this
for
is
you to
even more
state your case.
significant,
I cannot do that,
after
no?
the
But what I'm
respondent
asking
had
is if you
filed
can
her
point
answer,
out sa inyong
na tinawag pa nga
articles
nilang
kung saan doon yung
non-answer,
allegations of ultimate facts.
doon
Kasi
lang po
public document
naghanap
naman
ng
yan.
mga
Para lang
ebidensya
maaral ko na asan dyan yung
na
allegations
sakaling
nyo
makasuporta
of ultimate facts.
doon sa allegation
And this is
niyon.
where, before
That's
I
very
pass
important
on
for us
the,
because we had already filed their answer before AMLAC documents
floor
were suddenly
to
produced
the
to the
parties to
issuance of
answer.
subpoenas
I want to go
before the
into
BIR box
the
concerned
principle of
that
fishing
we are concerning
expedition.
ourselves with was presented
Nagkataon na
before
I
the
came
Committee on
across
Justice.
the-
Nasa panahon na yun, tapos na po kami sumagot. In fact, when they were saying that
trial
it was a
that we
non-answer,
had for,
to
former
be
Chief
very
Justice
candid with
Corona.
everyone, we wanted
And
to say
lumabas
because it
yung
was a
issue na yun,
non-complaint.
na sabi ko,
Kasi
exactly
walang
yung pinag-aaralan
walang walang ultimate
natin
facts
for
na naka-allege
today.
for us to even answer.
Yung
Now,
fishing expedition and no less
before
than
this honorable court,
the defense
I
had
do
to
recall that in
explain
our
it in
answer, we
Filipino kasi
also
sabi,
took
baka hindi
pains
alam
to
yung
discuss
ibig sabihin ng
no,
fishing expedition,
the
pangingisda
lack
ba
of
daw yun?
ultimate facts and
Parang hindi naman
also
daw yun yung
what we
translation. Pero ito
feel
yung
were
naghahanap ka,
violations of due
naghahagilap ka ng
process
ebidensya.
before the
Kasi wala
Committee
kang
on Justice,
ebidensya.
or at least
So,
with the
I'll go
proceedings
back
that
to
were
a case
conducted
and sama
before
niyo
the
to sa
Committee on
response nyo.
Justice.
Doon po
And
sa
that is also why we have a pending motion for exclusion na ikinalakip namin dun sa answer precisely
Humingi
because
dito
we were
ang
objecting
petitioner
to the
ng
fact
motion for
that these
issuance
pieces
of
of
subpoena
evidence
ducis
were
tecum ad
produced
testificandum
after
at sinabing
we had
padala daw
already
ng
filed our
documents
answer.
relative to their
Now, on
loan
the
to
fishing
Metrobank,
expedition,
as
I
well
think
as
on the
those
fishing
covering
expedition,
extradition
Your Honors,
foreclosure.
our main point is
Sabi ng
this:
Supreme Court,
even
this
if
is tantamount to
we
building
read
their whole case from the evidence of their
twin
opponent.
requests
Bawal daw yun.
for
Hindi daw
subpoenas,
pwede na yung kaso mo,
ulit-ulit po,
nakabase lang
nakasulat
dun
po
sa,
doon,
sasabihin mo dun
because
sa
this
kabila,
may
labas mo nga
show
lahat ng meron ka
context,
dyan.
because
No, your
this
case
may
has to be built.
show-
Yung evidence
prove
mo has to be
something.
there. So I will also
But
ask
para
both
sa atin,
parties,
this is
that
this only
jurisprudence
shows,
relevant to
and
this
at least,
case
again,
for the
on the part
prosecution
of the
and then also
defense,
for the
this
defense.
is somewhat already an admission
and then let
na hindi
us,
pa nga nila alam kung ano mismo doon sa mga hinihingi
also
nila
include a
ang pwedeng
discussion
sumuporta
on
sa mga aligasyon na unexplained wealth. And
why
that's
this
why,
is
if
or
you read
is
the
not
entire
a fishing
request, it
expedition.
uses the word
Yun nga,
may
napaka-importante po
several
kasi
times,
ito
and it even
dahil,
says in
it
one
is
paragraph, I think it's
ingrained in a
3.24,
complaint
but I
na
might
yung
be
allegations
mistaken,
mo ng ultimate
that
facts,
at least with the request
mapuprove mo
for,
ngayon yun with the evidence.
with their
Hindi
memorandum,
pwede
rather,
na
in
wala
their
kang
memorandum,
ebidensya,
nakasulat
hihingi mo lang
po
ng
doon
hihingin
that
by way
this does not
of
assume wrongdoing.
subpoena. Clear po yun sa
But
batas.
they
Kaya nga
want
gusto
those
kong
documents
ipaliwanag niyo sa akin,
nonetheless to
educate
see
me.
if something
Why
there
this
will
applies,
actually help
why this
support
is not
their
a fishing
allegations. That
expedition,
is why we
the
are
case
calling
I
it a
cited
fishing
does
expedition.
not apply because
Dahil
I
in
assume
Tagalog,
that's the position of the
para po
prosecution and then
maintindihan,
for the defense,
sa aming
ano naman po yung
pananaw,
position
sa
niya?
dami
Salamat.
ng hinihing dokumento,
The counsel for
para po
respondent will
itong
give his
nagtatapon
answer
po tayo
first
sa
with
dagat ng
respect
isang
to
napakalaking lambat
the question
at
of Senator
umaasa
Judge
tayo
Pia
na
on
kahit pa
ultimate
paano may
facts
mabingwit
as well
kahit
as on
isang
fishing
pirasong
expedition.
ebidensya.
Thereafter, counsel for the
Maraming
panel
salamat.
of prosecutors. You may proceed, sir, when you're ready.
Your
Counsel
Honor.
for the panel of
Pagdating
prosecutors,
po
the Honorable
doon
Jock.
sa sinasabi namin
Thank you, Your
na
Honors.
lack of ultimate
The question
facts.
propounded to this
nagsimula pa lang
representation
doon
first
sa
is,
Committee on Justice
what are the
when
ultimate
impeachment
facts
complaints were
alleged
filed.
in the articles
Because
of
the allegation,
impeachment?
and I'll stick
Yung po ay
just with
nakasaad
this,
sa
I believe,
page
Article
7
2.
of the articles. And if I
Pagdating
may
po
be
kasi
allowed
doon,
to
there was
just
an
read them
allegation
briefly.
of unexplained
You may do
wealth.
so, counsel.
Thank you, Your Honor.
Pero wala pong
Respondent Vice
nakasulat
President Sara
kung
Duterte committed
saan
culpable
nila
violation
nakuha,
of the
ano yung
Constitution and
basehan
betrayed the public
ng
trust when
unexplained
she
wealth na yun.
A.
Ano yung act
amassed
na
unexplained
ginawa
wealth
ng
manifestly
Vice Presidente,
disproportionate to her lawful
kailan
income
yun
and
ginawa.
earnings during her
So,
incumbency
sa
as a
amin,
public official.
para masabi nilang
B.
nagkaroon ng
failed to
unexplained
fully
wealth.
and truthfully
Ang
disclose
basic,
all her
if I may
all her
remember,
and her spouse's
was really
assets,
just
liabilities
the fact
and net worth,
na
and her
yung
statement
salin
of
niya
assets,
ay
liabilities and net
lumaki
worth,
from
including in her
2007
salins
to
for the years 2022,
2025,
2023, and 2024.
which sa aming palagay
and C.
does not
failed to
show
divest
any
and instead
factual
willfully
allegation
continued
whatsoever,
all her business
except for the
interests
fact that it
during
grew
her
bigger
tenure as
over a
Vice
span
President
of
for the
20
years 2022,
Pangalawa, wala rin
2023,
pong
2024, and
naka-attach, which I mentioned
2025.
in the oral
Please allow me
arguments
to
last week,
briefly explain
na kahit
why
anong
these are ultimate
ebidensya,
facts. Ultimate
or
facts
kahit
are
supporting
basically
document
the
man lang,
essential
huwag na nating
factual
tawaging
elements that
ebidensya.
make up a
Supporting
party's
document
cause of
that will
action or
support
defense.
any allegation
Halimbawa po,
whatsoever
pag murder,
of
treachery,
unexplained
evident
wealth.
premeditation,
And
lahat
that
ng
is
mga
why
kinakailangan ng
nabanggit ko rin
batas
na
para
after the
mapatunayan na
allegations
murder
were
po siya.
made, and this is
In our
even more
case,
significant,
we are alleging,
after
first of
the
all,
respondent had filed her
unexplained wealth.
answer,
And
na
based
tinawag
on
pa
the
nga nilang
jurisprudence, the
non-answer.
elements of unexplained wealth,
Doon
the
lang
factual
po
elements
naghanap
are
ng mga
amassing
ebidensya
unexplained wealth,
na
manifestly
sakaling
disproportionate
makasuporta
to one's
doon sa
lawful
allegation na
income
yun.
and earnings
That's very
during one's
important for us
incumbency as a public
because
official.
we had already filed
So,
our answer
nasatisfy po namin
before
yung
AMLAC
requirement na
documents were
pag-allege
suddenly
ng
produced in the
ultimate
issuance
facts or
subpoenas
essential factual
before the
elements
BIR box
sa tatlong
concern,
bagay na po ito.
that we
The
are concerning
evidentiary
ourselves with
facts
was presented
follow
before the Committee
in the
on
succeeding
Justice.
pages
Nasa
of the
panahon na yun,
articles.
tapos na na po
Doon
kami
po namin
sumagot.
dinetalye
In fact,
kung ano yung
when
mga
they were
iba't
saying
ibang
that
paraan
it was a
kung paano
non-answer,
nakuha
to be
o
very
naamas
candid
ni
with
Vice
everyone,
President,
we wanted
yun
to
ang
say because
sinasabi
it was a
natin na
non-complaint.
unexplained wealth.
Kasi walang
On to the issue of fishing expedition.
walang ultimate
Yung pong
facts
fishing
na naka-allege for
expedition
us
po
to even
ay
answer.
Halimbawa,
before
may subpoena na baka
before this
sakali
honorable court,
meron tayong
I do
makita.
recall that in our answer,
Yun
we
po ang
also
ibig
took
sabihin
pains to
ng fishing
discuss
expedition.
when the
party
lack
requesting
of ultimate
information
facts
does not
and also
know what might be
what we
produced,
feel were
and
violations
just
of
as
due
an off
process
chance
before
tries
the
to
Committee
use
on
that
Justice, or at
instrument
least with
in
the
order to
proceedings that were
gain
conducted before the
evidence
Committee on
that may be
Justice.
used against the other
And that
party.
is also why
Dito po,
we have a
malaki ang
pending
pagkaiba ng
motion for
sitwasyon.
exclusion na
Maalala po
ikinalakip
ninyo,
namin
during
dun sa
the
answer
hearings before the
precisely
Committee on Justice,
because we were
the
objecting to
Executive
the fact
Director of
that
the
these pieces
Anti-Money
of
Laundering
evidence
Council
were produced
testified and produced
after
documents
we had already
showing that
filed our answer.
from
Now, on the fishing
2007 up to the
expedition,
present,
I think on the fishing expedition,
6.7
Your Honors, our main
billion
point is
pesos
this.
ang dumaan
Even
po
if we,
sa account
we read
ni Vice President Sara
the twin
Duterte.
requests for
On that
subpoenas,
basis, and if we go
ulit-ulit
deeper
po,
into that
nakasulat po
report, it
doon,
says that during the
because this
period from
may
2007
show
to
context,
2013,
because this may
during the time that she served
prove
as mayor
something.
and vice mayor,
At para sa
umabot
atin,
po
this
sa halos
is only,
o lampas
this only
3
shows,
bilyong piso
and at
ang
least,
dumaan
again,
sa
on
kanyang
the part
mga
of the
accounts.
defense, this
So
is
may
somewhat
basehan
already
po
an
tayo
admission
para
na hindi pa nga nila
ipalabas
alam kung
ang
ano
bank
mismo doon
records. We are
sa
not
mga
just
hinihingi
guessing
nila
that
ang
there is
pwedeng
something there,
sumuporta sa
because
mga
the
aligasyon
AMLA
na
itself has
unexplained wealth.
confirmed
And
that
that's
there
why,
were
if you
covered
read
and
the
suspicious
entire
transaction
request,
reports
it uses the
submitted
word
to them
may
in those
several
amounts
times,
that I mentioned.
and it even says
Malayo
in one
po ang
paragraph,
fishing
I think it's
expedition sa ginagawa ng
3.24, but I might be
prosecution
mistaken,
dito po. If
that
we had
at
no
least with the
basis at
request
all,
for,
if we did not know
with their
what
memorandum,
was in the
rather,
AMLA
in
reports,
their memorandum,
ayun po,
nakasulat
maaaring
po doon
sabihin na
that
fishing
this does not
expedition.
assume
But in this
wrongdoing,
particular case,
but they
we
want those documents
know,
nonetheless
because these
to
are
see
matters of record
if something
presented before
there
the Committee on
will
Justice.
actually help support their
Second po,
allegations. That
ang
is why
fishing
we are calling it a
expedition,
fishing
maaaring
expedition.
magamit
Dahil in
yan
Tagalog,
sa ibang
para
mga
po maintindihan,
alegasyon,
sa aming
tulad ng,
pananaw, sa dami ng
baka meron
hinihing
kang hindi na-declare
dokumento,
sa iyong salin.
para po itong
But when it
nagtatapon po
comes
tayo
to
sa dagat ng
issues of
isang
unexplained
napakalaking
wealth,
lambat,
it's very
at
clear
umaasa
the
tayo
decisions
na
of the
kahit
court are
papaano
very
may
clear.
mabingwit
To
kahit
know
isang pirasong
whether a government
ebidensya.
official has
Maraming
amassed
salamat.
unexplained wealth, we must look at
Counsel
the
for the
entire
panel of prosecutors,
incumbency
the Honorable
of that
Jokno.
official, starting
Thank you,
from
Your Honors.
day one. We
look
the
at their
question
salary,
propounded
we look
to
at
this
all the
representation
income first
that he
is
or she has
what are the ultimate
earned,
facts alleged
both
in the
lawful
articles
and
of
not.
impeachment.
And from there, we
Yung
make
po
a
ay
determination
nakasaad sa page
whether there was
7 of the
unexplained
articles
wealth or not.
And if I
For
may be
these
allowed
reasons,
to just
Your Honors,
read them
the
briefly.
fishing expedition argument
You may
in
do
our
so,
view
Counsel.
is
Thank you,
totally
Your Honor.
untenable. Respondent Vice President
Senator
Sara
Judge
C.
Pia,
Duterte
you
committed
have further
culpable
questions?
violation of the Constitution and betrayed the public trust when she, A, amassed unexplained wealth manifestly disproportionate to her lawful income and earnings during her incumbency as a public official. B, failed
It's
to
actually
fully
just a
and truthfully
follow-up to what
disclose
the,
all her and her spouse's
prosecution,
assets,
how the prosecution
liabilities and net
responded.
worth
I
in her
think Senator
statement of
Alan
assets, liabilities and net
Peter will
worth,
go into it,
including
but
in her
since this is
salins
my
for the years
line of
2022,
questioning, I'll follow up lang on this
2023, and
point, no?
2024. And C,
His
failed to
Honor,
divest
I earlier
and instead
mentioned
willfully
the,
continued
fruit of the
all
poison
her
tree
business
doctrine.
interests
And ulitin
during her
ko,
tenure
pagka
as
yung
Vice President for
pinanggalingan
the
ng
years
information nyo,
2022,
bawal, hindi nyo na pwedeng
2023,
gamitin yun.
2024, and
So,
2025.
His Honor said,
Please allow me to briefly
I'm
explain
referring
why
to,
these are ultimate facts.
Congressman
Ultimate facts are
Prosecutor
basically the
Jokno,
essential factual elements that make up a party's cause
they
of action
know
or
the contents
defense.
of the AMLA
Halimbawa
report,
po, pag
something to that
murder,
effect. Because it was
treachery,
presented
evident
in the
premeditation,
impeachment,
lahat ng mga kinakailangan
hearing
ng
in
batas
the House.
para
That is correct,
mapatunayan
right?
na
That is your
murder po
statement.
siya.
Yes,
In
oo.
our case,
And,
we are alleging, first of all,
I asked my question and then I will
unexplained
give
wealth.
both parties the
And
opportunity
based
to
on the
respond.
jurisprudence, the elements of unexplained
yung
wealth, the
basihan
factual
na
elements
i-reveal
are
ng,
amassing unexplained
ng
wealth,
AMLC
manifestly disproportionate
and their
to one's
representative
lawful
sa inyo
income and
in
earnings
the impeachment
during one's incumbency as a
hearing in
public
the
official.
House. Because,
So, nasatisfy po namin
ang nakasaad
yung
sa law, I don't
requirement
even
na
want to use
pag-allege
my
ng ultimate
understanding of
facts
the law
or essential
because it's
factual
what is
elements
read in the
sa
law and I
tatlong
won't take up
bagay
the
na po
time
ito. The
of this
evidentiary
court na
facts
isa-isahin ko yun,
follow
pero
in the succeeding pages of
nakasulat
the
doon na
articles.
confidential
Doon po
ito.
namin dinetalye
So, ano
kung
yung
ano yung mga
basis na
iba't ibang
mailabas yun
paraan
doon
kung
sa
paano
impeachment court?
nakuha o
Because, and
naamas
since
ni Vice President yung ang
presiding
sinasabi
officer
natin
has given
na
giving me
unexplained wealth. On to the
the
issue of
permission
fishing
to
expedition.
to
Yung pong fishing
share in
expedition
general
po
the discussion
ay,
in
halimbawa,
our
may sabina na baka
discussion in our
sakali
caucus last week.
meron tayong makita.
Isa dun sa
Yun
napag-usapan
po
namin
ang ibig sabihin
precisely
ng
was
fishing expedition.
yung information
When the
na
party
lumabas
requesting
doon,
information does not know
kung yan ay
what
walang
might
basihan
be
na ilabas,
produced,
walang legal
and
basis
just
na
as an
ilabas yung
off chance
information,
tries to
hindi yan
use
pwedeng
that
idugtong
instrument in
dun
order
sa
to gain
mga allegations
that
na
may be
meron
used against the
kayo.
other
So that's
party.
my question.
Dito po, malaki ang pagkaiba ng sitwasyon.
During
Maalala
our
po
caucus,
ninyo,
isa din
during
sa
the
lumabas na
hearings before the
discussion,
Committee on Justice,
pero allowed
the Executive
ang
Director of the Anti-Money Laundering Council
AMLC
testified and produced documents
specific
showing
officers
that
to share that
from
information.
2007 up to the
But the
present,
specific provision of the law, and
6.7
please, both
billion
councils,
pesos ang
please
dumaan
respond,
po
please
sa account ni
elaborate
Vice
on how
President
this
Sara
supports or does not
Duterte.
support your case.
On that
A
basis,
specific
and if we
provision
go
dun sa-
deeper into that report,
sa
it says
batas,
that during the period from
yung sharing of
2007 to
information na yun,
2013,
sabi,
during the time that
kayo,
she served as
AMLC
mayor and
Council,
vice mayor,
mag-develop kayo ng
umabot po
rules
sa
kung
halos
paano kayo
walampas
makakapag-properly
3
share sa
piso ang dumaan
agencies.
sa kanyang mga
I believe,
accounts.
and again,
So may basehan po
feel free
tayo
to elaborate
para
on this or correct
ipalabas
me.
ang
That's
bank
referring
records.
to
We are not just
the bank
guessing
institutions,
that there is something
the
there
AMLC
because
hierarchy
the
and the
AMLA itself
the
has confirmed
agencies they
that
deal
there
with,
were
not
covered
in
and
court,
suspicious
because
transaction reports
ulitin ko,
submitted to
nakasulat
them
doon,
in those
confidential.
amounts
So,
that I
I will
mentioned.
leave this
Malayo po ang
here
fishing
that
expedition
if
sa
it is
ginagawa ng
confidential, it does
prosecution
not
dito po.
allow
If we had no basis
that
at all,
this be
if we did not know
divulged,
what
in
was
the
in the
manner it
AMLA
was
reports,
divulged,
ayun
then
po,
how do you
maaaring
use that?
sabihin
Because
na
that is
fishing
precisely
expedition.
the doctrine
But in this
of the
particular
fruit
case,
of the
we
poison tree.
know,
Please
because these are
take your
matters
time
of
to
record
tell us
presented
why
before the Committee on
that
Justice.
information is not the fruit of
Second
the poison
po,
tree.
ang
and
fishing
obviously,
expedition,
for the side of the
maaring
defense,
magamit
they
yan
will tell us
sa
why
ibang
they
mga
believe
alegasyon tulad
that
ng
it is the product of the fruit
baka
of the
meron
poison
kang hindi
tree.
na
Thank you,
declare
Mr.
sa iyong salin.
Counsel for the
But when it
panel of
comes
prosecutors
to
will please
issues of
respond.
unexplained wealth, Your Honor, it's
Section
very
8A
clear.
of the
The
Anti-Money
decisions of the
Laundering
court
Law
are very clear. It's really
to know
intended to whether a
prohibit
government
or
official
prevent
has
leaks
amassed
by
unexplained
officials
wealth.
of the
We
Anti-Money
must look
Laundering
at the
Council.
entire
But it was never
incumbency of
intended
that
to
official,
prevent
starting from day one.
subpoenas
We look at
coming
their
from
SALN, we
courts,
look at all the
including the
income
impeachment
that
court.
he or she has
Almost every
earned
week, the Sandigan
both
Bayan
lawful and
issues
not,
subpoenas
and from there we
for
make a
AMLA
determination
records,
whether
and
there was
despite
unexplained
what would
wealth
appear to
or
be
not.
a very
For these reasons, Your Honors,
categorical
the
prohibition
fishing expedition
contained in that
arguments in our
section
view
is totally
every
untenable.
time subpoenas are issued by the
Senator
Sandigan
Judge Pia,
Bayan, they are honored
you have further
by the
questions?
AMLA and no one is questioning them. Ganun din po itong impeachment court. The subpoena issued by this impeachment court is for the purpose of determining accountability based on the power that is expressly given
It's
by
actually
the
just a
Constitution.
follow-up to what
Ang aming pong paniwala is that
prosecution,
confidentiality
how the prosecution
cannot trump
responded.
accountability.
I think Senator Alan
Thank you.
Counsel for
Peter will
respondent.
go into it.
Thank you.
Since this is
Thank
my
you, Your Honor. I
line of
cannot
questioning, I'll follow up
verify
on
if
this
indeed
point.
the Sandigan Bayan, as mentioned
His
by
Honor,
opposing
I
counsel,
earlier
issues
mentioned
subpoenas
the
against AMLA
fruit of the
every
poison
week.
tree
So
doctrine.
that I will not
ulitin
comment
ko,
on because
pagka
I
yung
cannot verify that.
pinanggalingan
What
ng
is clear to us,
information
Your
nyo,
Honors,
bawal,
we have
hindi nyo na
demonstrated
pwedeng
last week,
gamitin yun.
is that
So,
8A is an
His Honor
absolute
said,
prohibition. And
I'm
again,
referring
this
to,
was the latest amendment of the law back in 2021. And for us, Your Honors, that is why when this
they
was
know
presented,
the contents
the
of
House
the AMLA report,
Committee on
something to that
Justice,
effect, because it was presented
we had
in
our
the
objections to
impeachment,
such matter. And
hearing
in fact,
in the
Your
House.
Honors,
That is correct,
it is
right?
the
That is your
subject of our
statement.
petition,
Yes,
the
oo.
Supreme Court,
And,
and aside from that, a subject of
I
our
asked my
motion for
question again. I will
exclusion
give both
before
parties
this honorable
opportunity
court.
to respond.
Ngayon po, sa
ano yung
atin,
basihan na
talagang yung
i-reveal
tinutumbok
ng,
natin is it is in
ng
fact within the fruit of the
AMLC
poisonous tree.
and their
In fact, I'm
representatives
surprised,
sa
Your
inyo
Honors, because,
in the
Your Honors,
impeachment hearing
na nabanggit
in
na
the
rin po
House.
ng aking
Because,
distinguished opposing counsel na
ang
nakita na
nakasaad
nila,
sa law, I don't
may
even want to
records na
use
sila.
my
In fact, if I'm
understanding
not
of the
mistaken,
law,
it was
because
also
it's what
attached
is
to the
read
articles of
in the law, and I
impeachment.
won't take up
So
the
kung meron
time
na pala,
of this
bakit
court
pa
na
nila
isa-isahin ko
pinapasapi
yun,
na ngayon
pero
sa impeachment court?
nakasulat
Is
doon
it
na
because,
confidential ito.
I don't want to speculate,
So,
maybe I
ano
just
yung
won't go there.
basis na
But ang
mailabas
sa akin
yun
lang po
dun
is,
sa impeachment
we have questioned
court?
this all
Because, and
throughout.
since the,
No, why Because
presiding
to us,
officer has given me
unang-una, bawal siya. Pangalawa,
permission
hindi siya
to-
relevant. Bakit hindi siya relevant?
share in
Your Honor's
general the
transactions
discussion
do not
in
equate to
our,
wealth. Transactions
discussion
do
in our
not
caucus
equate
last
to net
week.
worth.
isa dun
Especially
sa
if
napag-usapan
tinatali
namin
natin siya sa
precisely
SALN.
was
Because
yung
transactions
information na
happened
lumabas
over the
doon,
course of the year, and in this
kung yan
case,
ay
years.
walang basihan
But when
na
you talk
ilabas,
about
walang
SALN,
legal
we talk
basis
about
na
net
ilabas yung
worth on
information,
a specific
hindi yan pwedeng
date and
idugtong
time, which
dun
is
sa
December 31
mga
of every year.
allegations na meron
So sa
kayo.
atin
So
po,
that's
ang
my
aming
question.
pananaw dito ay hindi po relevant at hindi
And
po
during our
that it
caucus,
will
isa
not
din sa
directly
lumabas na
show
discussion,
anything about
pero
wealth.
allowed
Kasi
ang
again, AMLAC transactions
AMLC
do not
and
equate to net worth of a
the
certain
specific
person.
officers
And
to
that is
share
why,
that
Your Honors, we have
information.
opposed this.
But the
And,
specific
we have
provision
opposed
of
this
the law,
since the
and
time
please,
it was
both
being presented
counsels,
at the
please
House
respond,
level.
please
Thank you, Your Honor.
elaborate
Just
on
for the
how
record and
this
for the
supports or does
information of
not
the
support
Senator
your
Judges,
case.
I'm not sure about the
Ang
Sandigan Bayan
specific
issuing a
provision
subpoena
dun
every week
sa-
as well against
sa
AMLAC.
batas,
But I'm well aware, the court
yung
is well
sharing
aware of
of
cases
information
decided by
na
the
yun,
Supreme Court
sabi,
precisely
Oy,
on
kayo
subpoenas
AMLC
issued
Council,
by the Sandigan
mag-develop kayo
Bayan
ng rules kung
vis-a-vis
paano
the
kayo
AMLC.
makakapag-properly
Senator Judge
share
Pia,
sa
can you wind up?
agencies. I believe, and again,
You're done?
you feel free to
At this juncture,
elaborate on
Chair
this
will I
or correct me.
recognize Senator
That's
Judge
referring to,
Alan Cayetano
the
for
bank
his interjection and
institutions,
questions.
the
You may proceed, sir, when you're ready.
hierarchy and the
Before I ask question, Mr. Presiding
agency
Officer, may
stating
I
we have
thank
not
you,
import because ulitin
Senate
ko,
President Win
nakasulat doon,
Gatchalian, former
confidential.
Senate
So,
President Tito
I will
Soto, and
leave
the whole
this
court, because in
here
our caucus,
that if it
you
is
did three
confidential,
things.
it does
One,
not
you
allow
allowed us to
that
have the
this be
weekend to
divulged
review all
in
of
the
the laws
manner
so that
it
we can
was
ask more
divulged.
intelligent
Then how do you
questions.
use that? Because that is
Two,
precisely the
you
doctrine
allowed
of the fruit
to
of
hear the
poison
discussions,
tree.
mostly by Senator
Please
Pia,
take your
Senator
time to
Pangilinan,
tell us why
Senator Lacson, and Senator
that information is not the fruit of the
former
poison
Senator
tree.
Soto.
And
And
obviously,
then number
for
three,
the side of the defense, they will tell us why they believe
we
that
discussed
it
how
is the
a
product of the
complex-
fruit of the poison tree.
Or
Thank you.
what word did you use a while ago,
Counsel
Mr.
for the
Presiding Officer,
panel
that
of
it's two
prosecutors will
motions,
please
but
respond.
there are
There may be issues
Section 8A
underneath.
of the
issues and
anti-money laundering law
sub-issues. So,
is really intended
so
to
that
prohibit
after
or
we ask
prevent
questions and
leaks
after you make a
by
ruling,
officials of
we'll,
the
instead
Anti-Money
of
Laundering
asking
Council.
for
But it was
a division
never
of the House just in
intended
case
to
we do
prevent
not agree,
subpoenas coming from
I'll make a
courts,
manifestation,
including the
and then if
impeachment court.
others agree
Almost
on
every
how we
week,
can
the Sandigan Bayan issues
manifest or submit
subpoenas
in writing
for
in what parts of the ruling we agree
and
or
despite
disagree for the record.
what would appear
May I
to be a
proceed,
very
Mr.
Duly noted, Your Honor. You may
categorical
proceed, sir.
prohibition contained in
Good
that section,
afternoon,
every time
Attorney
subpoenas
Jokno
are
and
issued
Attorney Poa.
by the Sandigan Bayan, they are
So
honored
I really
by the
want to be
AMLAC, and no one
enlightened.
is
I have no
questioning them.
illusion na
Ganun din
magkakasundo
po
yung
itong
dalawang sides
impeachment
today
court.
because you have the
The subpoena
eloquent
issued by this
Attorney
impeachment
Jokno
court
on one side
is
and
for
the
the
eloquent
purpose of
no joke
determining
on
accountability
the
based on the
other
power
side.
that is
So sa pangalan
expressly
pa lang
given by the
baliktad na.
Constitution.
But I think the discussions are very important. And I do appreciate your opening, Congressman Jokno. I appreciate
Counsel for responding.
your
May
oral
reply.
arguments
Thank you, Your Honor.
because
I cannot
I've been
verify if
pondering
indeed the Sandigan Bayan
these questions. What if, hindi ko na sabihin this administration, let's say in future administration,
every week. So
this exact
that
thing
I will not
happens,
comment on because I cannot
5 years,
verify
3
that.
years,
What is
10
clear
years,
to us,
iba
Your
ang
Honors,
SALN,
we have
iba yung
demonstrated
income
last
ng
week
COA,
is that 8A is an absolute prohibition.
Chairman
and
or
again,
ng
this was the latest amendment
ombudsman
of
files
the
cases
law
sa
back
many
in
mukhang maraming
2021.
congressman makakasuhan
And for
ngayon.
us, Your Honors, that is
very,
why
very
when
much
this was
relevant
presented,
yung ating
the House
pinag-uusapan ngayon.
Committee on Justice,
just in the spirit of
we had our
liberality,
objections to
same
such
kay Senator
matter.
Pia,
And in
after
fact,
one
Your Honors,
answers, if
it
one
is the
wants to make
subject
a
of our
quick
petition
rebuttal,
to
I'll
the
ask you the
Supreme Court.
question, but
And aside from that,
let's
a
try to be
subject
concise.
of our motion for
Counsel, may I ask,
exclusion
let's
before this
start with the
honorable
case
court.
of Duterte versus
Ngayon
House of
po,
Representatives.
sa atin,
Thank you for reminding
talagang
us
yung
about
tinutumbok
certain
natin
precedents
is
and
it
how
is
I
in
voted
fact within
last
the
time.
fruit of the poisonous
But you would
tree.
agree,
In
diba,
fact,
that
I'm surprised, Your Honors, because
when you have
Your
legal
Honors,
proceedings, even in
nabanggit na rin
legislation,
po ng aking
you follow what the
distinguished
latest
opposing
law
counsel
is.
na nakita
So,
na
for
nila,
example,
may
if
records
you're
na
allowed
sila.
to issue
In fact, if I'm not
general
mistaken,
warrant
it
before
was also attached
Stonehill
to
versus
articles of
Jokno, but after
impeachment.
Stonehill
So kung
versus
meron na
Jokno,
pala,
so if
bakit pa
before
nila
Stonehill versus
pinapasabina
Jokno,
ngayon
walang
sa impeachment
doctrine
court?
of the
Is
fruit
it
of
because,
the poisonous tree,
I don't want to speculate,
then some
maybe I just
policemen will
won't go
still
there.
submit evidence
But ang sa akin lang
that
po
was illegally legally acquired.
We
But
have
after that,
questioned
we have to
this
follow.
all throughout.
So
No,
you
why?
did make your point
Because to
about
us, unang-una,
obiter
bawal
dictum.
siya.
I'll go to
Pangalawa,
that. But
hindi
I just
siya
wanna
relevant. Bakit
start
hindi
out
siya
by saying
relevant?
the
Your Honors,
fact is there
transactions
is
do
a
not equate to
Duterte
wealth.
versus House of
Transactions
Representatives.
do
So
not
with your
equate to
permission,
net
let's
worth.
start
especially
discussing
if
that.
tinatali
So
natin
this
siya sa
case of
SALN,
Duterte versus
because
House of
transactions
Representatives came
happen
out
over the course of the
after
year,
the
and in this
impeachment
case
of CJ
years.
Corona,
But
correct?
when you talk about
Yes, Your
SALN, we talk about
And
net worth
the-
on a specific date in time.
Two
which is
elements was
December
discussed in this
31
case.
of every
The
year.
act
So
charge
sa
must
atin
be
po, ang aming
impeachable
pananaw
under
dito ay
Article
hindi po
11,
relevant at hindi po
Paragraph
it
2 of the
will not
Constitution,
directly
and
show
2, the act
anything
committed
about
must
wealth.
be committed
Kasi,
during the
again,
term of the impeachable
AMLAC
officer. You commented on that.
transactions do
Can
not
you elaborate
equate to
or
net
give your
worth
stand
of a
regarding?
certain person.
I think you agree with letter
That is
A,
why,
right?
Your
That the
Honors,
charge
we have
must be an
opposed
impeachable
this,
offense.
and
we all
have
agree on
opposed
that,
this
right?
since the time
I
it
would
was being
distinguish, Your Honor,
presented
please,
at the House
between
level.
what we would
Thank you,
call
Your Honor.
ratio decidendi.
Just for the record and for the
or
information
rule
of
in
the
that
Senator
particular
Judges,
case,
I'm not sure
and
about this
arbiter
Indigan
dicta,
Bayan
which
issue
are
a
side
subpoena every
comments
week
or
as well against
incidental
AMLAC.
remarks
But
made
I'm
in
well
the
aware, the
opinion
court
of
is well
the
aware
court.
of cases
If we are
decided by the
speaking
Supreme
of the
Court
ratio
precisely
decidendi of the
on
Duterte versus
subpoenas
House of
issued by
Representatives
the
case,
Indigan Bayan
I would have to disagree
vis-a-vis the AMLC.
that it relates
Senator
to
George Pia,
the
can you wind
statements
up?
that you mentioned. My understanding of that
You're done?
case is it really relates to
At
the
this
first mode
juncture,
of
Chair would
impeachment
I recognize
and the
Senator
procedures
Judge
that must be followed,
Alan
the one-year
Cayetano for
ban
his
provided
interjection
in the
and questions. You may
Constitution,
proceed, sir,
how
when you're
that
ready.
will be applied.
Before I
When
ask questions,
impeachment
Mr.
complaints
Presiding
are filed
Officer,
by
may
at
I
least
thank
one-third
you,
of the members of the House of Representatives.
Senate President Win
Yung pong
Gatchalian,
nabanggit
former
nila
Senate President
that the basis
Tito
of any
Soto,
charge
and the
must
whole
relate
court,
to the
because in our
incumbency of
caucus,
the
you
official.
did three
In my
things.
view,
One,
that is obiter
you allowed
dicta,
us
not
to have
necessarily
I appreciate your
preemption
answer.
in the
We'll go
case.
to that.
Review
But
all of the
regardless
laws
of the
so that we can
Duterte
ask more
versus House of
intelligent,
Representatives ruling, we do agree with letter A. Two,
the
the
act
act charge
charge
must be an impeachable offense.
To hear
under
the discussions,
articles
mostly by Senator
11,
Pia,
2 of
Senator
the Constitution.
I would
Senator
agree, but if
Lacson,
I may be
Senator,
allowed to just qualify
No, this is just a
that.
general, this is
Former
not a prop
Senator
question.
Soto, and
So,
then
diba,
number
so the
three,
officer has to be impeachable, and the acts we discussed should how a complex should be an impeachable
what word
offense.
did you
And
use
since
a
we
while
have
ago,
betrayal
Mr.
of public
Presiding
trust,
Officer,
that's
that
why
it's
it's
two
broad.
motions,
So this is
but
not a
there
prop question.
are-
This is just laying the
There may
sub.
be issues
But go
under
ahead
the
if you want to
issues
on
under
sub issues.
Yes,
So
the acts charged must
so that
constitute
after
an
we ask
impeachable
questions
offense.
and after you make a
And
ruling,
that
we'll
power to
instead
decide
of
what
asking
is an
for
impeachable offense
division
is
of the
lodged
House just in
exclusively
case
with
we
this
do not
honorable
agree.
court.
Okay. You
I'll make a
disagree
manifestation
that
and then if
part of
others
the rest
agree on how
Ratio
we can
Decidendi is the
manifest
act
or
must be
submit in
committed during the
writing
term
in
of the
what parts of
impeachable
the ruling we
officer.
agree or disagree for
Thank
the
you for
record.
bringing it up.
May I
up
proceed,
now,
Mr.
Duly
because
noted,
I
Your
think all
Honor. You may
throughout
proceed, sir.
the
Good
trial,
afternoon,
especially in
Attorney
the articles
Jokno and
where we
Attorney
will
Poe.
bring up acts before
So I
2022.
really want to be
This discussion,
enlightened.
I
I
have no illusion na magkakasundo yung dalawang side today
discussing
because we have
this,
the eloquent Attorney Jokno on one
it
side
will
and the
pass
eloquent
upon
no joke on the
whether
other
or
side.
not,
So sa pangalan pa lang,
including proof,
baliktad na.
like
But
bank records,
I think the
financial
discussions
documents,
are very important.
before her term
And
can
I do
be
appreciate
inquired
your
into.
opening, Congressman Jokno.
The
I
prosecution
appreciate
says it cannot,
I mean,
right?
your
Because
oral
you believe it's an
arguments
obiter
because
dictum.
I've been pondering.
I'm just restating
these
these questions.
questions. What if you believe
hindi ko
that
nasabihin this administration,
the statement
let's say in
that the
future
act must be committed
administrations,
during the term of the impeachable
this
officer,
exact thing happens,
is not the law of the
5
land.
years,
It's an
3
obiter
years, 10
dictum.
years, iba
In
ang
the first place,
SALN,
if Your Honor,
iba yung
please, that
income
was not
ng
the exact statement of the court. The court said the basis of the
chairman
charge
or ng
must relate to the
ombudsman.
incumbency
Ombudsman
of
files
the
cases about
impeachable
many
official,
maraming
which does
congressman
not rule
makakasuhan.
out the
Ngayon,
presentation
so
of evidence
very much
of acts or
relevant
omissions
yung
that
ating
occurred
pinag-uusapan
before
ngayon.
the
So,
person
just in
became
the
an
spirit of
impeachable
liberality,
offense.
same kay Senator Pia,
judicial
after
notice
one
of the-
answers,
as you
if one wants
said
to make
more
a quick
eloquently,
rebuttal,
and
I'll
correct
ask you
me
the
that,
question, but let's try to be
acts,
concise
during
so,
her term.
Counsel,
So,
may I ask,
can you
let's
define,
start with the case of
you defined this in
Duterte
your
versus
opening
House
statement,
of
but for the sake of this
Representatives.
discussion,
Thank
an
you for reminding
obiter
us
dictum is
about
what?
certain
It's a
precedents and
side
how I
comment, Your
voted
Honor, that
last
is not
time.
necessary for
But
the
you would
resolution
agree,
of
diba,
that
that
case.
yeah,
And
when
when
we
we
have
have
legal
it's a remark
proceedings,
made
or
or
even
opinion
in legislation,
expressed by
you
a
follow
judge
what
in a
the
decision
latest
upon
law
a
is.
cause. So,
For
for example,
by the way,
if you're allowed
that
to
is
issue
incidentally
general
or
warrant
unilaterally and not directly upon the versus Jokno, but after Stonehill versus Jokno, not necessarily so if before Stonehill versus Jokno, walang introduced doctrine of the fruit illustration, analogy, or argument, then some policemen will still submit evidence binding precedents. That was illegally just for the public and for all of us, we have to follow. So ang sinasabi, yes, you did make your point about decision, but that obiter dictum will go to that. Could be an obiter dictum, meaning start out by saying yung the fact is there is will bind us Duterte versus House of Representatives. So issuing your permission or admissibility, discussing that. But Are you aware of case of Villanueva versus House of Representatives, GR 142947, March 19, 2002? I won't take
Yes,
it
Your Honor.
against both of you if you do not dare. The thousands of cases, two elements was discussed in this case. The act charge must be impeachable under Article 11. The prosecution characterized the Constitution and two, the requirement that the basis of the charge during the term of the impeachable officer. You commented on that. Can you elaborate in relation to their office regarding during the current term of the impeachable officer? The charge must be an impeachable offense. We all agree on that, right?
Well, I would distinguish, Your Honor,
But
please,
in the
between
Court
what we
of
would
Appeals,
call ratio decidendi, or the
Villanueva
rule in that
versus
particular
Court of
case,
Appeals,
and obiter
in that case,
dicta,
the Supreme
which are
Court
side
held
comments or
an
incidental
adjudication
remarks
on any
made
point
in the
within
opinion
the
of the court.
issues
If we are
presented
speaking of
by
the
the
ratio
case cannot be
decidendi of
considered an
the Duterte
obiter
versus
dictum,
House of Representatives
even where
case,
the point
I would
is
have to
only
disagree
incidentally
that
involved.
it relates to
So we
the
agree if it's
statements that you
incidental,
mentioned.
pwedeng
My
obiter,
understanding
but
of
if
that
it's
case is it really
on point
relates to
within the
the
issues,
first mode of
sabi ng,
impeachment
Villanueva
and the
case, it is
procedures
not.
that must be
So
followed,
long as
the
it is
1-year
presented and
ban
decided in the
provided
regular
the
course of the
Constitution,
consideration of
how
the
that
case
will be applied
and led up to the
when
final
impeachment
conclusion,
complaints are filed by
or
at least
is a
one-third
statement
of the
as to the
members
matter of
of the
which
House of
decision is
Representatives.
predicated.
Yung pong
The court
nabanggit
added
nila
that
the
a point
basis of
expressly
any charge
decided
must
does not
relate
lose its
to the
value as a
incumbency
precedent
of the
because the
official.
disposition
In
of
my
the
view,
case
that is obiter
or might have been
dicta,
made on
not
some other
necessary
ground.
for the
Appreciate your
decision.
answer.
And
Will
that
go
where
to that.
a court
But
decides
regardless of the
several
Duterte
points,
versus House of Representatives
ruling,
we do agree with letter
having
A.
the status of
the
a
act
dictum,
charge must
and
be an
one point
impeachable
should not be
offense
denied
under
authority
Article 11
merely because
of the
another point
Constitution.
was and more
I would
dwelt
agree,
on
but
and
if
more
I may be
fully
allowed to
argued
just
and
qualify
considered.
No, this is just
that.
a general. This is not
So
a trap question.
going back to the
Sorry,
versus
so the
House
officer has to be
Representatives,
impeachable.
the requirement that an
and the
impeachable
act charge
be
should
committed in relation to their office
should be
and
an
during the
impeachable
current
offense.
term
And since you have betrayal of
was
public
not a
trust,
remark
that's quite broad. No. So
made
this is not
by
trap
the
question.
way.
It's just laying the
The
basis.
Supreme Court
But
and
go
the
ahead
bank
if you
laid
wanna
it
comment
down
on it.
as one of the
Yes, the
enumerated
acts
principles
charged
that
must
due process
constitute an
requires,
impeachable offense,
which is the
and
very
that
ground
power
on
to
which the
decide
ruling was
what is
predicated.
an impeachable offense
Even if the
is
court
lodged
also struck down the
exclusively with this honorable
2025
court.
impeachment
Okay.
complaint based
So,
on the one-year bar, so this is the
You
question.
disagree that
Is it
part
not,
of the
does
rest-
it not render the
ratio
due process
decidendi
requirement laid out in
is the act must
as
be
a
committed
mere
during the
obiter
term of the
dicta, or
impeachable officer?
because it's based on due
Thank you for
process,
bringing it up
regardless
now,
of the
because
mode
I think all throughout
of initiation, regardless of the mode
trial,
of how
especially
the
in
articles of impeachment
the
got
articles
here,
where we
isn't
will
due
bring up
process
acts
still a
before
requirement.
2022, this discussion will
If I may be recognized, Your
relevant,
Honor.
no?
Counsel for the panel of prosecutors
by
may respond.
discussing
Precisely,
this,
Your Honor. If a matter is within the issues
it will pass
resolved by the
upon
court, then it may not be
whether
considered
or not,
as obiter dicta.
including
but if we
proof
look at the decision
like bank
in the
records,
case of
financial
Duterte
documents,
versus House of Representatives,
before her term
ang
can be
mismong
inquired
nangyari po
into.
doon ay may naunang
The
dalawang
prosecution says it
complaints that
cannot,
were
right?
endorsed
Because
at
you
may
believe it's an
sumunod
obiter
na
dictum.
complaint filed by at least one-third of the members
I'm
of
just
the House.
restating.
At
You can say it in
yun
your
yung
words.
tinutukan
You
po
believe
ng ating
that
Supreme
the
Court.
statement
It was
that the act
in
must
that
be committed
context
during the term of
that
the
Supreme
impeachable
Court
officer
made pronouncements
is not
about
the law of the land.
one-year
It's an
bar,
obiter dictum.
and even about in the due first place, process. if Your Honor, please, at that no was not time the exact in statement that of case the court was
Okay,
it
the
ever
court
said the basis of the charge must relate
about the
to
mode
the
of
incumbency
impeachment
of
that is
the
involved in our
impeachable
case
official.
today.
Which
Ang
thus
pinag-uusapan
po
po
natin dito
the
ay
presentation of evidence
individual complaints
of acts
that were
omissions
then
that
referred
occurred
by the
before
House to the Committee on
the person
Justice, became an
So
by the
let's
committee,
take the
and then brought back to the
judicial
plenary,
notice
and
of the,
eventually
as you
umabot po dito
said
through
more
articles of
eloquently and
impeachment.
correctly
So
that
kahit may sinabi ang Supreme
the
Court
acts, no, during
about
her term.
impeachable
So can you
offenses
define,
in relation to
you define this in your
the
opening statement, but for the
charges,
sake of this discussion,
kami
an
po ay
obiter
naniniwala
dictum is
na
what?
hindi po yan
It's a side comment,
pumapasok
Your
o
Honor, that is not
sumasako
necessary
sa
for the
issues that were
resolution of that
decided
case.
in that case.
Yeah,
I'll not
and
argue with
I
you
agree with
because
that, and
that's
it's a
not my job
remark
here.
made
I'll
or
follow the
opinion
Pia Cayetano
expressed by a judge
style
in a
and
decision
move
upon
to
a
the
cause
defense.
But just
By
a
the
follow-up
way,
question on that. So I
that
respect
is
your belief on
incidentally
that,
or
but
collaterally
my
and
point
not
is
directly upon the question
the legal
before
principle
him,
of due process
or upon a point
applied
not
to that
necessarily
mode.
involved in the determination of the cause,
or
is it
introduced
not
by way
logical
of
that it's the same
illustration,
legal principle,
analogy, or
or even
argument
if
such
such
another
another
mode?
So such are not
First of all,
binding
if Your Honor,
precedents.
please,
Just for
when
the
we
public
speak of
and
due
for all of
process,
us.
of course,
diba?
there are
So ang
two types,
sinasabi, yes, there can be a
substantive
Supreme
and
Court.
procedural procedural due
decision.
process.
But
And
that
when we
part,
speak of substantive, we're
could
talking
be an
about
obiter
protections
dictum,
to
meaning
life, liberty, and
hindi yan yung
property.
doktrina
Wala naman
that
pong
will
ganun
bind
na
us in
issue po
making
dito sa atin
decisions,
because
whether it's
office
issuing the
is not a
subpoena or
property.
or
We're not talking about
admissibility.
the life or liberty
But are you aware of the
respondent.
Villanueva
Ang
versus Court of
pinag-uusapan po natin
Appeals,
dito kung due
GR
process ang
142947 March
ay
19, 2002.
simply
I won't take it
fundamental
against both of you if you do not dare.
And I do believe that
Thousands of
this proceeding
cases.
does require
It
fundamental fairness.
talks about what
but
is obiter
at the same
dictum.
time, it
Have you
does
passed
not
about on this,
require that
both
this
counsels?
court be hamstrung
so
in terms of
the prosecution
how to decide whether an
characterization of the
offense is
requirement that the
impeachable
basis
or
of the
not.
charge
That power is
must
exclusively
be
given
for
to this court
impeachable
at
acts or
dapat kayo
omissions
lang po
committed in relation
ang
to their
magdesisyon
office
at magpasya
during
kung
the
ano nga
current
ba yan.
term of the impeachable
when
officer.
we speak of
as an
what is an
obiter
impeachable
dictum.
offense, may kaugnayan po yan doon
But
sa
in the
nabanggit
Court of
ninyong
Appeals,
the basis of the charge must relate to
Villanueva
the
versus
incumbency.
Court of
Because
Appeals,
in our
in
view,
that case, the
that is
Supreme
really
Court
something
held
that each member
an
of this
adjudication
honorable
on any
court will
point
have to decide
within
when
the
the time
issues
comes.
later on presented by the case cannot be considered an obiter dictum. What, if ever, even where the point is only incidentally involved, or so we agree if it's incidental, pwedeng obiter. But my point is, if we're saying that in the issues, modes of initiation is by case, it is not. So long as it is presented and decided in the regular course of the consideration of the case
current term,
and led up to the final conclusion,
wouldn't it be illogical
or
if you
is a
use
statement
another
as to the
mode
matter of which the decision is
pwedeng
predicated?
hindi
The court
committed in
added
relation to their
that a
office
point
and during their
expressly
current
decided
term.
does not lose its
I don't
value
think
as
the
a
Supreme Court
precedent
would be
because the disposition of the
illogical
case is
in saying this
or
is
might
the
have been
principle
made
for
on
due
some other
process in
ground.
this
And that where
mode,
a court
but not in
decides
this
several
other
points,
mode.
none of such points
Even
can
if we
be
assume,
regarded
Your
as
Honor, that
having the
that
status
is
of a
not
dictum.
obiter.
And one point
The
should not be
statement that
denied
the basis
authority
of the charge must relate
merely because
to the
another point
incumbency of
was
the
and more
impeachable
dwelt
officer.
on and more
We
fully
submit
argued and
that
considered.
that still
So,
applies,
going
and
back
we
to
have
the Duterte
satisfied
versus House
that
of
test.
Representatives,
As I mentioned
the
in
requirement
my
that an
opening
impeachable
statement,
act
integrity
be committed in
cannot be
relation to their
divided. Hindi
office
po
and
pwedeng
during the
biyak-biyak
current
yan
term.
ang integridad.
So on that
Was not
point,
a remark
so
if
President,
by
by
the
the way,
Ombudsman,
the
a
Supreme Court
COA
and Bank
chair
laid it
who's,
down
let's
as
say,
one of the
60 years
enumerated
old, but he
principles
started
that
in
due
government
process
at 20
requires.
years old. He
Which
can be
is
impeached
the very
by something
ground on
he
which
done,
the
he's
ruling
done
was
when he was 20
predicated.
to 30.
Even if the
Not
court
only
also
on
struck
what
down
he's
the
done when he was
2025
already an
impeachment complaint
impeachable
based on the
officer.
one-year
If
bar,
we are
so this is
speaking
the
about
question.
unexplained wealth, Your
Is
Honor,
it not,
I have
does it
repeatedly
not
cited
render
the
the due
cases of the
process
Supreme
requirement
Court
laid
that
out in
provide
as a
that
mere
we must
obiter
look
dicta, or
from the
because
reckoning
it's based
of
on
the
due
first day of
process,
service of that
regardless
public
of the
official.
mode
Look at all the
of
income
initiation,
that person
regardless
has
of the
amassed
mode of how
and
the
determine whether it is
articles of
manifestly
impeachment got here,
disproportionate
isn't
to
due
the lawful
process still
income
a
that he has
requirement?
reported.
Yes, I agree in terms of holding that
If I may be
person.
recognized,
Yes,
Your Honor.
Counsel for
liable
the
and
panel of
accountable.
prosecutors may respond.
But what I'm saying is that,
Precisely, Your
let's say he
Honor.
was a counselor,
If a matter is
then he was
within
a
the
customs
issues resolved by the court,
customs
then it may not be
director, then he was
considered as
BAR,
obiter
then he's now
dicta.
COA.
But if we look at the decision in the case of
Isn't the
Duterte
remedy
versus House of
for all his
Representatives,
other positions
ang
that
mismong
weren't
nangyari po
impeachable
doon ay may
is through the
naunang
regular
dalawang
courts and
complaints that
regular,
were endorsed at may
case build-up,
sumunod
etc.
na
But
complaint
once you're
filed by
impeachable
at least
officer,
one-third of the members of the
you're
House.
being held accountable
At yun
during
yung
the term that you
tinutukan po
are,
ng
in
ating
fact,
Supreme
an
Court.
impeachable
It
officer
was in that
because
context
usually
that
when
the
you're an
Supreme
impeachable
Court made
officer, it's too hard
pronouncements
to
about the one-year
prosecute
bar
you
and even about
the
due
normal
process.
way.
At no
Isn't
time
that the logic
in that
there,
case
or you disagree,
was it
counsel?
ever I would have to respectfully disagree. Ang pinag-uusapan po natin kasi dito ay betrayal of public trust. And I think it's very clear that when we speak of betrayal of public trust, individual complaints we are looking at whether the public official is justice or unheard by the committee in service. And then brought back to the plenary and eventually umabot po dito through articles of impeachment. So kahit may sinabi ang Supreme Court about, I think that would have offenses in relation to on the court's decision, charges, that person should kami po ay naniniwala na hindi po yan fit pumapasok o sumasakop office sa issues that were decided.
With the permission of Senator Judge
I'll not argue with you because that's not my
Cayetano,
job
with your
here. I'll
indulgence,
follow
sir,
the Pia Cayetano
a request was
style and
conveyed to the
move to
presiding
the
officer,
defense. But just a follow-up question
to
on
declare
that.
a very
so I
brief
respect your
break.
belief on that. But my
This is
point
not a break for all of
the
us,
legal
but,
principle
a very
of
brief
due
break of
process
5
applied
minutes
to that mode.
so that
Is it not logical that it's the same
counsel
legal
may
principle on
answer
due
to the
process
call
even if
of
you use another mode?
nature.
First of all, if Your
That
Honors,
is the
please,
message
when we speak of
conveyed to
due
this
process, of course,
the
there
presiding
are
officer,
two types,
including Senator Judge
substantive and
Cayetano.
procedural
So Chair
due
declares a
process.
5-minute
And
break.
when
We shall
speak
resume
of
at
substantive, we're
4:05.
talking about protections to life, liberty, and property. Wala naman pong ganun na issue po dito sa atin because office is not a property. We're not talking about the life or liberty of the respondent. Ang pinag-uusapan po natin dito kung due process ang issue ay simply fundamental fairness. And I do believe that this proceeding does require fundamental fairness, but at the same time, it does not require that this court be hamstrung in terms of how to decide whether an offense is impeachable or not. That power is exclusively given to this court at dapat kayo lang po ang magdesisyon at magpasya kung ano nga ba yan. So when we speak of what is an impeachable offense, may kaugnayan po yan doon sa nabanggit ninyong the basis of the charge must relate to the incumbency because in our view, that is really something that each member of this honorable court will have to decide when the time comes.
Yeah, later on, I'll ask you that question, whether or not, what, if ever, can the Supreme Court decide or what of their pronouncements will be applicable to this court and that. But my point is, if we're saying that pag ang mode of initiation is by 1/3 na pumirma diretso at ang nakalagay doon committed in relation to their office during the current term, wouldn't it be illogical if you use another mode and pwedeng hindi committed in relation to their office and during their current term? I don't think the Supreme Court would be illogical in saying this is the principle for due process in this mode but not in this other mode.
Even if we assume, Your Honor, that that is not obiter, the statement that the basis of the charge must relate to the incumbency of the impeachable officer, we submit that that still applies and we have satisfied that test.
Okay.
As I mentioned in my opening statement, integrity cannot be divided. Hindi po pwedeng biyakin ang integridad.
So on that point, so if a president, an ombudsman, a COA chair who's let's say 60 years old but he started in government at 20 years old, he can be impeached by something he's done when he was 20 to 30, not only on what he's done when he was already an impeachable officer?
If we are speaking about unexplained wealth, Your Honor, I have repeatedly cited the cases of the Supreme Court that provide that we must look from the reckoning of the first day of service of that public official, look at all the income that person has amassed, and determine whether it is manifestly disproportionate to the lawful income that he has reported.
Yes, I agree in terms of holding that person liable and accountable. But what I'm saying is that, let's say he was a councilor, then he was a customs director, then he was BAR, then he's now COA. Isn't the remedy for all his other positions that weren't impeachable is through the regular courts and regular case build-up, etc. But once you're an impeachable officer, you're being held accountable during the term that you are, in fact, an impeachable officer because usually when you're an impeachable officer, it's too hard to prosecute you the normal way. Isn't that the logic there or you disagree, counsel?
I would have to respectfully disagree. Ang pinag-uusapan po natin kasi dito ay betrayal of public trust. And I think it's very clear that when we speak of betrayal of public trust, essentially we are looking at whether the public official is fit or unfit to continue in service. Kung siya po ay nakapag-amass ng unexplained wealth, nung siya ay vice mayor o mayor na umaabot sa bilyon-bilyones, I think that would have a very big impact on the court's decision whether that person should continue in office or whether they are fit to have that office.
Okay. As I said,
With the permission of Senator Judge Alan Cayetano, with your indulgence, sir, a request was conveyed to the presiding officer to declare a very brief break. This is not a break for all of us, but a very brief break of 5 minutes so that counsel may answer to the call of nature. That was the message conveyed to the presiding officer, including Senator Judge Cayetano. So Chair declares a 5-minute break. We shall resume at 4:05. Resumed. We shall resume the interventions of Senator Judge Alan Cayetano pertaining to the issue at hand on the twin requests for subpoena by the prosecution. You may proceed, Senator Judge Alan, when you're ready.
Sir, Presiding Officer, if I may start there, whether or not the defense, although they stated already in their opening statement, considers such statement in the Duterte case as obiter dictum, and I'd like to reiterate, it's very important that we all understand and come to our own conclusions, because many, many times during this trial, and even in the decision we'll have to make, this question will play a center, will be front and center. So may I ask Attorney Poa, do you think that statement was a obiter dictum?
As stated, Your Honors, thank you for the question. As stated last week, Your Honors, it is our position of the defense that that is not obiter dictum, precisely because, Your Honors, it is our theory that when the Supreme Court decided the case of Duterte versus HOR, the point that the one-year bar was triggered is precisely because there was a violation of due process. That's why, if you read the decision, Supreme Court, through the words of course, Senior Associate Justice Marvic Leonen, painstakingly discussed what due process is actually in an impeachment proceeding. And in fact, there was a line in that decision that says that they wanted to clarify the guidelines on impeachment proceedings. Further to that, Your Honor, hindi lang po sa decision, pero pati po doon sa binibigay na primer or summary ng Supreme Court bago nila ilabas yung buong decision, they enumerated the guidelines, which were around 7 points, if I'm not mistaken. And the 6th point is actually on what is an impeachable offense. And in fact, we have prepared copies of that primer for the senator judges, which we can distribute, so that makita po nyo na while ang effect ay na-trigger yung one-year bar, it was really due process that the Supreme Court was discussing in that case to guide. Yes.
Commission Counsel for Respondent, kindly submit that to the Clerk of Court.
Yes, Your Honor.
Thank you. You may proceed, sir.
So, while as I was saying, Your Honors, while yung ang end result is na-trigger yung one-year bar, and that's why void yung naging first round of impeachment, ang talagang pinag-uusapan ng Supreme Court dito is the observance of due process in every stage of the proceeding. And that is why it is very important na mapag-usapan natin na yung kasama doon is really kung ano ba talaga ang isang impeachable offense. At nakasulat doon, if I may quote, the basis of any charge must be for impeachable acts or omissions committed in relation to their office, meaning in relation to their impeachable office and during the current term of the impeachable officer. So that is why, Your Honors, it is the view of the defense na hindi po obiter lang itong pronouncement ng Supreme Court na to as to what constitutes as an impeachable offense.
Yes. I'm not texting. I got on my phone the Duterte versus House of Representatives because, of course, my follow-up questions was to get into the mind of the prosecution when to apply the Duterte case and when not to. So, but I'll still ask you the same question. So, what's more logical, that the due process requirement that the acts committed should have been on the term is also applied to the other modes or just to the one-third mode?
All modes of impeachment, Your Honor. That is our position. Kasi po, we would veer into absurdity, no? Na kung dun sa one-third mode tayo, ang impeachable offenses limited lang sa term, pero pagdating doon naman sa other mode, which dinaanan, admittedly, at yun ang dinaanan nitong current proceedings natin, mag-iiba ang definition ng impeachable offense. I do not see any logic on why there's a difference because an impeachable offense is an impeachable offense. So para po sa atin, that should apply. And in fact, the Supreme Court did not make a distinction
resume.
as to the guidelines that
We
it
shall
laid down in
resume
that
the
decision, Your Honor.
interventions of Senator Judge Alan Cayetano.
Yeah, so in the first
pertaining to the
page,
issue at hand on
sabi dito,
the twin
second,
request for
considering the
subpoena by
nature of the
prosecution.
offices and
You
the
may proceed,
institutions
Senator
that
Judge
are
Alan,
subject to
when you're ready.
impeachment, presiding officer, if in I may start effect, there,
its
whether
effect
or not
on the
independence of constitutional departments and although they stated already and its nature as a constitutional process, all legal issues involving impeachment proceedings are subject to judicial review. It's very important that we all understand when, who, and whether an impeachable officer may be removed and disqualified from trial, and even in the decision will have to make. Duty to construe and this question process mandated by the Constitution will play a center. So is this for you? Will be front and center. So may I ask part of the rash decidendi, or is this? Do you think that statement was
Ratio, Your Honors. In fact, that's why the Supreme Court, when it started the decision, said that the Honors does not justify the means, of the defense, because it was precisely discussing the means. Ano ba yung precisely because, Your Honors, it is our theory that
so since
when
we're
the
talking
Supreme
about
Court
subpoenas,
decided
we'll go
the
to that
case
and
Duterte versus HOR,
With the permission of Senator Judge Allen,
the point
I would just
that
like
the
to get
one-year bar was triggered
assent of the counsel
precisely because
from
there
the
was a
panel of
violation
prosecutors.
of due process.
The documents ought to be
That's why
distributed
if you
by
read
the counsel
decision,
correspondent.
Supreme Court,
Is a
through the
July
words of
25,
course,
2025,
Senior Associate Justice Marvic Leonen,
discussion on the
painstakingly
Duterte v.
discussed
HOR
what due
on the
process
one-year
is
bar,
actually in an impeachment proceeding.
rule.
And in fact,
Again, it's dated.
there was a line in that
last
decision
year.
that says that
With the permission
they
of the
wanted to
prosecution, we shall
clarify
distribute it
the
without
guidelines
prejudice to
on
the
impeachment
counsel
proceedings.
for the panel of
Further to
prosecutors
that,
to
Your
also
Honor, hindi lang po sa
furnish
decision, pero
whenever
pati
it
po
shall so
dun sa
desire, because
binibigay na
this
primer
issue was
or
pointed out by
summary
Senator
ng
Judge
Supreme
Cayetano
Court
will
bago
linger
nila ilabas
until the end of the
yung buong
proceedings without
decision.
prejudice to the
They
counsel from the panel of
enumerated
prosecutors
the
to so furnish
guidelines,
also
which was around,
Senator
around
judges
7 points, if
with
I'm not
their
mistaken.
rejoinder
And the 6th
to
point
this document
is actually
being furnished
on
to the
what
senator,
is an impeachable
judges.
offense.
Is that okay?
Your Honor, I believe
In
that,
fact, we have prepared
first of all, may we
copies of
request
that
for a
primer
copy of
for
that,
the
document.
senator judges,
I
which
believe
we
that
can
document
distribute
refers to
so that
the
makita po
practice of
nyo
the spokesperson
na
of the
while
Supreme Court.
ang effect
In which case, Your Honor, we
ay
would have to
na-trigger yung
interpose an
one-year
objection.
bar,
Because any
it was really due
interpretation
process that the
by
Supreme
office
Court
of
was
the
discussing
spokesperson is
in
not
that
binding
case
on the
to
Supreme
guide.
Court. What we
Yes,
must look at are
counsel
the
correspondent.
actual
Kindly
text
submit that to the clerk
of
of
the
court.
decision.
Well,
Yes,
counsel,
Your
you
Honors.
can say that in your rejoinder.
So,
point that out in
while
your rejoinder,
as I was
and,
saying, Your
point
Honors,
that out
while
in,
yung
your
ang end result
submission.
is na-trigger yung one-year
So
bar,
ordered.
and that's why void
Clerk of Court is
yung
directed to
naging
kindly
first
distribute the
round
copies
of,
to the senator judges
impeachment.
without prejudice to
Ang
the
talagang
panel of
pinag-uusapan
prosecutors
ng
submitting
Supreme
a
Court
rejoinder
dito
to this
is the
document.
observance
Senator
of
Alan
due process
Senator Judge Alan
in every
Cayetano, you may
stage
proceed,
of
sir.
the proceedings.
Apologies for the interruption.
And that is why it is very
To be fair
important
to the-
na
I wouldn't have
mapag-usapan natin
objected
na
if
yung
you
kasama doon
objected to the
is really
distribution, but realistically,
kung ano
we
ba
won't have
talaga
time to
ang
read
isang
it because
impeachable
magruruling na
offense.
after.
At
So
nakasulat
it'll be
doon, if
more
I
of
may quote,
reference materials, but
the
feel free
basis
also
of any
to,
charge
if you
must
feel
be
that you
for
should,
impeachable acts or omissions
submit
committed
in writing a
in
rejoinder
relation
to
to
be fair
their
to everyone.
office.
So,
Meaning
if
in
the voting
relation
was
to their
tomorrow, and it would
impeachable
be
office
unfair to
and during the
distribute it.
current term of the
So,
impeachable
can I ask the same
officer.
question,
So that is why,
Congressman?
Your Honors,
So,
is the view of the defense
I read,
na hindi
it's the
po
first
obiter
few paragraphs,
lang
no?
itong
sabi
pronouncement ng
kasi
Supreme
dito,
Court na to as to what
you heard me naman, no,
constitutes
when you want me
as
to
an
read it again, no?
impeachable offense.
If I may be allowed to respond already to the
I'm not
question.
texting.
First of all, Your Honor, I
It
think
got
we
on my
must
phone
point
the
out
Duterte versus House
one
of
of the
Representatives
plainest
because,
reasons why
of course, my follow-up
that
questions was
statement
to
in the Duterte
get into the
ruling
mind of the
is
prosecution
obiter
when to
dictum.
apply
And
the
that
Duterte
simply is
case
because
and
there
when
was
not
no
to.
trial
But
yet
I'll still
to
ask you the
speak
same
of when the Supreme
question.
Court
So
rendered
is it-
that decision.
what's more
Paano po
logical
magiging
that
issue
the
yung
due process
nangyayari
requirement
ngayon sa trial,
that,
samantalang nung dinesisyonan po yan, ay wala pa pong trial.
that
Therefore,
the acts
any
committed should have been on
statements
the
by the
term
court
is
about
also
how the
applied to the
trial
other modes or
should
just to
be
the one-third
conducted
mode?
are
All modes
outside
of
the
impeachment,
issues of
Your Honor. That is
case.
our position.
And
Kasi
while
po,
they may be
we would
guidelines,
veer
they are
into
not
absurdity,
binding
no? Na
as
kung dun sa
judicial
one-third mode
precedent,
tayo, ang
to us and
impeachable
to the
offenses
future
limited lang sa term, pero
Actually, I was
pagdating doon
referring
naman
to
sa
a
other
different
mode,
matter already,
which
but just to that point,
admittedly, at yun ang
it's not
dinaanan
how, it's
nitong
what.
current proceedings natin,
It's
mag-iiba
paragraph 6.
ang
The basis of
definition
the
ng
charge must
impeachable
be
offense.
for impeachable
I
acts
do
or
not see any
omissions
logic on why
committed in
there's a
relation to
difference
their
because an
office and
impeachable
during the
offense is
current
an
term
impeachable offense.
of the impeachable
So,
officer.
para po sa
For
atin,
the President and
that
Vice
should apply.
President,
And in
this
fact, the
act
Supreme
must be
Court did not
sufficiently
make a
grave,
distinction as to the
amounting to
guidelines that it laid down
the
in that
crimes
decision, Your Honor.
described in Article 11 Section 3.1 of betrayal of public trust given by the majority of the electorate. Sabi dito, second, considering the nature of the officers and the acts must be sufficiently grave that they undermine and outweigh its effect, the respect for the constitutional departments and autonomy. So this doesn't really tell us how to conduct the trial. All legal issues involving impeachment proceedings are subject to judicial review. While the court does not determine when, who, and whether an impeachable officer may be removed and disqualified from political office. We've gone through that it has argument, and I won't argue with both of you. Going back to process mandated by the Constitution. So second, considering the nature of the offices and the institutions that are subject to impeachment, it affects on independence of
Your Honors.
constitutional
In fact,
department
that's
and
why the
organs,
complete
and its
Supreme Court, when it
nature as a
started the
constitutional
decision, said
process,
that
all
the end
legal
does
issues
not
involving
justify the
impeachment
means,
proceedings
no?
are
Because
subject
it was
to judicial
precisely
review.
discussing
I'll stop
the
there.
means. Ano ba
Kasi
yung
nabanggit mo
dapat
kanina,
natin sinusunod na
may I speak
proseso?
English Filipino. So since we're talking about subpoenas, we'll go to the end
That's
for us to justify to decide.
With the permission of Senator Judge Allen,
My interpretation, and
I
I
would
felt
just like to
that
get the
many times, di ba, na zealous
assent of
dapat
the counsel for the
impeachment
panel of
court sa powers
prosecutors.
niya kasi
The document sought to be distributed by the counsel correspondent is a July 25, 2025
apologize to Senator
discussion
Judge Risa, my
on
phone
the Duterte
fell.
v. HOR
wala nga tong,
on the
you
one-year
cannot
bar
appeal the decision of
rule.
my belief, no?
Again,
You
it's
cannot,
stated
appeal the
last
decision
year.
of
With the permission of the
to acquit or
prosecution,
to
we shall
convict,
distribute it
to the
without
Supreme Court,
prejudice to
diba?
the counsel
But the
for the panel of
parameters,
prosecutors to also
so
furnish
let me use the words
whenever
of
it
the
shall
Supreme
so
Court,
desire,
no?
because
Ang
this
sabi
issue was
niya,
pointed out by Senator Judge Cayetano Willinger until the end of the
all
proceedings, without
legal
prejudice to the
issues
counsel from the
involving
panel of prosecutors
impeachment
to so
proceedings
furnish
are
also
subject to judicial
Senator
review.
judges with their
You disagree with
rejoinder
this or you agree?
to this
In
document
context ng sinabi
being
mo
furnished
kanina
to
na
the senator,
it's within our
judges.
power to
Is that
make
okay?
this decision.
Your Honor, I believe
what is the
first of all,
controlling
may we request for
decisions
a copy
there,
of
Your
that,
Honor, are the cases
document.
of
I believe that document refers to
and
the
Francisco.
office of the spokesperson.
Because in those cases,
the
the
issue of
Supreme
what
Court
is an impeachable
in which case, Your
offense
Honor, we
was
would have to
squarely
interpose
brought
an objection
before the court,
because
and the court said very clearly that
by
is
the
purely a
office of the
political
spokesperson,
question,
that's
binding
not
on the
within
Supreme
the
Court.
judicial power
What we
for
must
us to
look
decide
at are the
and I
actual
believe that
text
that should
of the
be
decision.
Well, counsel, you can say that in
So
your
let me be
rejoinder.
more specific. So for example,
Point that out in
we
your
issue some
rejoinder
subpoenas
and
and
point
we
that out in
do not issue some.
your
Can
submission.
one or both of
We
you,
will do that,
meaning
Your
the
Honor.
prosecution
So
and
ordered,
defense, go to the Supreme
Clerk
Court
of Court
and
is directed to
question
kindly distribute the
Well, there
copies
is
to the
always
Senator
the
judges
possibility
without
that,
prejudice to the
some
panel
side,
of
perhaps the
prosecutors
defense,
submitting
may
a
claim
rejoinder to
that,
this document.
there's a great
Senator
abuse of
Alan,
discretion, I
Senator
believe, as
Judge
they have
Alan
done in
Cayetano, you may
other
proceed, sir.
petitions.
Apologies for the
and,
interruption.
Presiding
And therefore
officer,
make an
to
attempt
be fair
to,
to the, I wouldn't have
stop the
objected if you
proceedings before
objected
this
to
court.
the distribution,
But as
but
I have said,
realistically we
last
won't
week,
have time
Your
to
Honor,
read it because magruruling
in our
na us.
opinion,
So it'll be more of
this court
reference
has the
materials,
sole and
but feel free
exclusive
also
power to
if you
decide
feel
what
that
an
we should,
impeachable offense is. And
submit
no one, not
in
even the
writing a
Supreme
rejoinder
Court, can
to be fair
dictate
to everyone.
on this
So
court
if the
in
voting
making
was
that decision.
tomorrow, and it would be unfair
Same
to
answer.
distribute it.
No,
So
Your Honor.
can I ask the
I
same
have a
question,
different-
Congressman? Okay, you can go back to that question. Then my follow-up
I
question
read,
was, it's the
so
first, let's say,
few
certain
paragraphs,
orders
no?
of the court. Can
sabi kasi
the prosecution
dito,
or defense go up to the Supreme
you heard me
Court
naman,
and
no?
question its
You want me to read it again?
constitutionality?
Yes, Your Honor.
If I may
It is our
be allowed to
position
respond
that
already to
either
that
the parties can do
question.
that.
Well,
Why?
first of all,
Because
Your Honor, I
sa
think we
atin
must
nga,
point
sabi
out
natin kanina,
one of
that
the
the
plainest
Constitution cannot
reasons
be
why
read in
that
isolation.
statement
So
in
while
the
the
Duterte
Constitution
ruling
gives
is
the sole
obiter
power
dictum.
to the Senate,
And that simply is
try an
because there was no
impeachment case,
trial
to try and
yet
hear an
to
impeachment
speak
case,
of
we must
when the
read this in
Supreme Court
conjunction
rendered
with,
that decision.
again, Article
Paano
3,
po
Bill of
magiging
Rights,
issue
and Article 8,
yung nangyayari ngayon
specifically
sa
Section
trial,
1, which is the
samantalang
power
nung
of judicial
dinesisyonan
review.
po yan, ay
pag
wala
sa
pa
tingin po
pong
ng isang
trial.
panig, merong grave abuse
Therefore,
of
any
discretion na naganap,
statements by the court
we are of the
about
position
how
that
the
in
trial
fact this is a
should be
justiciable issue
conducted
and can be brought
are
before the
outside
Supreme
the
Court. Your
issues
Honor.
of that case.
So at least in
And while
that
they
small
may be
point, I think
guidelines,
we-
they are not binding
We all agree
as
that
judicial
if we think there's
precedent
grave abuse of discretion,
to us and to
there's
the
a
future
possibility
generations.
that the Supreme Court will take
Actually,
it
I
up.
was referring
Not
to
referring
a
to
different
any
matter
I'm not
already,
referring
but
to just to
subpoena
that
and
point.
talking
in general.
It's not
So I'll
how,
skip
it's what.
a few pages of my
It's
question
paragraph
6.
precisely
the basis
because
of
I
the
wanted
charge
to
must be
elicit
for impeachable acts your opinions or your omissions regarding in relation to their office and during the current term is supreme, but it's not true that we can do anything for the president and vice president. These acts must be sufficiently grave based on amounting to the crimes described in Article 11, Section 3(1) of betrayal of public trust given by the majority of the foreign accounts or the dollar. For the other impeachable officers, the acts must be sufficiently grave that they undermine and outweigh the respect for their constitutional independence and autonomy. So this doesn't really tell us how to conduct the trial. This basically tells us is that if we don't follow that, we're endangered of course we know because of having a trial that's void waiver na lang si Chief Justice
I would have to respectfully disagree.
So can I go
Your
now
Honor?
to the ultimate we've gone through that argument and I won't argue with both of you. Going back to the Senator Joel, but Senator Pia asked a little bit. Second, considering the nature of the offices and the institutions just a quick review or maybe effects on independence of we're also governed by the rules of court when it comes to nature as a constitutional process. All legal issues involving in general, every pleading shall contain in a methodological and logical form plain, concise, and direct statement of the ultimate facts, English Filipino, including the evidence on which the party relies on his or her claim of defense, as the case may be. My interpretation and our defense relied on is many times the pertinent provisions thereof and their applicability to him or her will be clearly not only because it's sui generis, stated. So does the two councils agree that sa ultimate facts, you have to include the evidence? Apologize to Senator Judge Risa, my phone.
I would make a distinction, Your Honor, between what we call ultimate facts and evidentiary facts, which are the pieces of evidence that could be used to come to the conclusion or to decide whether those ultimate facts are present in the case
Supreme
or not.
Court, diba? Yeah. But I think all of us lawyers agree with that. There's a difference between ultimate facts and evidentiary facts. But the rules of court says, ang sabi niya, including evidence. Kasi kung walang including evidence, all ang kailangan mo lang issues involving impeachment proceedings are subject to judicial evidence. I don't, you disagree with this, mean that every single, in context ng sinabi mo kanina na it's within our power to make this decision. But so let me go to my second question. So pwede bang sa articles of impeachment, ultimate facts lang, walang naka-attach na evidence?
Because in those cases, the issue of what is an impeachable offense was squarely brought before the courts. And the court said, look at the articles of impeachment, that is purely a political question that's not within the judicial power for us to decide. Actual allegations. And I believe that should be facts that are the controlling jurisprudence.
Thank you for that answer. Let me be more specific. So for example, we issue some subpoenas and you answered do not issue some. So with respect to the Sabalia and both of you, meaning the prosecution and defense, is it correct that there was no authentic records that were attached when they were filed?
Well, there is always the possibility that some side, perhaps the defense, may claim that if Your Honor, please, first of all, I believe as they have done in an issue with respect to and therefore make an attempt to is acting as an appellate proceedings before this court. What happened, as I have said last week, Your Honor, the power to initiate an impeachment has the sole and exclusive power to decide what an impeachable offense is, and no one, not even the Supreme Court, can dictate with this on this court. And I don't believe that it is part of the function to go back
Your Honor.
to what may have happened during
you can go back to that question. And my follow-up question was,
the articles have already
let's say
been
certain orders of the counsel, can even your the prosecution or defense go up to the Supreme Court, recognize that you are a brilliant man, you're
yes, Your Honor.
very well
it is our position that either of the parties can do that. Why? Because sa atin nga, sabi natin kanina, that the Constitution cannot be read in isolation.
So two of my colleagues started with
gives the sole power
your discussions
to the
fishing
Senate
expedition
try an impeachment case,
going down
to try and hear an
ultimate
impeachment
facts
case.
and
We
evidence.
must read this in conjunction
I wanted
with,
to distinguish
again, Article 3,
when is
Bill
it
of
a
Rights,
fishing
and Article 8,
expedition and when it's not. So I just wanted to
specifically
know as a
Section
fact.
1, which is the power
Or
of
can we take
judicial
judicial
review.
notice
So, pag sa tingin
that
po
there
ng
was
isang
no
panig, merong grave
authentic
abuse of
records
discretion na
in the
naganap,
Sabalia and
we are of the
Cabrera?
position that in fact, this is a justiciable issue and can be brought before the Supreme Court, Your Honor.
What's the point again,
So at
Senator,
least in
that there
that
were no
small point,
authentic?
it was just preliminary because I wanted to compare it with other impeachment complaints. And I wanted to ask the question. The Supreme Court will take it up. Not referring to any fishing expedition. I'm not referring to the subpoena. I'm talking these are legitimate questions. So I'll skip a few pages of my questions precisely because I wanted to elicit authentic your opinions or your stand regarding information ko the fact that the impeachment court is supreme, but it's
I
not
believe
true that we
Senator
can do
Judge Alan
anything
that the
or we can
Zabalia and
just
Cabrera complaints
make
were
decisions
attached
that are
as an
not based
annex,
on statutes
if
and on
I'm not mistaken,
legal
to
orders.
the
In fact, when
respondent's
the
answer.
Supreme Court
Would that be
issued
correct,
the
Attorney
TRO,
Cole?
and to be fair, it was
As well as the annexes.
foreign accounts
Yes,
or the
In
dollar
fact, the
account
presiding
in the
officer
Corona
noticed
case,
that it lacked
the
a page
impeachment
in one
court
of the
voted
annexes to
to
the,
respect the
I think, Zabalia
TRO,
complaint.
no? But
So,
of course,
which
we
we think pointed out. So that's a fact.
Yeah,
So it's in the
factual
record,
lang,
Senator Judge
factual
Alan.
lang po. So, in the absence of authentic supporting records, if we what factual basis did the prosecution rely on because of history to say that allegations were sufficient in form and substance? So can I go now to the
If I
ultimate
recall
facts?
correctly, Your Honor, please, there were some attachments to
I don't know if Senator Joel, but Senator Pia asked
and
a little bit about
I'm not aware
this.
of any rule in the House of Representatives as far as
just a quick
impeachment
review,
cases are
or maybe
concerned
so
that limit
we're also governed by the rules of
what
court
may
when
be
it comes to
discussed
ultimate
or
facts. This is what
investigated by the
Section 1
committee
says.
to only
In general,
what
every
is
pleading shall
contained
contain in a
and attached to the
methodological and
impeachment
logical
form.
I'm not questioning if there's an attachment. Plain, concise, and direct statement of the ultimate facts. I'm asking question. I'm not even questioning it. I'm asking on which the party relies on his or her claim of defense, as the case may be. If a cause of action or defense relied on is based on President pertinent provisions thereof, and their applicability to finding was the complaint failed to establish any factual nexus between the President and an impeachable offense. Does the two councils agree that what are presented were policy and disagreements and generalized accusations?
I would make a
not
distinction, Your
ultimate
Honor,
facts?
between what we call
Yun ang
ultimate
finding
facts
ng
and
Committee on
evidentiary
Justice.
facts, which are the
Correct.
pieces of evidence that could be used to come to the conclusion or to
Yes, sir.
decide
Okay,
whether
the
those
best of
ultimate
so,
facts
so that's my
are
question.
present in the case or
After
not.
answering that question, does the prosecution agree? All of us lawyers agree with that. There's a difference requirement between of alleging ultimate facts and evidentiary facts. Applies the rules of court to all impeachment complaints, regardless of it's the president or the vice president. Kasi kung walang including evidence, then ang kailangan mo lang i-file or the ultimate facts. Pero pag sinabing
Yes, Your Honor,
kasama
and as
ang
I recall,
evidence, I
when
don't-
the members of the
For me,
committee
it doesn't mean that
examined
every single
the complaint filed against the
testimony,
President,
every single
the
document
conclusion
should be
of the
attached,
committee
but-
was in fact that
So let
there
me go
were
to my
only
second question.
conclusions of
So
law
pwede bang sa
contained
articles of
in that,
impeachment,
complaint, not
ultimate facts lang,
allegations of
walang
ultimate facts.
naka-attach na evidence? In that complaint, there were
Ang requirement po sa
there
pleading
were,
ay doon na dapat nakasaad ang ultimate facts.
documents
But
attached,
if you look at the articles of
authentic
impeachment
records, and
that
the
are
House did
before
not
this
ask
court,
na masupina
it
yung
also contains
AMLA,
evidentiary factual
BIR
allegations
and,
to support
bank
the ultimate
records
facts that are
of the
contained
President.
therein.
Thank you for that answer.
The
Actually, that
requirement,
was
if
my
Your Honor,
next
please, of
question.
ultimate facts is
Did
really
it
based
contain,
on
and
what
you
is
answered it.
alleged in
So,
the
with respect to the Sabalia
petition
and
or complaint
Campera
itself.
what was the exact words is it correct that there was no authentic records that were attached when they were filed?
Confidential.
Hindi confidential. So why in the case of President Marcos is
If
the
Your Honor, please, first of all, I would have
confidential,
to
but in the case
raise
of,
an
Senate-
issue with
of Vice
respect
President
to
Sara,
whether
it's not
this honorable
confidential.
court is
Wala naman
acting
po
as
akong
an
maalalang ruling
appellate or
ng
review court
committee
of what in the case
happened
of the
during
President
the House
na meron
proceedings.
silang sinabing
The power of
confidential.
to
No,
initiate an
recall is
impeachment
that
complaint is
the
exclusively
conclusion was
lodged
that
with the
the
House,
complaint
while the
did
power
not
to try and
allege
decide
ultimate facts.
So there was a
impeachment
conclusion
case is exclusively
even before
lodged with
asking
this
for all
honorable
of this.
court.
But in this
And
case,
I don't believe that it is part of the
there was a
function
conclusion that there's
to
no nexus
go back to what
between
may have
the-
happened during the
President and an
proceedings
impeachable
before the
offense.
House.
In this
But if
case,
the articles have already been transmitted to
walang
this Honorable
counsel,
authentic
even your
documents,
students,
pero
colleagues, humihingi ng subpoena
recognize
that you are brilliant man, hindi confidential.
very well,
So, which goes to my well, first,
learned
let
sa
me
law.
honor who I should honor because
minsan
it
mabilis
seems that actually that's not where I was going. Linaliktad ko lang. So two of my colleagues started with or in your discussions, ano yung fishing expedition? ECT party list was here kanina and facts and evidentiary. Antonio Tino, I wanted to distinguish the last when is it a fishing expedition and when it's not. So I just wanted to know as a fact here. Or so can we take judicial notice? In their case kasi, there was no I can say walang selectives in the justice because they wanted the same standards of president and vice president. So that's my next question.
What's the point
We want
again,
fairness
Senator
for
Judge? There were
everyone.
no
It was
authentic.
Filipino people, it was just preliminary because I wanted to require 20 years of documents from AMLA, and I wanted to ask the question and bank accounts from when is it a fishing expedition requiring the same. So these are legitimate questions. Bongbong, considering that all of the scandals is happening during his administration. Yung Sabalia and Cabrera
if
ba
the
may
allegations
authentic
of the complaint
records
against the
attached?
President
ang information
in
ko
fact
wala.
contain
But
ultimate
I don't want
facts,
to...
I would see no reason
I
why the
believe,
Committee on
Senator
Justice
Judge
should
Alan,
not
that
have
the
proceeded
Zabalia and
with it.
Cabrera
So I'll take that
complaints
answer.
were
May I
attached
ask
as
the
an
same
annex,
question? Yes.
if I'm not mistaken, to
Rule
the
8,
respondent's
ultimate
answer.
facts,
Would that be
yes,
correct, Attorney
including
Bo?
evidence. And to be fair,
Yes,
it's
sir.
the answer of the
As well as the
prosecution was
annexes.
that basta
Yes,
may
sir.
evidentiary
In fact,
facts.
the presiding
But
officer
ang nakalagay
noticed
kasi
that
sa
it lacked a
Section 1
page
ng
in
Rule
one of
8,
the
including
annexes to
evidence.
the,
What is the
I
position
think,
of the...
Zabalia complaint.
So,
Which
anyway,
you think pointed out. So that's a fact.
defense
So it's in the
follows
record,
strictly
Senator
the rules
Judge
and
Factual lang
Alan.
po.
While
So,
I agree with
in
the
the absence
distinguished
of
opposing
authentic
counsel
supporting
na iba
record,
yung
what
ultimate
factual
facts and
basis did the
evidentiary facts.
prosecution
No? I
rely
don't want to
on
blur that line. Tama naman
to
po
say
yung
that
sinabi ng
allegations
ating
were
opposing.
sufficient in
But yun
form
nga
and
po yung
substance?
punto namin. No? In the
If
Zabalia
I recall
and Cabrera complaints,
correctly, Your Honor, please,
wala
there
pong
were some
ultimate facts at wala
attachments to
din
both
pong
complaints.
evidence.
And
Evidentiary
I'm not
na
aware of any rule
nakakalakip
in the
doon
House of
po sa mga
Representatives
complaints,
as far
and
as
which is the
impeachment cases are
very
concerned
issue
that
that we
limit
brought up to the Supreme Court, Your Honor.
what may
So
be
if you were
discussed or
representing now the
investigated by the
President
committee to
the
only
opposing
what
counsel
is
was also
contained
asking
and
for
attached
20
to
years
the
of
impeachment.
records. I'm not questioning if there's an attachment. I'm questioning whether there was... I'm asking question. I'm not even questioning it. I'm
Your
asking
Honors,
questions
on
that unless there were authentic records. So I'll move on. In the
relevant
complaint
and
against
definite,
President Bongbong Marcos,
I read in
the
your pleadings,
the finding was the complaint failed to establish any factual nexus between the President and an impeachable
why
offense.
is it definite
What
in your
are
view?
presented were
So,
policy and
on the first
disagreements
question,
and generalized
yes, Your Honor.
accusations,
Even if I were
not
to be
ultimate
representing the
facts.
President now, I
Yun
would
ang
have the
finding
same
ng
view, no?
Committee
Na
on
hindi po
Justice.
pwedeng ganun ka.
Correct.
20 years ang span ng mga documents na hiningi precisely because
Yes, Your Honor. To the best of my
jurisprudence
So,
provides
so that's
that
my
for a
question.
valid
Does,
subpoena to
after answering
issue,
that question, does
it
the
must be
prosecution
particularly
agree
described,
that
plus,
the
yung
requirement of
sinasabi po
alleging
natin na
ultimate
relevance. Now,
facts
to the second
applies
question as
equally
to
to all
why
impeachment
it is not
complaints,
particularly
regardless of
described,
it's the President or the
Your
Vice
Honors,
President,
unang-una,
regardless if
let's
it's
start
the
with the
Ombudsman
bank
or the
accounts.
COA
Yung bank
chairman.
accounts na
Yes, Your Honor, and
naka-enumerate
as I recall,
sa kanilang
when the
request,
members of
it
the
is our
committee
position
examined
na yun po
the
yung
complaint,
natawag kanina na
filed
fruit
against
of the
the
poisonous
President,
tree. Because
the
as you can
conclusion of
see,
the committee was
lahat
in
po ng
fact that
pinanggalingan
there
na
were
accounts na
only
yan ay yung
conclusions of
AMLAC.
law
But
contained
which
in
we are
that,
contesting. No?
complaint,
Sa amin
not
po, unlawful po yung
allegations
naging
of
disclosure
ultimate
sa
facts.
Committee on
Yet
Justice.
in that complaint,
But
there
more
were
importantly, pangalawa,
authentic
aside from just the mere bank accounts, the documents they're asking,
documents
Your Honors,
attached.
while they are
Authentic
specified,
records, and the House did
kung
not
titingnan
ask
mo
na
talaga ng
masubina
mabuti
yung
kung anong hinihingi nila,
AMLA,
they're asking for all bank
BIR
records
and,
without
bank
any
records
assertion
of
as
the
to
President.
why all of these are
The
relevant
requirement,
to
if Your Honor,
prove
please, of
whatever
ultimate
allegation
facts
they
is really based
have
on what
stated
is
in the articles
alleged
of
in
impeachment.
the
I'll skip
petition
many
or
questions
complaint
here.
itself.
But what was the exact words
Go
of
to that
counsel?
question,
Ang
but to be
katotohanan
fair,
ay hindi, Congressman Dioknos, you said,
confidential.
that's an exclusive, hindi confidential. So why in the case of President
Authority,
Marcos
right,
is the
power of the House.
katotohanan
So, if I want to
confidential, but
question
in the case
the
of
difference,
Senate,
I'll do that
of
in
Vice
either the
President
Senate
Sara,
or
it's not
as a private
confidential.
citizen,
So I won't
Wala
go
naman
into
po
that.
akong
But
maalalang ruling
I ask
ng
that now in
committee in the
context
case of
of,
the President na
whether or
meron
not
silang
the
sinabing confidential.
certain
What I recall
parameters
is
in the
that
subpoena
the
you're asking
conclusion
for,
was that the
is
complaint
valid or
did not
not.
allege.
Yes, so let me just go
facts.
to there was a
series of
conclusion
questions.
even before asking for all of this. But in this case, balikta, there's a conclusion that there's no nexus. This is really a discussion into what is substantial facts, what's ultimate facts, the President and an impeachable offense. In this case, and as you said, walang we don't authentic want documents bore everyone with that. Humihingi ng subpoena, it's important in terms of hindi confidential. So, which goes to my basically the ultimate facts honor who I should honor, because it seems that the charge in this case unexplained. Well, the Lisa Masa complaint. Let me put it this way in my question to Attorney and ACT party list was here kanina, and I think so. Like if I say that Antonio Tino, I think Sara Elago was here the last week, commissioner ng ganito or representative senator was here. So, ang SAL-ENIA was 1 peso. Their case kasi, I can say walang selective. SAL-ENIA was 1 million 20 years later, the same standard 20 million versus the commissioner of BIR. So that's my next question. We want fairness for everyone and for the Filipino people. To this congressman, would it be unfair? Then I said, to require 20 years of documents from AMLA, in your view, is that sufficient accounts from for the impeachment court Sara without requiring the same from President? Do you have to specify, considering that all of these scandals is happening during his administration? For example, you say that
If the
commissioner,
allegations
sa
of the
SAL-ENIA, he
complaint
only has
against
2
the
cars.
President
He actually
did
has more than
in
4.
fact contain
Therefore,
ultimate
paying
facts,
subpoena
I would
para
see
sa
no
LTO.
reason
O
why
that
the Commission
commissioner,
on
ang
Justice
sabi
should
niya,
not have proceeded with
isa
it.
lang ang bahay. So I'll take that answer. Pero supina sa LRA kasi apat ang nakita namin. Diba? Kasi on the later examples, ultimate facts, medyo mas malinaw yung, so the answer of the ultimate prosecution was that, pero yung sinabi mo lang, ito facts, but ang nakalagay kasi which was my point actually in my last what is the position just because tumaas yung defense on this.
The defense
Yung
follows strictly the rules, Your Honors. While I agree with the distinguished
but my
opposing
question there
counsel
was,
na iba yung
does that give us now the
ultimate facts and
authority
evidentiary facts, no? I don't want to blur that line.
get
Tama
the
naman
bank
po yung
accounts,
sinabi
the
ng ating
AMLA
opposing.
and the,
But yun nga po yung punto namin, no? In the
BIR, because
Sabaya
whatever we do in the
and Cabrera
impeachment court is
complaints,
for impeachable officers.
wala pong ultimate
But
facts at
nanonood
wala
din
din
yung
pong
Sandigan Bayan, nanonood din
evidence
ng
or
RTC,
evidentiary
MTC,
na
nanonood din yung Supreme Court.
nakakalakip
So
doon
whatever
po sa
rule
mga
we have
complaints,
here,
which
that
is
will
the
influence then how we
very
deal
issue
with
that
barangay
we brought up
captains
to the
all the
Supreme
way
Court, Your Honor.
So if you were representing now the president and
For
the
unexplained
opposing
wealth,
counsel was also
Your Honor, I
asking for
believe the
20
ultimate
years of
facts
records
must
of,
include the following.
AMLA bank
First,
accounts
that
and
the
BIR.
person involved
Would you still have the same
amassed
position?
wealth. Second,
Your
that
Honors,
that
I-
wealth
that-
is
that
manifestly
unless,
disproportionate
it is,
to that person's lawful income.
relevant
So kailangan po
and
natin
definite.
makita kung ano yung
I read
kanyang
in your
kayamanan
pleadings, diba,
at
and in
kailangan
your
natin
position paper
kumpara
na yun yung-
doon sa
So kasi
lehitimo niyang
I'll ask na rin my
kinita.
next question. Why
And
is
that
it
can be only
definite in your
determined
view?
by looking at the
So,
records
on
that
the
we
first
are requesting
question,
from
yes,
this
Your Honor.
honorable court.
Even if
No,
I were
but
to be representing
if you're
the
just looking
president
at the
now,
SAL
I would
and
have
at
the
yung
same
kinita
view,
niya.
no? Na hindi
So
po
I'll
pwedeng
give you
ganun ka.
a example.
20 years
I won't
ang
name the
span
person para
ng
walang
mga documents
mag-react.
na hiningi.
But
Precisely
he was
because
senator, I think, in
jurisprudence
1987,
provides
an
that for a
outstanding
valid
human being.
subpoena to issue,
And he was
it might-
telling us,
it must be particularly
etong lupa na
described,
to, nabili ko
plus,
ng
yung
1980 o
sinasabi po natin
1970 na
na relevance.
50,000.
Now, to the second question
Nabenta ko
as
ng
to why
1990.
it is not
Kaya lang
particularly
sa SALN,
described,
ang
Your
nakalagay
Honors,
kasi doon, yung
unang-una,
acquired cost.
let's start with the bank accounts.
So nilagay ko
Yung bank
50,000.
accounts
So kung
na
titignan mo kami,
naka-enumerate
then he
sa
named
kanilang
some
request,
great
it is our
other great
position
senators, etc.
na yun po
nakasabayan
yung
niya,
natawag
congressman
kanina
dito.
na fruit of the
Titignan mo si
poisonous
Senator
tree.
ganito,
Because
kami
as you
lahat.
can see,
O, ang
lahat po
SALN
ng
namin baka
pinanggalingan na
5
accounts
million.
na yan
Pero
ay
yung
AMLA.
100,000 na
But,
lupa na
which we
binili
are
namin nun,
contesting, no? Sa
baka
amin
5
po,
million,
unlawful
20
po yung
million,
naging
30 million. So if
disclosure
one
sa
of
Committee on
those
Justice.
officials
But more importantly,
suddenly
pangalawa,
sold the property
aside from just
and
the
then
mere bank
placed
accounts,
the
the documents
money
they're
that came
asking,
in.
Your Honors,
So let's say the
while
100,000
they are
property was sold
specified,
for 5 million.
kung titingnan mo
But
talaga
then,
ng
for
mabuti
example,
kung anong
pinang-blow
hinihingi
out
nila,
na sa pamilya
they're
yung
asking for all
500,000
bank
before
records
December 31
without
of that
any
year, mag-increase
assertion
yung
as to
kanyang
why all of
SALN by
these are
4.5
relevant to prove
million.
whatever
So if you just compare his
allegation they
income
have
na
stated
sweldo
in the
niya
articles
with
of
that,
impeachment.
that will not show
many
you
questions
that he has
here
still
and-
gotten
and
wealth. Go to that question, but to be
compared
fair,
na
pagka
Congressman
inallege ko
Diokno,
na
he said,
ang
that's an
sweldo niya
exclusive,
200,000, eto,
authority,
pero bakit
right,
may
power
bahay siya
of
sa
the
ganito,
House.
ganito,
So,
ganito, nawala
if I
sa
wanna
SALN
question
niya.
the difference,
So
I'll do that
I agree,
in either the
nasundan
Senate
natin yung
or
ebidensya.
as a
If the
private
SALN is
citizen, so
much
I
more
won't
than
go
what
into
you,
that.
what
I ask that now
you're
in
making,
context of
that could spark your
whether or not
curiosity, your
the
suspicion, and continue to
certain
investigate.
parameters
But do you make
in
the
the
conclusion
subpoena
now
you're
and
asking
file the
for,
impeachment
is valid
case
or
that
not? So let
since
me just go to this
malayo yung
series of
SALN sa income,
questions.
therefore ill-gotten yun, without giving that person a way to explain before you subpoena every single
This is really a
document
discussion
about their
into
lives.
what is substantial
That's
facts,
precisely
what's
why,
ultimate facts,
Your
what's
Honor,
essential
they call
facts,
it
what are
unexplained wealth. Doon po
and as
natin
you said,
malalaman
Attorney
yan
Powa, we don't
sa mga
want to-
dokumento.
No, I agree.
Kung-
everyone
kung
They call it
ipapalabas-
unexplained.
Go ahead,
It's
sorry,
important.
in
I'm
terms of
sorry,
due
I'm the one.
process.
Please
So,
continue.
Kung halimbawa sa
Basically,
binigay
diba, the
niyong
ultimate
example
facts
ay
are that
nag-appreciate
establish
yung
the charge,
value of
in
the
this
land,
case,
then I would
unexplained
not call that
wealth.
unexplained.
So
I would call that
let me put it
explained
this
wealth.
way in my question.
Yeah.
But you're introducing a new
To
concept
attorney
now,
and
unexplained wealth versus
Congressman,
ill-gotten
Prosecutor
wealth.
Joke.
I agree with you.
So, like, if I say
unexplained wealth
that,
is that if you look at the SALN,
may kilala
at hindi
akong
tumutugma,
politiko,
may
commissioner ng ganito
ano yan, may
or
unexplained wealth.
congressman,
That's why you ask them to
senator,
explain
whatever.
it.
Ang SALN
And then
niya
pag hindi
was
maganda
1
yung
peso,
explanation
what's-
and may
what's a
ebidensya
reasonable
ka,
amount?
then you can
was
go
1 million, 20
against
years
that person
later,
for
it's
ill-gotten wealth.
20 million versus
Diba?
the
But like
commissioner of BIR in 5
certain
years, it gained
parts here, I
50
saw
million.
some compared to this
that I would
congressman
consider,
nito,
even
then I
without
said,
asking you
eto lang
evidence,
income niya,
but for example,
unexplained
yung mga
wealth
kumpanya,
yan. in your view, sabi dito, lugi yung kumpanya. for the
So kung
impeachment
lugi yung
court and
kumpanya,
to issue the subpoenas, or
hindi
do you have to
makaka-contribute yun sa
specify
kanyang
na
ill-gotten wealth kung meron man. So why are we
for
getting
example,
all
you
the
say
documents
that
about those
commissioner,
companies?
sa salin niya,
Doon
he only had 2
pumapasok
cars,
yung
but he
criticism
actually
ng
has
iba.
more
Is this
than
a
4.
fishing expedition?
Therefore, paying subpoena
Kasi if I
para
had
sa
5
LTO,
companies,
o that commissioner,
and
ang
they were
sabi
all
niya,
making isa lang ang bahay,
money, and supposedly
pero
I only
subpoena
own
sa
1%
LRA
of that
kasi
company,
apat
but
ang
I'm
nakita
getting half
namin.
of that income.
Diba? Kasi on the,
I would agree with you, subpoena lahat yan.
Medyo mas malinaw yung, baka yan yung pumasok sa akin. Pero lugi nga yung mga
pag
kumpanya.
sinabi mo lang, eto
As an example,
eto tumaas,
so,
which was my
that's
point
my point.
actually in my
Is it enough
last
in the
few
view of the
vlogs that
prosecution
just because
panel just to allege
yung
malaki yung salin mo,
yung salin, that doesn't mean that there's
bigger
ill-gotten
than
wealth.
your monthly
But my
sweldo.
question there was, does
Both
that
of us
give
agree.
now the authority?
It's unexplained. But is
to
it ill-gotten? Or
get
do
the
you
bank
need more
accounts,
allegations
the
to show that
AMLA
it was
and the,
ill-gotten?
Your Honor, please,
BIR,
the
because
decision
whatever we do in the
whether
impeachment court is for
wealth is
impeachable
unexplained
officers.
or,
But nanonood
as you
din
said,
yung Sandigan
ill-gotten,
Bayan,
is really a
nanonood din
decision
ng
that this
RTC,
honorable court
MPC, nanonood
will
din yung
make
Supreme Court.
based on
So
the
whatever rule we
evidence.
have
Ang
here,
gusto
that
lang
will
po namin
influence
ay
then how we
mailatag ang
deal
ebidensya
with
sa
barangay
inyong
captains
harap
all the way to
para kayong na mismo ang
anyone who's
magsabi.
not impeachable.
At para malaman po yan ay we have
For
to look at
unexplained
the
wealth,
Your
statements
Honor,
of
I
assets,
believe the ultimate
liabilities, and
facts
net worth.
must
We
include
have to look
the
at the lawful
following.
income report
First,
that the person
ICRs
involved
we have to look at
wealth.
the bank records
Second,
that wealth
kung ano
is
yung pumasok at
manifestly
lumabas sa kanilang mga
disproportionate
accounts.
to
Let
that
me
person's
far as-
lawful
I'm sorry,
income.
Your Honor.
Yeah, go ahead,
So
Sir.
kailangan po
As
natin
far as
makita kung ano
businesses
yung kanyang kayamanan at
that
kailangan
has to
natin
do with the
ikumpara
third
doon
subcharge
sa
under
lehitimo niyang
unexplained wealth.
kinita.
Yung pong
And that can be
continuing to
only
participate
determined by
in
looking
business
at the
interests
records that we are
despite
requesting
the
from
clear
this honorable
and
court.
express
No,
prohibition
but
provided
if
in
you're
the
just looking at the
Constitution.
salin
We
at yung
want
kinita
to know
niya, so
whether
I'll
those
give you a
businesses,
sample. I won't
yung
name
ba
the
ay mga
person para walang
operational ba
mag-react.
ito? Ito ba
But
ay
he was
talagang,
senator, I think in
sasabihin
1987, an
natin na
outstanding human
nandun
being.
yung
And
sinasabi
he was
nga
telling us,
inaamin ni Vice
etong
President
lupa
sa
na to,
kanyang
nabili
salin
ko ng 1980 o
na business
1970 na
interest nga niya
50,000. Oh. Yeah. Nabenta
I'm
ko ng
skipping
1990
because this is mostly
kaya lang sa
questions
salin,
on fishing expedition.
Ang nakalagay kasi doon, yung acquired cost. I'll go to the
So,
dinilagay ko
after this,
50,000. Can you tell us
So,
the difference
titignan
between
mo kami,
evidence
then
and
name
proof? Some great, in your
other
layman's
great
term or
senators,
legal
etc.,
terms,
nakasabayan niya,
or,
congressman at dito.
Titignan mo, si Senator
if you wanna
ganito,
look it up,
kami, lahat. Ang salin namin, baka 5
how do you
billion.
explain to
Pero
people
yung
the difference between
100,000
evidence
na
and proof?
lupa na binili namin noon,
Napakabigat
baka
po
5
ng inyong
billion,
tanong.
20
I'll
billion.
try
In our words lang,
I will
one
try
of
my
the
best, Your
officials
Honor, to answer it.
suddenly sold the property
in a court
and then
proceeding, whether
placed
we're
the
speaking of an
money that came
impeachment court
in.
or a
So let's
regular
say the
court,
100,000 property was sold for
judges
5
look
million.
at the evidence.
But then, for example,
They may
pinang-blow up
never
niya sa
be able
pamilya
to
yung
know the entire
500,000
truth.
before December 31
Kasi ang
of that
pangyayari
year.
ay nangyari
Mag-i-increase
dati pa
yung
po.
kanyang salin by 4.5
Essentially, a trial is really
million.
a reconstruction
So if you just compare
of
his
something that
income,
happened before.
the sweldo niya
So
with that,
it may happen
that will not show you
in
that
some
he has
cases
ill-gotten wealth.
that there is enough evidence to make
So
conclusions
compared
as
na
far as the
pagka
judgment
inallege
is
ko na
concerned.
ang
Even
sweldo
if
niya
the
200,000,
members of the
eto,
court did not get to see
pero bakit may
the
bahay siya sa
entire
ganito, ganito,
truth.
ganito, nawala
Ang
sa
gusto po
salin
namin
niya.
maiwasan na dito
So
sa impeachment
I agree
court
na sundan natin
ay
yung ebidensya.
meron po tayong
If the salin
hindi
is much more than what
mailatag na
you,
ebidensya sa mga
you're
maestrado po
making,
na nandito
that
para
could
talagang
spark your
maging buo
curiosity,
yung
your
larawan nila
suspicion,
bago
and
po
continue
kayo
to
magpapasya.
investigate. I
But
don't
do you
think
make
there's
the
any
conclusion
question
now and file the
that
impeachment
all of us here
case that
want na mailatag yung ebidensya. The
malayo
question
yung salin
is,
sa income,
do you have the
therefore
evidence or are you
ill-gotten
fishing
yun?
for the evidence?
Without giving that person
And that's a question not
way
only
to
for you,
explain
but for
before you
every
subpoena
single
every
impeachment
single document about
process,
their lives.
not only the umabot
That's
dito,
precisely
because
why, Your
myself,
Honor,
Senator
they call
Subiri,
it
Senator
unexplained wealth. Doon po
Chis
natin
Escudero,
malalaman
then later
yan
on, Senator
sa mga
Villanueva has
dokumento.
been, I agree, in the
Ngayon,
House,
kung
they call it
naipaliwanag-
many times.
Go ahead, I'm sorry, Your
During
Honor.
I'm the
impeachment
of presidents and chief
continue.
justices.
Kung
no?
halimbawa
But
sa binigay niyong example
the reason I
ay
asked between evidence
nag-appreciate yung
and proof is
value
because
of the land,
if you have the,
then I would not call that
evidence, you
unexplained.
want
I would
the
call that explained
opportunity.
wealth.
Yes, diba?
But
to
you're introducing a new concept
bring
now,
it here,
unexplained wealth versus
show the
ill-gotten
relevancy.
wealth.
I agree with you.
To the
Unexplained
crime,
wealth is
we
that
admit
if you look
it,
at the
so that
salin,
if it's true, then
at
we can
hindi
convict.
tumutugma, may the opposite sides
ano
na
yan,
may
will will either question, that's why you ask them to explain it. Pero walang relationship yan, and then pag hindi maganda yung explanation, so what I'm saying is that if you're going to prove your case against that person for ill-gotten wealth, with no evidence, diba? But except that if you get all of that, certain parts here, I saw magiging arbitrary yung House of Representatives that I would consider even without asking you evidence. But for example, impeach yung mga kumpanya. Almost any public official who's been there for a long time. So kung lugi yung kumpanya, you will see discrepancies in their salary. Hindi makaka-contribute yun sa kanyang unang-una iba yung acquisition cost at so why are we getting all the documents about those current value at iba din yung deadline ng criticism ng iba? Is this a phishing December 31? No? Kasi if I had 5 companies, I'll ask the and they were all making go into the money and supposedly I only own 1% of that company but I'm getting half of that income. If you're I would agree with you, subpoena evidence already. Tignan natin yung flow niyan. Baka kinukuha mo yung subpoena na yan. Pero lugi nga yung mga kumpanya. As an example, I don't think there'll be a question there. That's my point. Is it enough in the view of the prosecution panel said kanina na just to allege kung yung BIR box na yan, alam natin salin mo, and bigger than your monthly sweldo, both of us agree, alam yung it's unexplained. Are we fishing there if there's a tax or do you need more allegations to show that it was illegal? I'm asking you the question.
Well,
you can answer
the
it in any way
decision
you're
whether
comfortable in answering.
wealth is unexplained or, as you said, narrate the procedure that this honorable the House will make to undergo based on the articles to reach ang gusto lang po namin ay mailatag ang ebidensya sa when the complaints were filed na mismo before the House of Representatives. At para malaman po yan, we have to look at the statements of assets liability trial net worth. We have to look at the lawful income reported but simply determining whether there was probable cause bank records in terms of kung ano yung pumasok at lumabas sa kanilang so hindi po namin hinalas yung kabuuan ng ebidensya dahil hindi po namin as far as the when we made the determination that there was sufficient probable charge under to proceed with that case, yung pong continuing to participate in business interest in terms of the articles of impeachment that reach and express prohibition provided in the Constitution. Siyempre po, we want to know preliminary investigation conducted by a prosecutor. Yung mga operational ba ito ba ay ebidensya, ang titingnan lang po niya ay sasabihin natin na nandun yung sinasabi nga na amin Vice President sa kanyang that prosecutor because wala pa po trial. The presentation of evidence,
I'm skipping
even the
subpoena
subpoena or compulsion to present evidence will only happen when the trial
I'll go
takes
to the defense after this. But can you tell us the difference between evidence and proof?
Yun ay
In
maaaring
your
sabihin
layman's
natin
term or
nangyari
legal terms?
kung
Or
only if the party
you wanna look it
requesting
up,
the evidence or
but
documents ay
how do we explain
nagbabakasakali
to
lang.
people the difference between
Baka
evidence and
may makuha tayo dito.
Napakabigat
In
po
our
ng
case,
inyong tanong.
I have to
in our
disagree
words
that
lang,
there was
para
an
may
fishing
Your
expedition because based on what the Committee on Justice and later the plenary of the House found or a regular sufficient, the judges look at the evidence to proceed with. They may never be able to know the entire truth. Kasi ang pangyayari ay
so anong
nangyari
makukuha
dati
natin
pa po.
if we grant all the subpoenas
Essentially, a trial is the evidentiary construction of something that happened
not
before. Yet, so hindi pa nakita ng House nung in some cases lang po namin that there is enough evidence to make conclusions
so,
as far as the judgment is concerned.
No, kasi you said
because there is basis for the court requesting for
so what will you see? You still don't know what you see.
Ang gusto po namin maiwasan natin sa impeachment for the bank records ay meron po tayong hindi mailatag na provided by the anti-money laundering council po na nandito appears to show that there were yung larawan nila that went through the accounts.
Okay. I don't think there's any question. Let's go to that. All of the permission of the defense then want na mailatag yung ebidensya. The question is, the anti-money laundering, have the evidence or are you fishing for the evidence? Council, no? And that's a question not only for you but for every single impeachment, right? Process. So pag sinabing billion, that doesn't mean that a certain official has billions in their account. So meaning if I have $1 million pesos deposit on January 1 in the House and then many times during on January 5, presidents and chief I take it out and put it in time deposit for 1 month. The reason I asked between 1 month later it comes out with is because 2% if you have time deposit. Hindi na 1 million yun. 1 million in opportunity. 1 million out, 2 million. 1 million in the time deposit, 3 million. Show the relevancy. Paglabas na may 2%, 1 million. We admit it so that if it's true, then we can convict. 2,000 pesos na 4 million na yun. Question, hindi admissible yan or admissible so, hindi pero walang relationship speculation sa so what I'm saying is that pera, meaning if you're going to prove all I have to do is find someone with a bank account and give them a long enough period and I will say that they have hundreds of millions or billions. Then magiging arbitrary yung House of Representatives. Sinong gusto nilang
because as you mentioned,
impeach
only
because
reports submitted
almost
by the
any public
Anti-Money
official
Laundering
who's been there for a
pertain
long
to
time,
covered and
you will see
suspicious
discrepancies
transaction
in their
reports.
SAL-N
They do not show
because
us the
unang-una iba
exact
yung acquisition cost at
balances
iba
that
yung
were contained
and
in those
suspicious
bank
current
accounts. And it
value
is
at
only
iba
the
din
bank
yung
records
deadline
that will
ng
provide that information.
December 31,
Agree. And it's
no?
suspicion,
Which
when you
after
say
this,
suspicion,
I'll
that
ask the defense to answer, then I'll
necessarily
go into
suspicion
the
that it's attached
AMLA,
to
which is
a
different from
AMLA
bank,
crime.
but it could be
bank
suspicious,
accounts, no?
meaning
So,
6 months walang
if
gumagalaw.
you're coming to the
biglang
court
every
with
day ngayon
evidence
gumalaw.
already,
Diba?
but yun yung
Kinukuha
definition
mo yung
ng
subpoena na yan,
part
diba,
ng
to
definition ng
further
AMLA.
prove your
But if you
your
cannot
point,
connect AMLA and the
I
bank
don't think
accounts,
there'll be a
that's
question
precisely
there.
what the defense
As,
and other people are saying.
Aren't yung
Attorney
fishing between
Poe
the
said
three?
kanina na kung yung BIR box
Fishing
na yan,
means
alam
hindi mo
natin yung
pahawak.
lawak,
So
and
you're trying to
dapat
get
gamitin dito.
a
They
fish. In this
inallege
case, a
na.
very big fish.
Pero kung hindi
Diba?
alam yung
So,
laman,
pag
pag sinabing hindi
there,
fishing
if there's a tax
expedition,
evasion or
meron
wala.
ka ng ebidensya.
I don't know the answer. I'm asking
but
you the
you want,
question.
you can answer
to
it
prove
in any
that
way
in court,
you're
and you
comfortable
need
in answering.
that to prove it, but you know
If
what
I
to
may
prove already.
briefly narrate the procedure, if we bring your honors
the House
had to undergo logic for the articles to reach this honorable court. That would mean that the Committee on Justice would have to conduct a full-blown trial before the House of Representatives. At that level, the Committee on Justice was tasked not when we get to this court a trial. When that is not the contemplation of the procedure for the evidence, but simply determining whether there was probable cause
with the
to
permission, with
proceed
the permission of the
with the
gentleman
case.
of the floor.
So hindi po namin
Senator
hinanap yung
Cayetano,
kabuuan ng ebidensya dahil hindi po namin
Thank you very much.
tungkulin yun. When
Senator
we made the
Escudero,
determination
myself, we
that
were in
there was
the
sufficient
Estrada and
probable
Arroyo
cause to proceed with that case,
impeachment. It's harder to
then
impeach a president
that
than a
is
vice
what we
president.
submitted in terms of the
But whether
articles
it
of
was
impeachment
accounts,
that
anong
reached
laman,
this honorable
property,
court.
kotse,
Ngayon,
we did our
syempre
homework.
po, just like
So
a
it's not my place to
preliminary
tell you you did
investigation
or not.
conducted by a
Kaya nga tinatanong
prosecutor,
ko, may
ang
ebidensya
hawak
ba
lang
o wala?
po
Or
niyang
is it a
ebidensya, ang
fishing
titingnan lang po
expedition
niya
or
ay
not? But
kung
as I
merong
said a while ago,
probable
I won't
cause.
argue.
Not
So I have
all
one
the
last question
evidence
after that, but
yet
I'll go
is
first to the
before that prosecutor because wala pa pong trial.
defense. In the
The
context of
presentation
what
of evidence,
what I asked,
even the
no.
subpoena
Between
or
those two
compulsion to
examples,
present
eto
evidence
SAL-N mo,
will
eto
only happen
income mo, malaki
when the
SAL-N mo.
trial
Oh.
takes place.
We can agree
And
it's
Yung
unexplained.
tinutukoy po
Kasi nga, you
ninyong
need to
fishing
explain it
expedition,
further. But
yun
is it
ay
automatically
maaaring
ill-gotten
sabihin
wealth?
natin nangyari
No, Your Honor.
kung
So if it's not
only
automatically
if
ill-gotten
the
wealth,
party requesting the evidence or
in
documents
your
ay
view, I mean, I read this from
nagbabakasakali
your,
lang. Baka
maybe
may
you can
makuha
just
tayo
restate,
dito.
why is it a fishing
In our case,
expedition?
I have to disagree
Your
that
Honor,
there was
because
any sort of
precisely,
fishing expedition
yun pong
because
sinasabi
based on
nila
what
na
the
unexplained
Committee on
wealth,
Justice and later the
they were
plenary of
basing
the
it
House
for 20
found
years, for one.
was sufficient.
Pangalawa, they
There
couldn't
was enough
pinpoint
cause
exactly
to proceed with the
I'll
case.
go to
nasabing
probable
may
cause, but you
unexplained.
sinabi
Alin
baka
dito sa
sakaling may
properties
makukuha
yung
dito.
unexplained?
You said hindi
Third,
ganon.
and
So
if I
ano
may
makukuha
elaborate
natin
from
if
our
we grant
memo.
all the subpoenas you're
If you look at the articles
The
of
evidentiary
impeachment, it
facts, Your
presupposes
Honor,
that the Vice
that
President
were
earned
not
30 million
yet,
over a span of 20
hindi pa
years.
nakita ng
Yet,
House nung
they did not
ang ginagawa lang
think
po namin
about the
ay
Vice President not
determinahin
being in
ang
public
probable
office
cause.
from
So,
2013
nagbabakasakali
to
din.
2016.
Hindi po.
No, kasi you
They
said
didn't
because
think
there
about
is
the
basis
income that
for
could have
requesting
been
for the
So what do you
generated by
see?
being
You
married
still
to a
don't know what
lawyer
you'll see.
who had his own law office.
We are
So,
basing
to
the
us,
request for the bank
it was
records
basically
on the
a conjecture,
evidence and information
speculation,
provided
conclusion
by
of
the
law and
Anti-Money
fact to say,
Laundering Council,
biglang, uy,
which
may unexplained wealth
appears to show
dito.
that there were billions
That's basically
of
our
pesos that
point.
went through
And
the
then
accounts
secondly,
of the Vice President.
the
during
decision
that
Let's go to
period.
that
earlier,
with the permission
it
of
was
the
mentioned
defense,
by
then I think
distinguished
you're
opposing
listing down
counsel.
naman.
Decision
So the
rests
anti-money
upon this court
laundering
to determine kung meron ng unexplained
council,
wealth.
no?
I disagree
does not
with that.
deal with
The
income,
ultimate
they deal with
decision
flow,
rests
right?
upon this court. That is
So
true.
pag sinabing billion,
But the
that
initial
doesn't mean that
decision
a certain
rests with the
official
person
has billions in their
accusing,
account.
di ba?
So meaning if I have
Pero
a
nung
million
accused
pesos
yung tao sa
deposit on
Sabalian
January
Cabrera
1,
complaints, wala
and
man
then,
lang nakasulat po doon. Kanina
on
na-mention
January
po
5,
yung should
I take it out and put it in
Committee on
time
Justice
deposit
now
for 1
conduct a
month.
full-blown
And
trial.
1 month later, it
shouldn't.
comes out
It
with
should just evaluate
2%
the
time
complaint.
deposit.
Para nga pong
Hindi na
fiscal,
1 million
parang
yun. 1
preliminary
million
investigation.
in,
Pag
1
tayo po
million
pumunta sa
out,
fiscal,
2 million, 1 million in the
at ang
time
dala lang natin
deposit,
doon
3
ay puro
million.
paratang. Wala man naman lang
maglabas na may
supporting
2%,
document.
1
What will the fiscal
million,
do? Dismiss the
2
case
pesos,
outright.
1 million,
Yan naman po ang totoo.
2,000 pesos,
So that
4
was our
million
point
na
to
yun.
begin with. And that is why we're saying
So, hindi
fishing
evidentiary yun,
expedition
speculation
ito.
sa-
Kasi
sa
hindi mo
ikot
man lang
ng
mapinpoint
pera. Meaning,
kung anong
all
transaction
I have to do
sinasabi
is
mong
find
nag-amas
someone with a
ang
bank
Vice
account
President natin.
and give them a
Anong
long
taon
enough
na
period,
nag-amas
and
ang
I will
Vice
say that
President
they have
natin ng
hundreds of
ill-gotten
millions or
wealth or
billions.
unexplained wealth?
Precisely, Your
dahil
Honor,
doon
that is why
ngayon,
we want
we're
the
asking
bank
for
records
records
to be
spanning 20
produced.
years,
Because,
both
as you mentioned,
BIR records,
the only
bank
reports
records,
submitted by
AMLAC
the
records, which they
Anti-Money
already
Laundering
have,
Council
actually,
pertain to covered and
from the
suspicious
Committee on
transaction
Justice. Pero
reports. They do
hindi
not
natin
show
ma-pinpoint
us
alin
the
ba talaga
exact
dito. We cannot
balances
specify
that
kung
were
ano yung act,
contained
And
ano yung
those bank
omission na
accounts.
ginawa
And it
niya
is
na
only the bank
nakapag-amass siya
records that
ng,
will provide us
unexplained
that
wealth.
Talking
information.
about,
Agree, and it's suspicion.
When you say suspicion, that doesn't mean necessarily suspicion that it's attached to
Actually,
a
binago na rin ngayon.
crime.
Probable
But it
cause
could be suspicious
with
meaning
reasonable certainty
6 months walang
makoconvict.
gumagalaw. Biglang
So meaning
everyday
you go
ngayon
to the
gumalaw.
fiscal's office,
Diba? Yun yung
that
definition
you point
ng
out ano
part
yung
ng
crime,
definition ng AMLA.
sino
But if
yung
you
gumawa
cannot
ng
connect
crime,
AMLA and the bank accounts,
and yung
that's precisely
preliminary
what the defense and
evidence
other
mo
people are saying.
might not
Aren't
be
you
enough to
fishing
convict
between
at
the
the
three?
time, but enough to say na phishing means hindi mo pa hawak, hindi lang to marites. So if
you're
I go
trying
to the
to get
fiscal's office
a
or
fish, in this
ombudsman
case, a very
saying this
big fish.
senator has
Diba?
150
So,
million in SALN.
Pag sinabing hindi
10 years
fishing
ago, it was 50
expedition,
million. Meron ka ng
therefore it's
ebidensya.
ill-gotten wealth, and then
But
wala
you
pa
want,
akong ibang dala except yung
to prove that
magkano
in
sweldo
court, and you need that
dito.
to
I
prove it,
doubt
but
the
you know
fiscal
what to
will-
prove already. Will file
If
the
we
case.
bring
But if
Your
I tell the
Honor's,
fiscal that he has 2 cars
logic
in
to
his
its
SALN, but
conclusion,
eto,
that would mean
I
that
see
the
him
Committee
using
on Justice
4.
would
Then
have
give
to
him the
conduct a
opportunity, but I can
full-blown
subpoena
trial,
the LTO.
get all the
Na
evidence
kanino ba
at
yung
that
plate
level,
number na yan? Baka namang
so that we do not
nasa
have to
kapatid
fish
talaga
anymore
niya, no?
when
But
we get to this
the last
court.
set of
When
questions,
that
I'll
is
just
not
ask
the
it
contemplation
once,
of the
no?
procedure
So I think
for
everyone
impeachment
understands
under the
naman yung
Constitution.
subpoena
I won't
regarding the
argue
Vice
what
President,
With
what
the
the
permission,
issue was
with the
really the
permission of the
dates
gentleman of
and
the floor,
how specific or hindi.
Senator Cayetano,
Last 2 questions.
The
Thank you very much.
corporation, 2 questions. The
Senator
corporations,
Escudero, myself, we were in the Estrada and Arroyo
do you not have to pierce
impeachment.
the
It's harder
corporate
to
veil,
impeach a president than a vice
considering there's no
president.
allegations
Diba?
in the
But whether it was
articles that
accounts and
these companies were used to
kotse,
amass.
we did our homework.
So it's not my
Ill-gotten
place to
wealth.
tell
In fact,
you did or not.
I haven't read
Kaya nga
everything,
tinatanong
but so
ko,
far
may
sa
ebidensya
binasa ko,
ba o wala? Or
is it
hindi
a
kumikita
fishing
tong mga
expedition or
kumpanya
not?
na to?
As I said
Because
a while
there's a
ago, I
Supreme
won't
Court decision. So I have
If
one
it's a
last
joint
question
account,
after that.
my
but I'll
rights
go
then
first
yung
to the
isa.
And I don't even know if we
defense. In the
informed all of
context of
those
what I-
companies
what I
that we
asked,
might subpoena
no.
their
Between those two
their
examples,
records. So did
ito
we give them
SALN
that
mo, ito
opportunity?
income mo, malaki
Isama ko na
SALN
yung
mo.
last question,
Oh.
Mr. Presiding Officer.
We can
and
agree,
I
I
will
won't
explain. Follow
Kasi
it
nga,
up.
you need
no?
to
But,
explain it further. But is it automatically ill-gotten wealth?
No, Your Honor.
So if it's not automatically ill-gotten wealth, in your view, I mean, I read this from your, maybe you can just restate, why is it a fishing expedition? Yeah. The
Your
question
Honor,
was,
because precisely,
Because
yun pong
as law student
sinasabi nila
asked
na
me,
unexplained wealth.
Sir,
They were
bakit dinala
basing
yung
it
box
for
dito
20
sa
years,
Senate?
for one. No?
Ba't
Pangalawa,
hindi
they
nila binuksan
couldn't
sa
pinpoint
House?
exactly.
So sinagot ko sa kanila,
bakit mo
ano
nasabing
ba
may
turo ng
unexplained?
professor
Alin
nyo?
dito sa properties
Sir, hindi naman
and
nakalagay
unexplained?
impeachment trial in
Third, and
cases
if I
of
may elaborate
impeachment.
from
So
our
the House
memo,
was actually empowered
If you look at the articles of
to open
impeachment,
the
it
box
presupposes that the
there.
Vice President
So I
earned
just wanna
30 million
know the
over a
position
span of
of
20
both,
years. Yes, they did not
parties.
think
Kasi
about the
nahihiwagaan
Vice
ako sa
President
box
not
na yun.
being in public office from
Si Neil dinala
2013
dito,
to
babalik sa inyo,
2016.
then magsusupina
They didn't think
tayo.
about the income
But,
that could have
dun sa
been
graduate
generated
na yung
by
nagtanong
being
sa akin
married to a
doon.
lawyer
They
who had
discussed
his
it
own
daw in
law
class,
office.
and
So
their
to us,
professor and their
it was
class,
basically
ang consensus is that the House
conjecture,
would have opened it
speculation,
because the
conclusion of
wording
law
in
and fact to
the
say, biglang, uy, may unexplained wealth po dito.
in the-
That's basically
sorry.
our point.
Is it the
And
BIR
then
case or
secondly,
the bank
the
accounts?
decision earlier
No, bank accounts
it was
ata,
mentioned by
in cases of
distinguished opposing
impeachment,
counsel.
yung nakalagay
Decision
dun sa-
rests
sa bank
upon
accounts.
this court to determine
Secrecy
kung
of bank
meron ng
deposits.
unexplained
Yes.
wealth.
So
I
ang
disagree with
question
that.
niya, let me
The
rephrase
ultimate
it, is that,
decision
did you
rests
do
upon
that
this
there?
court, that is
If
true.
you did that there,
But
hawak
the
nyo na
initial
ngayon.
decision
Hindi na
rests
namin
with the
problema
person
sana.
accusing.
So those
Diba?
two questions lang
Pero nung
regarding the-
nag-accuse yung tao
do you think
sa Sabayan
nag-comply
Cabrera
yung requirements
complaints,
dun sa
wala man
companies,
lang
and should we give
nakasulat po
notice
doon.
to
Kanina
the
na-mention
companies?
po yung
And
should
secondly,
the
about,
Committee on Justice now
bank
conduct a
account,
full-blown
could we
trial?
have
No,
opened it
it
already
shouldn't.
in-
It should
in the
just
House?
evaluate the complaint. Parang nga pong piskal. Parang preliminary
Counsel for the panel of
investigation.
prosecutors
Pag
may
tayo po
respond
pumunta
thereafter,
sa piskal,
counsel for respondent.
At wala,
Thank
at
you,
ang dala
Your
lang
Honor.
natin
And
doon ay
would
puro
like to thank
paratang.
Counsel
Wala man
thank
lang
you, Judge
supporting
Allen,
argument.
for his
What would the
interjection.
fiscal do? Dismiss
Your
the
Honor,
case
please,
outright.
the doctrine of
Yan naman
piercing
po
the
ang
corporate
totoo.
veil
No? So that was
applies
our
when
point to begin
we are
with. And
determining
that
determining
is why we're
liability
saying
of the
fishing
company
expedition ito.
or corporation
Kasi
involved.
hindi mo man lang
In this
mapinpoint
particular case,
kung anong
that
transaction
doctrine
yung
has no
sinasabi mong
application
nag-amas
at
ang
all.
Vice President
We are
natin.
asking for
Anong
those
taon na
records to
nag-amas
be
yung Vice
produced
President
so
natin
that
ng
we can
ill-gotten
determine
wealth
the
or
extent
unexplained
of
wealth?
participation
At dahil doon
of the Vice
ngayon,
President.
we're asking for
As she
records spanning
herself had
20 years,
admitted
both
those business
BIR
interests in her
records,
salary.
bank records,
Kaya po
AMLAC
namin
records,
hinihingi
which
po
they
yun.
already have.
Kasi tingin po
Actually,
namin ay wala pong
from the
aplikasyon
Committee on
ang
Justice justice.
using the
Pero
corporate veil.
hindi natin
Second, as far
ma-pinpoint
as
alin
opening
ba
the
talaga
box is
dito. We cannot
concerned, while it is
specify
true that
kung ano yung
under
act,
Republic Act
ano yung omission na
1405,
ginawa niya na
there's no
nakapag-amass siya
qualification that
ng,
impeachment
unexplained
trial lang
Talking
po ang
about
pwede.
the
As I understand
both
it, it was
parties talking
the
about
better
the
judgment of the
fiscal
committee
or prosecutor.
out of sheer
Actually, binago
discretion
na rin
and
ngayon.
prudence.
Probable cause
Not to,
with reasonable
because at that
certainty
time,
mako-convict.
we were already being
So
bombarded
meaning you
with
go to the fiscal's
petitions left and
office
right
that you
seeking
point
to
out ano yung
restrain
crime,
our proceedings.
sino yung
And,
gumawa ng
we
crime,
felt that it would be
and yung
more prudent
preliminary
to bring the
evidence
matter
mo
to this
might not be enough to convict at that time, but enough to say na
Your Honor.
Counsel for the respondent.
hindi
On
lang
the first point,
tumarites.
Your Honors, on
So if I
piercing
go to the
corporate
fiscal's
veil,
office or ombudsman
para
saying
sa
this
amin,
senator
pwede
has
lang naman
150
under
million in
jurisprudence
SALN,
mag-pierce ng corporate
10 years
veil.
ago it was 50
Ibig sabihin,
million.
kasi separate and
Therefore,
distinct
it's
personality
ill-gotten
mga
wealth.
korporasyon,
And then
you
wala
can
pa
pierce
akong
that
ibang
veil
dala
if there's
except
an allegation
yung
of fraud.
magkano sweldo
And in this case,
dito.
wala naman
I doubt
pong
the
allegation
fiscal
of fraud. Pangalawa, kung totoo po
will file
na
the
talagang
case. But if I
hinahanap
tell
lang
the
po
fiscal
ang
that he has two
kinakagalang-galang
cars
na
in his
prosecution
SALN, but
ay
eto,
tungkol dun sa divestment
I see him
issue,
using
then
four.
they will
Then
not
give him
need
the
the tax
opportunity. But I can
records, the
subpoena
bank
the LTO.
records, or
Na kanino
even
ba
the
yung
AMLAC
plate number
records
na
of
yan?
these
Baka
companies,
namang
because all they
nasa
need would be the
kapatid talaga
GIS.
niya, no?
The
But
the general
last set
information
of
sheet would
questions,
show
I'll just
you
ask it
exactly the
once,
extent
no?
of the interest
So I
of
think
the
everyone
stockholders.
understands
Hindi po
naman
ba?
the subpoena
Pangalawa,
regarding the
pagdating
Vice
naman po
President,
dun sa what's our position,
the issue was really
pagdating
the
sa bank
dates
secrecy
and
the
how
exception on cases
specific
of
or hindi.
impeachment. Sa aming pananaw, at the committee level,
corporate,
meaning Committee on
actually two questions.
Justice,
The corporations,
ay hindi pa po applicable yung exception na ito. And we are
do you
holding on
not
to the
have to
ruling of
pierce
Marquez
the
versus
corporate veil,
Ombudsman or Desierto,
considering
I
there's
believe
no
na.
allegations
Wherein it was said
in the
na
articles
pagdating sa
that
preliminary
these companies
investigation,
were
hindi
used
pa po
to
applicable
amass,
yung mga exceptions under the Bank Secrecy
ill-gotten
Act,
wealth. In
and there
fact,
has to be a
I haven't
pending
read
case
everything, but so
before
far sa
such
binasa
bank
ko
documents are
is
in fact
hindi kumikita
subpoenaed.
tong mga
That is our position.
kumpanya na to because there's a Supreme
Thank you,
Court decision
counsels for the
that if
parties.
it's a joint
Chair will
account,
now make a
may
ruling, but
rights
prior
din
to
yung
that ruling,
isa.
Chair
And I
would like to
don't even know
inquire
if
very,
we
very briefly
informed
from
all of
the
those
councils.
companies that
First,
we might subpoena their
for the counsel for
their
respondent,
records. So did we
may the
give them
court
that
know
opportunity? Isama ko na yung last question, Mr. Presiding Officer.
when the
and
respondent
I
was
won't
married
follow
to
it
her
up, no, but,
spouse, and what is the property regime governing their marriage?
Your Honor, I believe they were married, but let me just check the facts just to be sure. But I think it was 2007.
Yeah, the question was
2007, Your Honor.
Because
Can I get back to you on the
law
specific
student
date
asked
for
me,
that?
The date would
Sir,
not be
bakit
necessary
dinala yung box
because
dito sa Senate?
2007 would mean
Ba't na lang
they would
hindi
be
nila
covered
binuksan
under the
sa
family
House?
code. So may
So
the
sinagot
chair
ko sa
ask,
kanila,
what
ano
is
ba
the
turo ng
property
professor
regime
niyo?
governing
Sir,
their
hindi naman
marriage?
nakalagay impeachment
As far as I
trial
know,
in
there are
cases of
no,
impeachment. So the House was actually
property
empowered
regime arrangements
open
or
the
prenup.
box
That's
there.
why, Your Honor,
So I
I would
just
assume it
wanna
would be
know
the
the position
default,
of both
property regime, which would be
The absolute
absolute
community
kasi
of property.
nahihiwagaan ako
Thank
sa
you,
box
counsel.
na yon.
Chair will now make its
Sinil,
ruling.
dinala dito, ibabalik sa inyo, then magsusupina
The
tayo.
impeachment court will now
But,
resolve the
dun
prosecution's
sa
renewed request for the
graduate
issuance
na
of
nagtanong sa
subpoena
akin
ducis
nun,
tecum
they
dated July
discussed it daw in
6,
class, and
2026
their
in a seat
professor
council.
and their class, ang consensus is
Directed
that
to the
House
concerned
would have
banking
opened it
institutions
because
and
the wording in
anti-money
the,
laundering council. The court begins with the standards governing the
in
issuance
the-
of subpoena
sorry,
ducis tecum.
is it the
These are set
BIR
forth in
case or
Section
the
3, Rule 21 of the Rules
bank
of Courts, which provides,
bank
among
accounts
others,
ata,
that
yung in cases
in
of
the case of a
impeachment, yung
subpoena
nakalagay dun
ducis
sa-
tecum, it shall contain
sa
a reasonable
grounds.
description of the books, Secrecy of bank documents, or deposits. Yes.
So
things demanded,
ang question
which
niya,
must
let me
appear to the
rephrase,
court
is that,
as prima
did you do
facie
that
relevant.
there? Kasi if you did that there, hawak nyo na
Settled
ngayon.
jurisprudence has affirmed
Hindi na
and
namin
clarified
problema
these
sana.
requirements in the 2021
So,
case of
two
Republic
questions lang
versus
regarding
Sandigan
the-
Bayan,
Do you think
dated
nag-comply yung
2/15/21, where the
requirements
Supreme
dun sa
Court
companies,
stated,
and
quote,
should we give notice
a subpoena
to
ducis
the
tecum may be
companies?
issued if the tests of
And
relevancy and
secondly,
definiteness are
about,
satisfied. The
bank
court,
account,
the court
could you have
must
opened
ensure
it
that,
already
number one,
in the House?
the books, documents, or other things
BIR.
requested must appear prima
Counsel
facie
for the
relevant
panel
to the issue,
prosecutors
may respond subject of the
Counsel for
controversy,
respondent.
the test of relevancy.
Thank you, Your
And number
Honor.
two,
And
would like to thank
such
books
counsel
must be
takes
reasonably
very
described by the
for his
parties to be
interjection.
readily identified.
If Your Honor,
The test
please,
of
the doctrine
definiteness.
of piercing the
In the case of
corporate
BSB
veil
Group Inc.
applies
versus
when
Go,
we
GR
are
number
determining
168644.
liability of the the company
The court
or
stated that
corporation
evidence is
involved.
relevant when it
In this
bears such a
particular
direct
case,
relation
that
to the fact
doctrine
and
has
issue
no application
as to
at
induce
all.
a belief in
We
its
are asking
existence
for
or
those
non-existence,
records to be
and when it
produced
relates
so
to
that
a
we can
collateral
determine
fact
the extent
from which
of
the existence or
participation
non-existence of the
Vice
principal fact
President,
may
as
logically
she
be
herself
inferred.
had admitted
These
those
requirements are
decisions
intended to
in her
ensure that the
hands.
subpoena is not
Kaya po
used, as
namin
mentioned
hinihingi
earlier and
yun.
discussed earlier,
Kasi
as a
tingin po
tool
namin ay
for a
wala
fishing
pong
expedition as
aplikasyon
held in
ang
Apostol
case in the
versus
corporate
Lubingan
bill.
Rafael,
Second, as
GR
far as
number
opening the box is concerned,
260640,
while it
dated
is
October
true
1,
that under
2025.
Public Act 1405,
We are also aware of the ruling of the
there's no
Supreme Court in
qualification
HG
that
Libenau versus
impeachment
Philippine
trial
National
lang
Oil
po
Company,
pwede.
GR number
As I understand it, it was the
13146.3,
better
quote,
judgment of
a
the
general
committee
inquisitorial
out of
examination
sheer
of all the books,
discretion and
papers, and
prudence,
documents of an adversary
not to-
conducted with a
because at
view
that
to
time,
ascertain whether
we were
something of
already
value
being bombarded with,
may or may not show up
petitions left and
will
right,
not be enforced.
seeking to
However,
restrain our proceedings.
after a careful examination of the
And,
records
we felt
requested,
that
the court
it would
finds
be more
that the
prudent
requested
to bring the
documents
matter
meet the
to
requirements
this
set
honorable
forth above. They are reasonably described,
Your Honor,
readily
counsel for the
identifiable,
respondent.
prima facie
On the
relevant,
first
and
point,
material
Your
to the
Honor,
allegations
on
under Article 2.
corporate bail.
This is not the first
Para
time
sa
that bank
amin,
records have been
pwede lang
examined by an
naman
impeachment
under
trial.
jurisprudence, mag-pierce ng corporate
During the impeachment
bail.
trial of former
Ibig
Chief
sabihin,
Justice
kasi
Corona,
separate and distinct
the Senate
person
sitting as an
natin
impeachment
makorporasyon,
court granted
you
the
can pierce that
prosecution's
bail if
request for
there's
the
an
production
allegation
of bank
fraud.
records.
And in this
In
case,
granting
wala
that
naman pong
request, the court
allegation of
cited
fraud.
Section 2 of
Pangalawa,
Republic Act number
kung totoo po
1405,
na
which
talagang
expressly
hinahanap lang po
recognizes
ng mga
cases of impeachment
pinakagalang-galang
as an
na
exception to the
prosecution
confidentiality
ay
of bank
tungkol dun sa
deposits
divestment
and the
issue,
rights to
then they
privacy
will
of
not need the
depositors.
tax records,
As to the
bank
requested period
records,
from 2007
or even the
to
AMLAC records
2021,
of these companies, because
the
all they
defense's
need would be the
objection is
GIS.
overruled.
The
The
general
respondent's
information sheet
invocation
would
of
show
what
you
they refer
exactly
to
the
as
extent of the
offenses in
interest of
term,
the
quote unquote,
stockholders, hindi
in their
po ba?
memorandum.
Pangalawa, pagdating
Doctrine
naman
in
po dun
Duterte
sa what's our
versus
position
HOR does
pagdating
not
sa bank
avail.
secrecy
First,
and the exception on
the
cases of
documents
impeachment.
requested under the
Sa aming
subpoena
pananaw,
dusistegum
at the
will not
committee level,
be
meaning
used to
Committee on
allege
Justice,
additional
ay hindi
independent
pa po
impeachable
applicable
offenses.
yung exception na
The
ito.
court
And
will
we
not
are
allow this
holding
in
on to the
adherence
ruling
to
of
the doctrine
Marquez
laid down in
versus,
Duterte v. HOR,
Ombudsman or
as
Desierto,
this will
I believe,
violate the
no?
respondent's
Wherein it was
right to be
said
informed of
na
the
pagdating
nature
sa preliminary
and cause of the
investigation,
accusations
hindi pa po
against her
applicable
and her
yung
rights
mga
to due process
exceptions
at
under the
every
Bank
stage
Secrecy
of the
Act,
proceedings.
and there has to be
Rather,
a pending case
the court will only
before
allow these
such
records
bank
to be used to
documents are in
establish a
fact
factual
subpoenaed.
baseline
That is our position,
against
Your Honor.
which the respondent's Thank you, assets, counsels financial for the parties. transactions,
Chair will now
and
make a
business
ruling, but
interests
prior to
during
that
her
ruling,
present term may
Chair
be
would like to
assessed.
inquire very briefly from
Establishing
the
such a
counsels.
factual baseline is
First,
recognized in
for the
settled
counsel for
jurisprudence involving
respondent,
allegations
may the court
that a
know
public
when,
officer's wealth is manifestly disproportionate
when the
to the lawful
respondent
income
was married
and financial
to her
capacity of the
spouse,
officer
what is
and the officer's
property
spouse.
regime governing
As
their
held by the
marriage.
Supreme Court in concerned taxpayer versus
Your Honor, I
Doblada
believe
Jr.
they were
dated
married,
8
but
June
let me just
2005, quote,
check the facts.
in
just to be
determining
sure, but I
whether
think
the
it was
properties
2007.
acquired were manifestly out of proportion to the lawful income of the spouses necessarily
2007,
requires
Your Honor,
comparing
can I
their
get back
value
to you
with
on
the
the
spouse's
specific date
salaries,
for that?
benefits,
The
other
date would
lawful
not be
income,
necessary,
and revenues
because,
from legitimately
2007
acquired
would mean,
properties
they
or
would be
businesses.
covered under the family
Further,
code, so may
in the
Yes, Your
case of
Honor.
Ombudsman V. Bernardo,
property regime
GR number
governing their
185098,
As far as I know, there are no
respondents' beginning net worth must be
property
considered for purposes of
regime
determining
arrangements or
whether his
prenup.
disposable
That's why, Your
income
Honor, I
was
would
more
assume
than
it would be the
sufficient to
default,
justify his property
property
acquisitions
regime
and
that
foreign
should be
travels
absolute
The absolute
for the
community
covered
of property.
period,
Thank you,
and
counsel.
whether he possesses
Chair
the
will now make
financial
its ruling.
capability to acquire or purchase properties
The
as
impeachment court
reported
will
in
now
his
resolve the
SALN.
prosecution's renewed request
Quote,
for the issuance of
such
subpoena
net
to
worth of the
dated
respondent
July
as
6,
declared in the statement
2026.
filed by him or
You may seat,
her
counsels.
from the first day of his employment with the
Directed to the
government shall be
concerned
considered
banking institutions
as
and
his true net
Anti-Money
worth
Laundering Council.
as of
The court
such
begins
date
with
for
the standards
purposes of
governing the
determining his
issuance of
capacity
subpoena
for
duces
future
tecum.
property
These are set forth in
acquisitions
section 3,
during
Rule
his
21 of the
tenure
Rules
as
of
a
Court,
public officer,
which provides,
any
among others,
unexplained
that
increase in his net worth
in the
thereafter
case of a subpoena
may fall
duces
within the
tecum, it shall
ambit of the
contain a
presumption
reasonable
provided
description
for
of the books,
in
documents,
Republic Act
or
number
things demanded,
1379,
which
must appear to the court
The
as
production,
prima
therefore,
facie
of
of
the
the
records
records from 2007 to 2021
Settled
is
jurisprudence has
authorized
affirmed and
strictly for
clarified
that
these
limited
requirements
purpose
in the
only.
2021 case of
Their
Republic versus
admissibility and
Sandigan Vian,
evidentiary use shall remain
dated
subject to the
2/15/2021,
prosecution
where the
establishing
Supreme Court stated,
their
quote,
connection to the alleged
"A subpoena
unexplained
duces
wealth
tecum may be
be issued
during
if the
the
tests of relevancy and
present
definiteness are
term
satisfied.
in relation only
The court
to Article
the court
2
must
of the
ensure that,
Articles of
number
Impeachment.
one, the
Now,
books,
with regard to the
documents,
bank
or other
records held
things requested
separately
must
by
appear
Attorney
prima
Manases
facie relevant
Carpio
to the
and
issue,
Joint Carpio,
subject of the controversy,
and jointly
the
by
test of
him and the
relevancy.
respondent.
And number two,
The defense's
such books
objection
must
is
be reasonably
likewise
described by the
overruled.
parties to be
The
readily
respondent's
identified.
reliance on Republic
The test
versus
of
Eugenio is
definiteness.
unavailing. That
In the
case
case of BSB
involved
Group,
only an
Inc.
ordinary
versus
civil
Go,
inquiry into
GR number
spousal assets
168644
that were not
The
statutorily
court stated that
aggregated.
evidence is
On the other
relevant
hand,
when it bears such a
Section 8
direct
of the
relation
Republic
to
Act
the
number
fact in issue
6713 requires
as to
public
induce a
officials
belief
to
in its
disclose their
existence or
assets,
non-existence,
including
and
that
when it
of their
relates to a
spouses.
collateral fact
Their financial
from which
interests
the
are therefore
existence or non-existence
statutorily
of the principal
intertwined for
fact
purposes
may
of
logically be
disclosure.
inferred. Respondent likewise
These requirements are
insists
intended
on
to
the
ensure
separate
that the
legal
subpoena is
personality
not
and
used,
distinct
as mentioned
privacy
earlier and discussed
of
earlier, as
Attorney
a
Carpio.
tool for a
that this is
fishing
likewise
expedition as held in
untenable.
Apostol
Article
versus
75
Lubino
of the
Rafael,
Family Code explicitly
GR number
provides, which is why the
260640,
presiding
dated
officer
October 1,
earlier asked
2025.
the property regime
We
governing
are
them.
also aware of the ruling of the
In the
Supreme Court
absence of a
in
marriage
HC
settlement
Libanov versus
or when
Philippine
the
National
regime agreed
Company,
upon is void,
GR number
the system of absolute community of properties established
a general
in this code shall
inquisitorial
govern.
examination of all the
Under
books,
this regime,
papers, and
Article
documents of
91
an adversary
dictates that community
conducted with a
property
view
shall
to
consist
ascertain whether something
of
of
all the
value
property
may
owned
not
by the
may or may not
spouses
show
at
up
the time of the
will not
celebration
be
of marriage
enforced.
or acquired thereafter.
However, furthermore,
after a careful examination of the records
Family Code
requested, the
imposes
court
a strict
finds
statutory
that the
presumption that the
requested documents
Article
meet the
93, which
requirements set
mandates that
forth
property
above.
acquired during the
They are
marriage is
reasonably
presumed to belong to the
described,
community,
readily identifiable,
unless
prima
it is
facie
proved
relevant,
that
and
it is one
material
of
to
those
all
excluded
exclusions
therefrom.
therefrom.
The
This
law
is not the
clear
first
on
time
matter.
that bank records have
The
been
legal
examined by an
necessity of
impeachment
examining
trial.
the financial records of Attorney
During the
Carpio is
impeachment
firmly
trial of
cemented
former
by
Chief
the default
Justice
property
Corona,
regime
the Senate
of
sitting as an
absolute
impeachment
community
court
of
granted the
property
prosecution's
governing
request for the
his
production of
marriage
bank
to the
records.
respondent.
In granting
Absent
that
any
request,
proof
the
of a
court
different
cited
property
Section
regime
2 of Republic
governing
Act
their
number
marriage.
1405,
Any funds
which
deposited in the
expressly
bank accounts of
recognizes
Attorney
cases of
Carpio are legally
impeachment
presumed to
as an
form a
exception
single,
to the confidentiality of
indivisible
bank
mass of
deposits
community
and
property
the rights to
jointly
privacy
owned
of depositors.
with the respondent Vice
As to the
President.
requested period from
Because
2007
Philippine
to
civil law
2021,
legally merges their assets,
the defense's
properties, and
objection is
income into a
overruled.
single absolute community.
The respondent's
It is the
invocation of
legal
what they
and
refer to as
mathematical
offenses in
It
term,
is a
quote,
legal and
unquote, in their
mathematical
memorandum.
impossibility to determine.
Doctrine in
the
Duterte
respondent
versus
true net
HOR
worth or
does
lawful
not
income without
avail. First,
examining the bank accounts
the
of her
documents
husband.
requested under the
Investigating
subpoena
Mrs.
Mr. Carpio's
Carpio's
will
financial
not
records is
be
therefore
used
not
to
an
allege
additional
additional
into a third
independent
party's
impeachable
privacy.
offenses.
But an
The
absolute
court
legal
will not
prerequisite in
allow this
determining
in
the
adherence
actual
to the doctrine laid
aggregated
down
wealth of the
Duterte
respondent.
VHOR. The
As
defense
this will
likewise
violate the
invokes the
respondent's
right to
right to
be
be
informed of the
classifying the
nature
records as sensitive
and cause of
personal
accusations
information,
against her
requiring
and her rights to due
strict scrutiny,
process
quote,
at
unquote,
every
citing
stage of the
Zoleta versus
proceedings.
Ombudsman.
Rather, the court
However,
will only allow
in
these
Zoleta
records to be
did
used
not
to establish
really
a
use the
factual
phrase strict
baseline
scrutiny, but said
against
strict
which the
adherence
respondent's
to
assets,
the Data
financial
Privacy Act.
transactions, and
Accordingly,
business interests during her
Section
present
16
term may
of the
be
Data
assessed.
Privacy Act expressly states that the right to
Establishing
privacy
such a
does not
factual
apply
baseline is recognized
when
in
personal
settled
information
jurisprudence
is
involving
needed
allegations
pursuant to a
that a
subpoena.
public officer's wealth
Furthermore,
is
Rule
manifestly
5, Section
disproportionate to the
22F
lawful
of the
income
DPA,
and
Data
financial
Privacy Act
capacity of the
implementing rules
officer and the
expressly
officer's
permits
spouse.
the processing
As
of
said by the
sensitive
Supreme Court in
information,
concerned
personal
taxpayer
information
versus Doblara
when
Jr.,
provided to
dated
government
8
or
June
public authority
2005,
pursuant to a constitutional
in determining
or
whether
statutory
the
mandate,
properties acquired
and
were
when necessary
manifestly
for
out
the
of
protection of
proportion
lawful rights
to the lawful
interests
income of the
in court
spouses
proceedings.
necessarily
Now,
requires
as to the
comparing
21
their
listed
value with the
com-
spouse's
corporate
salaries,
entities and
benefits,
partnership.
other lawful
The
income,
requests are
and
granted
revenue
with respect
from
only to
legitimately acquired
19
properties or
corporate
businesses.
entities and partnership.
Further, in
The
the case of
respondent's connection
Ombudsman
to
V.
these
Bernardo,
entities is prima facie
GR number
shown by the
18,
General Information
1598
Sheets,
quote,
in the articles of
respondent's
partnership
beginning net
which
worth
have been
must be
pre-marked in
considered
evidence
for
and by her
purposes of
admitted
determining
sal
whether
ends
its disposable
from
income
2022 to
was
2025.
more than sufficient to
The
justify
request,
property
therefore, is not
acquisitions and
considered
foreign
as a
travels
fishing expedition
for
and
the covered
subpoenas may
period,
issue
and
for
whether
their
he possesses the
demonstrated
financial
financial
capability to
accounts
acquire or
strictly
purchase
only
properties
in relation to Article
as
2.
reported in his SAL.
However,
quote, the request directed
such
to
net
banking
worth of the
institutions
respondent
concerning
declared in the
JTC group of
statement filed by
companies
him or her
from the first day of his employment with a government corporation
are denied.
as his true
Their
net
general
worth
information sheets do
as
not
of such
identify the
date
respondent
for
or her
purposes of
spouse as
determining his
shareholders,
capacity for
and the
future property
prosecution at this
acquisitions
time failed to show
during
either
his
direct
tenure as
business
a public
interest
officer
or a clear
Any
and convincing
unexplained
basis
basis
in
in
this
this
regard
regard
thereafter
separate
may
juridical
fall within the
personalities.
ambit of the presumption
As held in
provided for
Pantranco
in
Employees
Republic Act
Association
number
number
1379.
GR
The production,
170689
therefore, of
and
the
the
records
NUSA
of 2007
2007-2021
number
is authorized strictly for that
174938
limited purpose
The
only.
corporate veil may not be
Their
pierced on mere
admissibility and
suspicion or
evidentiary use shall
speculation
remain
misuse
subject
of
to
the
the prosecution
prosecution
establishing
establishing conduit
their
or
connection
instrument
to
of
the
fraud
alleged
must be
unexplained
clearly
wealth.
established. During the
Absent such
respondent's
proof, these
present
entities
term
cannot be subjected
in relation
to
the
only to
compulsory
Article
process
2
intended
of the Articles
for
of
another.
Impeachment.
Now, with
As
regard
to
to
the
the bank
request for
records
subpoena
separately
against
by
the
a partnership
partnership
of
of
Carpio
Carpio lawyers,
and
the same is granted
and
with the
jointly by
following
him and the
reservation.
respondent.
In adherence to
The defense's
Subido
objection
versus
is likewise
Pagantes
overruled.
Orteza Mendoza,
The respondents
and
relies
B9
on
law
Republic
officers
versus
versus
Eugenio
Court
is
of Appeals.
unavailing.
That case
GR number
involved only an ordinary civil
216914.
inquiry into spousal
The chair
assets
notes the
that were
practical
not
reality that an
statutorily
examination of a
aggregated.
law firm's
On the
bank
other
accounts
hand,
may incidentally
Section
disclose
8 of Republic Act number
sensitive
6713
information relating to
requires
its clients
public
and legal
officials to disclose
engagements.
their assets,
The court acknowledges
including
that
that of their spouses.
the
Their
partnership
financial
and
interests
or
are
the
therefore
clients of Carpio
statutorily
lawyers
intertwined for
may seek
purposes
appropriate
of disclosure
remedies and to challenge
Respondent
compliance with
likewise
applicable legal
insists on the
requirements,
separate legal personality
particularly in light
distinct
of
right
the
to
potential
privacy
legal
of
implications,
Attorney
including
Carpio.
concerns relating
But this is
to
likewise
attorney-client
untenable.
privilege, which may
Article
also be
75
raised
of the Family
during the
Code
trial
explicitly
proper.
provides
Furthermore, the presiding officer
the court must
earlier
draw a
asked the
legal
proper
firm line
regime
regarding
governing them.
foreign currency
In
deposits.
the absence of a marriage
Foreign
settlement
currency
or when
deposits
the
are
regime
governed by
agreed
Republic
upon
Act
is
number
void.
6426,
The system of
particularly
absolute
Section
community
8,
of properties
which
established
recognizes
in this code
only
shall
one
govern.
exception to confidentiality.
Under this regime, Article
The written
91 dictates
permission
that
of the
community
depositor.
property shall consist
This is
of
also
all the
guided by the
property
President
owned by the
arising from the
spouses at the time of the
2012
celebration
Corona
of
impeachment
marriage or
trial
acquired thereafter.
on February 19,
Furthermore,
2012, the Supreme Court issued
the
the
Family
temporary
Code
restraining
imposes a
order in
strict
PS
statutory
Bank versus
presumption
Senate
under
Impeachment Court,
Article 93, which
GR
mandates
number
that property
200-238,
acquired during the marriage is presumed to
enjoining the
belong to the
Senate from
community
opening the Chief
unless
Justice's
it is proved that it is one of
dollar
those
accounts.
excluded therefrom.
In the absence of a
The
written
law is
waiver
clear on the
of the
matter.
depositor.
The legal
Accordingly,
necessity of examining the
insofar as
financial
the
records
request
of Attorney
covers
Carpio is
foreign
firmly
currency
cemented
deposits
by
of
the
the
default
respondent,
property
her
regime
spouse, separately or
of absolute
jointly,
community of
as well as
property
the
governing
corporation and
his
partnership,
marriage
it is
to the
denied.
respondent.
Such accounts
Absent
shall be
any
excluded
proof of a different
unless and
property
until written
regime governing
consent
their marriage.
of the
Any
respective
funds
depositors
deposited
is
in the bank
produced.
accounts of Attorney Carpio
The
are
court now
legally
turns
presumed
to
to
the
form a
records held by
single,
the
indivisible
indivisible
mass
massive
of community
council.
property jointly owned. With
As to the
respondent
request
Vice
directed to the
President.
Anti-Money Laundering Council,
Because
the same are
Philippine Civil
granted
law
with
legally
respect to
merges
the
their
19
assets, properties, and
the
income into a
respondent, her
single
spouse,
absolute
and the
community
19 entities.
It is the
And
legal
one
and
partnership
mathematical
for which
it is
a
a
prima
legal and
facie connection
mathematical
has been shown
impossibility
through
to
the pre-marked
determine
general
the
information
respondent's
sheets,
true net worth or
articles of
lawful income
partnership,
without
and the
examining the
respondent's
bank
admitted
accounts of her
salaries.
husband.
However,
Investigating
the requests
Mr. Carpio's
as to
financial records
JTC
is
group of
therefore not
companies
an
and
unwarranted
Pikimong
intrusion into a
Philippines
third party's
Corporation are
privacy.
denied.
But an
For
absolute
failure
legal
at this stage
prerequisite
to
in
establish a
determining
prima facie
the
link,
actual
the
aggregated wealth
respondent
of
or
her
her
spouse
spouse
and said entities,
The defense likewise
or
invokes
any
the
sufficient
Data
basis
Privacy
to
Act,
disregard their
classifying their
records
records
as
as
sensitive personal
as
information,
previously stated.
requiring
The defense vigorously argues that the MLC is absolutely shielded.
The court,
From this
however,
court's compulsory
in Zuleta
process
did
by the
not
confidentiality
really use the
provisions
phrase
of Section
strict
80 of
scrutiny,
the
but said
Anti-Money
strict
Laundering Act,
adherence
as
the
amended
Data
and warrants
Privacy
that
Act.
compliance with exposed
Accordingly,
AMLC officers to criminal
Section
sanctions
16B of the
for
Data
breach of
Privacy Act
confidentiality
expressly states that the
The
right
court,
to
however,
privacy
finds
does
this
not
argument
apply
unavailing.
when personal
Section 8A
information
regulates
is needed
unauthorized
pursuant
and
to a
arbitrary
subpoena.
disclosures by AMLAC
Furthermore,
personnel.
Rule 5, Section
It does not
22F
and
of the
constitutionally
DPA
cannot
Data Privacy
nullify
Act
the
implementing
lawful
rules
subpoena
expressly
powers of the
permits
Senate
the
sitting as an
processing of
impeachment
sensitive
court
information,
where
personal
compliance with the
information,
lawful constitutional
when provided
subpoena is
to
a
government
justifying
or public
circumstances
authority
that
pursuant
if
to a
at all would
constitutional
extinguish
or
any
statutory
penal
mandate,
mandate,
and
under
where
Article
necessary
11,
for the
paragraph
protection
6
of
of the
lawful
Revised Penal
rights
Code for any
interests
act
for any person
in court
acting
proceedings.
in obedience to an
Now, as to
order
the
issued by
21 listed
superior or
corporate
some lawful
entities and
purpose.
partnership.
In the landmark case of
requests are
Republic versus
granted with
Miguel
respect
Bayan,
only to
GR
19 corporate
222724
entities and
rather.
partnership.
The
The Supreme Court
respondent's connection
explicitly
to these
rejected the
entities is
MLC's
prima
attempt
facie
to
shown
quash
by
a
the general
subpoena
information
sheets,
ruling verbatim.
quote,
In the articles of
The
partnership,
Anti-Money
which had been
Laundering
pre-marked in
Council is
evidence
not
and by
merely a
admitted
repository of
salience
reports and
from
information
2022
uncovered
to
in suspicious
2025.
transactions.
The request
It was
therefore
created
is not
precisely to
considered
investigate
as a
and
fishing expedition, and
institute
subpoenas may issue for their peso-denominated accounts
charges against
strictly
those suspected
only
to
in
commit
relation
money
to
laundering
Article 2.
activities. The criminal prosecution
However,
of such activities would be
The
unduly
request
hampered
directed to banking
if we were to
institutions
prohibit
concerning
it from
JTC
disclosing
group of
such
companies
information.
and Pikimong
For the Anti-Money Laundering Council to
Philippines
refuse
Corporation
disclosing
are
the
denied.
information required of it,
Their general
would be to go
information
against the
sheets
very
do not
function,
identify
its
the
very
respondent
function
or
under
their spouse
the
as
law.
shareholders. And
Further,
the prosecution
as
of the
the Supreme
Supreme
Court
Court
in
to
Sabio
show either
versus
direct
Gordon,
business
GR
interest
number
or a
1743
clear and convincing basis
disregard their
disparity,
separate
explain that
juridical
statutory
personalities.
provisions on
As held in
confidentiality
Pantranco,
and
Employees Associations
exceptions from
VNLRC,
inquiry, exemptions from inquiry
GR
cannot be
170689
invoked to deny
and
access
Lanuza
to information
versus
by
BF
Congress,
Corporation, GR number
174938. It is therefore the position of
corporate
this court
bail may
that
not be pierced on
if
mere
the
suspicion or
Sandigan
speculation
pursuant to
misuse
its
of
abuse
the
of power
corporation
cannot
as
be
an alter ego,
denied
conduit, or
AMLC
instrument of
records
fraud,
as
must
well
be
as the
clearly
legislature
established.
in aid of legislation.
Absent such proof,
It
these
most
entities
certainly
cannot be subjected
denied to the Senate, to the compulsory process intended for another.
The defense also
As to the
vehemently
request for subpoena
objects
against the partnership of Carpio lawyers, the same is granted
to the
with the
production
following
of
reservation. of MLC documents by pointing out
versus Pagantes
to the agency's own
Mendoza
printed footnotes
and Binay Law Offices versus Court of Appeals, which
GR
restrict
number
the reports for
216914.
intelligence purposes only.
The chair notes the
and
practical
explicitly
reality
state
that
they are not to
examination
be
of a
used
law
as
firm's
evidence
bank
in
accounts
any
incidentally
formal
disclosed
proceedings.
sensitive
The court,
information
however,
relating to
overrules.
its clients and legal engagements. The court acknowledges that
The admissibility
the
and
partnership
evidentiary
and
weight
the
of
clients of
documents in an
Carpio
impeachment
lawyers
trial are
may
determined
seek
by the
appropriate
Constitution,
remedies and to
the
challenge
rules of
compliance
court,
with
and the
applicable
judgment of the
legal
impeachment
requirements, particularly in light of the potential legal implications by an executive agency on its letterhead, attorney-client privilege,
an
which may also
administrative
be raised
footnote or
during
internal
the trial
intelligence
proper.
sharing protocol.
Furthermore, cannot rise
The court
to the
must
level
draw
of
a
a
legal
constitutional
firm
or
line
statutory
regarding foreign
exclusionary
currency
rule.
deposits.
While the
Foreign
MLC's
currency
internal
deposits
protocols
are
are
governed by
validly
Republic Act
designed to
number
prevent premature leaks
6426,
during ongoing
particularly Section 8,
investigations, they
which
cannot
recognizes
legally
only
operate to
one
tie the hands of the
exception to
impeachment court
confidentiality,
once the documents are
the
lawfully
written permission
subpoenaed.
of the depositor.
Because the requested
This is also
suspicious
guided by the
transaction
President
reports
arising
and
from the
covered transaction reports
2012 Corona
satisfied
impeachment
the
trial.
threshold of prima
On
facie
February 19,
relevance
2012, the
in
Supreme
tracing
Court
the
issued a
alleged
temporary
accumulation of
restraining
unexplained
order in
wealth
PS
under
Bank
Article 2.
versus Senate
They
Impeachment
shall
Court,
be produced.
GR number 200-238, enjoining the Senate from
The
opening
defense
Chief
further invokes
Justice's
the 5-year
Corona
record
dollar
retention
accounts
period under
in
the
absence
AMLA
of a written
regulations
waiver of the depositor.
under the MLA regulations.
Insofar as the
5-year
request
period is
covers
a minimum
foreign currency
mandatory
deposits of the
retention
respondent,
requirement
her
imposed
spouse,
on
separately or
covered
jointly,
institutions,
as well as the
It is not
corporation
an
and
absolute
partnership. It
prohibition
is
against
denied.
keeping or producing
Such
all the
accounts
records.
shall be excluded
Accordingly,
unless and until a
let
written
AMLC
consent
invoke
of the
this
respective
limitation and its
depositor
return
is produced.
The court now turns
this
to the
court
records
shall
held
take
by the
into account and
MLC
inform the
or
parties
Anti-Money Laundering
thereon
Council
accordingly, should they be unable
As to the
comply
request
with the
directed to
subpoena.
the Anti-Money Laundering Council,
As for
the
the
same are
partnership
granted
of
with
Carpio
respect to the
lawyers,
19
Section 1 of
the
Republic
respondent,
Act
her
number
spouse,
10,
and the 19
365,
entities,
amending
and
Section
one
387
partnership,
of Republic Act number
for which a
9160,
prima facie connection has been
treats as
shown through the
covered
pre-marked
persons
general
those
information
including
sheets,
lawyers,
articles of
manage
partnership,
client money
and
or
the
assets
respondent's
managed
admitted
bank
balance.
savings
However,
and securities
the
accounts,
requests as to
organized
JTC
contributions
Group
for
of companies and
create,
Pikimong
operate, or manage
Philippines
judicial
Corporation
persons
are
or
denied
arrangements.
for failure at this
Section
stage to
2
establish a
CFMLC
prima facie
regulatory
link.
issuance B number
The
1 series of
respondent or her
2018
spouse
adopted
and
on May
the
10,
said
2018
entities
and
or
filed
any
on
sufficient
June 13,
basis to
2018
disregard their
expressly
separate juridical
reiterates
personalities as
activity
previously
based
stated.
rule.
The defense vigorously
The
argues
court
that the MLC is
recognizes the
absolutely
statutory
shielded
exception for
from
lawyers
this
acting
court's
as
compulsory
independent
process
legal
by the
professionals,
confidentiality
where the
provisions of
information
Section 80 of the
concerns their
Anti-Money Laundering
clients or
Act,
disclosure with
as amended
compromised
and
client
warranted compliance
confidences
would expose
or
AMLC
the
officers to
attorney-client
criminal
relationship.
sanctions for breach of
Absent any showing,
confidentiality.
however,
The
that
court,
the
however,
particular
finds this
records
argument unavailing.
contain such information
Section
or would
8A regulates
compromise a protected
unauthorized and
confidence.
arbitrary disclosures by
exception cannot
AMLAC
be
personnel
invoked merely because the
it does
entity
not
concerned is a
and
law
constitutionally
partnership.
cannot
It
nullify the
protects
lawful
client
subpoena
confidences.
powers of the
It
Senate,
does not confer a
sitting as an
blanket
impeachment
immunity
court
upon every
where
financial
compliance with
record
the lawful constitutional
bearing the law
subpoena is a
firm's name.
justifying circumstances. The request
That
for
if
the
at
issuance
all
of
would
subpoenas
extinguish
for the
any
identified
penalizability
financial records therefore
under
pertaining
Article
to
11,
Carpio
paragraph
lawyers is
6 of the
granted.
revised penal code for
Subject
any
to the
for any
remedies in
person
law
acting
and or
in
their
a
legal
legal
right
right
to
to
assert
assert
a
a
specific
specific
claim of
superior
privilege over
or
a
some
particular
lawful
document
purpose.
at the proper time.
In the landmark case
No
of Republic
generalized
versus
blanket
Ligon
invocation of
GR
lawyer of attorney-client
2322724
privilege
724
should
rather.
excludes compliance at this
The
time.
Supreme Court explicitly rejected
Therefore,
the
to summarize,
MLC's attempt
the
to
court
quash a
rules as
subpoena
follows.
ducis tecum, ruling verbatim.
The request for subpoenas
The
directed to the
Anti-Money
concerned
Laundering
banking institutions
Council is
covering
not
the
merely
accounts
a
of
repository of
respondent,
reports
attorney
and
Manases
information
Carpio,
uncovered and
separately or
suspicious
jointly.
transactions.
The partnership of
It was
Carpio
created
lawyers and the
precisely to
19 listed
investigate
corporate
and
entities
institute
is granted. The banks are ordered to submit to the clerk of court
Charges
the
against
documents
those
on July
suspected to
30,
commit money
2026
laundering
at 9 a.m.
activities. The criminal
with the
prosecution of
attendance
such
parties and
activities will be
counsels.
unduly hampered.
The request
If we were to
insofar as
prohibit
it seeks
it from
to-
disclosing
it
such
seeks the
information
records pertaining to
for the
JTC Group of
Anti-Money
companies and
Laundering
Pikimong
Council to refuse
Philippines
disclosing the
Corporation
information required
is
of it
denied
would be to
for
go
failing
against
to
the very
establish
function,
prima facie
its very
relevance.
function rather under
The
the law.
subpoenas granted shall
Further,
apply only
as held
to
by the Supreme Court in
peso-denominated
Sabio
accounts
versus Gordon,
relevant to
GR
Article
number
2.
174340.
Foreign currency deposits are
By
excluded
parity,
absent
explain
the
that
written
statutory
consent
provisions
of
of
the
the
respective
respective
depositors.
depositors.
And
The
exceptions from
subpoena directed to the
exemptions
Anti-Money
from
Laundering
inquiry
Council cover
cannot be
respondent
invoked
attorney
to deny
Manases
access to
Carpio
information
separately
by
and jointly with
Congress in
respondent.
aid of legislation.
The partnership of
It
Carpio
is therefore
lawyers,
the position
Carpio
of this court
lawyers,
that
and the 19 listed
if the
corporations
Sandigan
and
Bayan
entities
pursuant to
is
its
granted.
subpoena powers cannot be
The request
denied
insofar as it
MLC
seeks records pertaining to
as well as
JTC
the
Group of companies
legislature
and
in aid of
Pikimong
legislation.
Philippines Corporation
It
is
most certainly
denied
cannot be denied
for
to the
failing to
Senate
establish
sitting as
prima
an
facie
impeachment court.
relevance.
The defense defense also vehemently objects. Finally, the court is cognizant of the Supreme Court ruling in Almonte documents by pointing out to the agency's own stated that a government privilege against disclosure is recognized for intelligence purposes only, quote unquote, and it is not amiss to state that even matters of national security as evidence in any formal proceedings, inappropriate in-camera proceedings by the court. Therefore, the court ex abundante ad cautela or out
The
of an abundance of
admissibility and
caution hereby
evidentiary
directs
weight of documents
in
in an
order to
impeachment
prevent the
trial are
unwarranted
determined by the
exposure of sensitive
Constitution,
AMLC
the rules of
methodologies
court,
and
and the
information
judgment of the impeachment
to
court,
submit the records
not by
strictly in camera
unilateral
to the presiding
disclaimers
officer
printed
through
by
the
an
clerk of
executive
court
agency
first
on its letterhead.
on July 30,
An
2026 at
administrative
9 a.m.
footnote or
who
internal
shall review
intelligence
these
sharing
documents
protocol
privately before
cannot
turning them
rise
over
to the level of a
parties as
constitutional
may be
or
warranted.
statutory exclusionary
The
rule.
parties are directed to
While
be
the
represented by
MLC's internal
counsel on
protocols
the
are
aforementioned time
validly
and date
designed to prevent
for the
premature
proper
leaks during
inspection,
ongoing
comparison,
investigations.
photocopying,
They cannot
and
legally
or
operate to
marking
tie the
of
hands
these
of the impeachment
documents
court
as the
once
case
the
may be.
documents are lawfully
Sorted.
subpoenaed.
Because the
Moving
requested
now on-
suspicious transaction reports and covered transaction reports satisfy the threshold of prima facie relevance.
The impeachment court
in
will now
tracing
resolve the
alleged
prosecution's
accumulation of
request for the
unexplained wealth
issuance of
under Article
subpoena
2,
dated they shall
July
be
6,
produced.
2026, directed to the Commission or Internal Revenue.
The
At
defense
outset,
further
the presiding
invokes the
officer
5-year
reiterates
record
and adopts
retention
by
period
reference the
under
court
the
citation of
AMLA
applicable
regulations
rules
regarding the issuance of subpoena
under the
to
AMLA
sustain
regulations.
which forms an integral part of this
The
order.
5-year period is
The
a
foregoing
minimum
standards are
mandatory
deemed to
retention
produce
requirement
and shall govern the
imposed on
court's
covered
disposition of the
institutions'
present
subpoena requests.
It is not an absolute prohibition against
After
keeping or
examining the
producing
records
all
sought,
the
the court
records.
finds that the
Accordingly,
requested documents meet
let
the requirements
AMLC
set forth.
invoke
They are
this
reasonably
limitation
described,
and its
readily
return
identifiable,
rather,
and prima facie
which
relevant
this
in material
court shall
to the
take into
allegations under
account
Article
and
2.
inform the parties
However,
thereon
the court,
accordingly.
similarly,
Should they be unable to
requests
comply with the subpoena.
insofar as it seeks the
As
records
for
of
the
JTC
partnership
group of
of Carpio
companies,
lawyers, Philippine
Section
Senate
1 of
and
Republic Act
Philippines
number 10,
Corporation.
365, amending
The
Section
prosecution failed to
387
establish a
Republic
prima
Act number
facie nexus
9160,
between these entities.
treats as
So either the
covered persons
respondent
those
or
including lawyers
to her spouse
who manage client
The records
money
of
or
therefore
assets
do not at this
managed
time
bank
satisfy the
savings
requirement
and
of prima
securities
facie
accounts,
relevance under Rule
organized
21 of the Rules of Civil
contributions for
Procedure.
companies or create,
The
operate,
court
or
also
manage judicial
resolves the
persons
respondent's
or
objection to the
arrangements.
requested
Section
period
2 CFA
from 2007 to
B number 1 series of
2018
adopted on May
They
10,
anchor their
2018
opposition
and
on the
filed
Supreme
in
Court's
June 13,
pronouncement in
2018
Duterte v.
expressly
HOR
reiterates this
that the
activity
basis of any
based
charge
rule.
must be for impeachable acts or omissions committed
court
in relation to their
recognizes
office
the statutory
and during the
exception
current
for
term of
lawyers
the
acting
impeachable
as
officer.
independent legal professionals.
The argument
For
as
the
stated
information
earlier
concerns
fails because
their
first, the
clients or
documents
disclosure
requested
would
under the
compromise
subpoena to
client
sustain
confidences
will not
or
be
the
used
attorney-client relationship.
to allege additional
Absent any showing,
impeachable
however,
offenses
that the
this
particular
court
record
will
sought
not allow it.
contain such
For the
information
same
or would
reasons
compromise a protected confidence
discussed in the
the
court's
exception
earlier
cannot be
order
invoked
consistent
merely
with the
because
same
the entity
jurisprudence which
concerned
are
is a
hereby
law
adopted by
partnership.
reference.
It protects
The court
client
likewise
confidences.
holds that the
It does
requested
not
records
confer
are
a
sought to
blanket
establish
immunity
respondent's
upon
financial
every
baseline and
financial
capacity
record
only,
bearing the law
not
firm's
inquiring
name.
to or prosecute alleged
The request for
impeachable
the
acts
issuance of
occurring
subpoenas for the identified
outside the
financial
present
records therefore
articles of
pertaining to
impeachment.
Carpio lawyers is granted.
Accordingly,
Subject
these
to the
records are
remedies in
required to
law
establish a
and
factual
their legal
baseline
right to
against which
assert
the
a
respondent's
specific claim of
assets,
privilege
financial
over particular
transactions and
documents
business
at the
interests
proper
during
time.
her present term
No
may be
generalized
assessed.
blanket invocation of
We
lawyer
are also
of attorney-client
without,
privilege
not without precedent.
should exclude compliance
During the
at this
Corona
time.
impeachment trial, the SAL ends
Therefore,
prior to
to
his
summarize,
appointment as
the
Chief
court rules
Justice
as
in
follows.
2010 were presented
The request
on
for
the January
subpoenas
18,
directed to the
2012 hearing of
concerned
the court.
banking institutions covering the
Likewise,
accounts of
evidence and
respondent,
testimony
attorney
concerning
Manases
properties and
Carpio,
transactions
separately
before
or
his appointment
jointly,
as
the
associate
partnership
justice
of Carpio
were
lawyers and
presented
the
before
19
the court
listed
on
corporate
March 13,
entities is granted.
2012.
The banks are ordered to submit to the clerk of
Therefore, the
court the
production of
documents on
records
July
from
30,
2026
2026
to 2021 is therefore
with
allowed
attendance
and
of
authorized
parties and
strictly for
counsels.
purposes of
The
establishing
request insofar
a
as
comparative
it seeks
baseline
to,
only.
It seeks the records
They shall not
pertaining
be
to
used as
JTC
proof
group of
of
companies
another
and independent impeachable
Philippines
offense.
corporations
Is
Their
denied.
admissibility and
For
evidentiary
failing to
use shall
establish
remain
prima
subject to
facie
the
relevance.
prosecution establishing
The subpoenas
their
granted
connection to the
shall
alleged
apply only to
unexplained wealth
peso-denominated
during the
accounts
respondent's present
relevant to Article 2.
The defense's
Foreign
invocation
currency
of the
deposits are
Data Privacy
excluded
Act is likewise
absent the
unavailing.
written consent.
As previously
of the
stated,
respective
Section 16B of
depositors.
that law expressly
The
states that the right
subpoena
to privacy
directed to
does
the
not apply
Anti-Money Laundering Council
when personal
covering
information
respondent
is
is
needed
needed
pursuant
pursuant
separately
to
and
a
jointly
with the respondent.
Furthermore,
The partnership
Rule
of
5,
Carpio
Section
lawyers
22
to appropriate lawyers, and the 19 listed permits the processing of sensitive personal information. The request to government public authority pursuant to constitutional statutory mandate Philippines Corporation is denied protection of lawful rights and interests and court prima facie relevance. The court is likewise unconvinced by respondents' argument that the issuance of the subpoena will usurp the authority of the BIR under Section 5
Finally,
of the
the court is
NRC.
cognizant of the Supreme
This
Court ruling in
court is not
Almonte v.
determining the
Vasquez
tax
GR
deficiencies or civil
95367,
liabilities which
where it
remain
stated
within
that
the province of the BIR.
a government
It is
privilege against
exercising its
disclosure is
constitutional
recognized
mandate
with
to
respect
determine
to
public
state
accountability
secrets
under the articles
and
of
it is
impeachment.
not amiss to state
Neither
that even
the
matters
dependency
of
of
national
BIR audit,
security
suspend, or
have
limit
been
the Senate's
inquired into
exclusive
in appropriate
jurisdiction
in-camera
to try
proceedings by the
impeachment
court.
cases. Therefore, the respondent invokes section 270 of the National Internal Code to prevent hereby directs in order to prevent the unwarranted exposure of sensitive AMLC methodologies and
The Supreme Court
expressly ruled in submit the spouses Olivan GR 168771 clerk of court first section 270 on July 30, 2026 at 9 a.m. obviously does not address the confidentiality of ITRs. Over to the parties. It merely penalizes the unauthorized disclosure of taxpayer information except as otherwise provided for by law. It does not bar the production, comparison, photocopying, however, the respondent correctly invokes section 71 and other provisions of the NIRC which recognizes only three instances in which a taxpayer's records may be opened for inspection. Number one, upon order of the President or authorization of the President, the prosecution's request for the issuance of subpoena dated July 6, 2026 with approval of the President, Commission or Internal Revenue. Upon the taxpayer's waiver. At the outset, the presiding officer reiterates and adopts by reference the court citation of applicable rules regarding the issuance of subpoena to preclude the issuance of the requested subpoena. The foregoing issuance of subpoena is merely a preliminary procedural step and does not by itself authorize the disclosure, examining the records sought, or admission that the requested documents meet the requirements set forth into evidence described, readily identifiable, this issuance is the order that shall set under Article 2 all things in motion. The court, upon service, the BAR Commissioner may refuse compliance so far as it seeks the records of JTC Group of Companies or comply by invoking any of the exceptions under the NIRC as previously mentioned. The prosecution failed to establish a prima facie nexus between these entities compliance to either the respondent with any or the enumerated exceptions. The records sought therefore do not receive any subpoenaed records from the BAR relevance under Rule 21 similar of the Rules of Civil Procedure. Done when the sealed box. The court also resolved by this court to be objection to the requested period. There is also a precedent during the 2012 Corona impeachment trial. The Senate issued the subpoena and thereafter awaited the return of the BAR Commissioner. The requested records were produced only after the requisite presidential authorization had been obtained and during the current term of the impeachable officer under Section 71 of the argument, as stated earlier, fails because first, the documents requested under the court's no remedy. Will not the requested tax records are lawfully to allege additional any impeachable exceptions. This correspondent made the appropriate stage of the proceedings. For the same reasons, any and all objections concerning the relevant court's earlier order consistent with the same jurisprudence which are hereby adopted by reference. The court likewise holds that the requested records are sought to establish a ruling on the admissibility of the documents only, ultimately not to inquire into or prosecute alleged impeachable acts occurring. The subpoena shall therefore be issued and we shall await the return of the BAR Commissioner. Accordingly, at which time these records are required to establish a factual baseline against which the respondent's assets, accordingly, financial transactions and business interests during her present term, the request for the issuance of subpoena directed to Commissioner also without Carlito Martin R. Mendoza during the Corona impeachment trial, the summons prior to his appointment as Chief Justice in 2010. The records pertaining to JTC Group of Companies Inc. and Pikimong Philippines Corporation is hereby denied. Evidence and testimony concerning satisfy the requirement of prima facie appointment as Associate Justice. The Commissioner is directed to make the appropriate return to this court in accordance with the law 2012 on July 30, 2026 at 9 a.m. Therefore, the production of records from 2007 to 2021 is therefore allowed and authorized strictly for purposes of establishing the parties are likewise a comparative baseline by counsel. They shall not be used as proof for inspection, comparison, photocopyable offense, and or marking their admissibility and evidentiary use shall remain subject to the prosecution establishing their connection to the alleged unexplained wealth during the respondent's present term. We were seeking recognition earlier. The defense's invocation of the raise of the Privacy Act is likewise unavailing. As previously stated, Section 16B of that law expressly states that the right to privacy does not apply when personal information is needed pursuant to a subpoena.
There are parts,
Furthermore,
I'm talking about myself
Rule 5,
first,
Section
but I think
22F of
some
its
feel the
implementing
same
rules
way.
expressly permits the
There are some
processing of
parts that
sensitive
we
personal
agree, some
information
parts we disagree. For
provided to
example,
government, public
to
authority
subpoena
pursuant to a
the
constitutional or statutory
certain
mandate
records between
and when
2022
necessary
to
for the protection of
2026.
lawful rights and
In my
interests
case,
and court proceedings.
I agree with the know your
The court is
client,
likewise unconvinced by respondents'
opening
argument that the
balance.
issuance of the subpoena will
Just for
usurp the authority of the
reference, so that we
BAR
have a
under
starting
Section
point.
5
So,
of the NIRC. This court
may
is
I
not determining the
suggest that
tax
instead
deficiencies
of,
or civil liabilities which
objecting, I don't know
remain
if I'm
within the
alone or with
province of the
others,
BAR. It is exercising its constitutional mandate to determine
we
public
will-
accountability
I will
under
not
the articles of
manifest anymore,
impeachment.
but may I submit
Neither
in
does
writing,
dependency of a BAR audit suspend
which
or
parts
limit
of
the
the
Senate's
ruling I
exclusive
disagree,
jurisdiction
and if anyone wants
to
either
try
manifest
impeachment
or
cases.
submit in writing.
The
But I do
respondent
have one
invokes
question to the
Section 270 of
presiding
the
officer.
National
So you
Internal Revenue
narrated
Code to prevent the
everything.
production of the requested records.
In the page
The objection
2 of
is overruled in
the
part.
request for subpoena for...
The Supreme Court expressly ruled in Dipad v. Spouses Olivan, GR 168771, that
For-
Section 270, quote, of the NIRC obviously does not address the
004,
confidentiality of ITRs.
nakalagay,
It merely
all
penalizes the
records
unauthorized
filed
disclosure
with
of taxpayer
submitted to or
information,
maintained by the BIR
except
for
as
taxable
otherwise
year
provided for by
2007 to
law.
25,
It does not
including
bar
but
the
not
production of
limited
the
to.
documents.
So sinabi,
However,
1, 2, 3.
the respondent correctly invokes Section
1 and 2, pero
71
not limited to. The
and
other
other
one,
provisions of
4,
the NIRC which recognizes
page
only
4
three
of,
instances
the
in which a
request
taxpayer's
number
records may be
004,
open for
2026.
inspection.
Sorry, that's the
Number
case
one,
number.
upon
So the
order
other
of the
one is to
President or
the-
authorization of the President. Number two, upon the
one's to the
request of a
anti-money
foreign tax
laundering.
authority with the approval of
Nakalagay
the
po sa
President. Or
page
number
4,
three,
and all
upon the taxpayer's
other
waiver.
relevant documents.
Nevertheless,
So I just like to
the
ask,
existence of these
was
statutory
your narration
limitations does
exclusive?
not
Because
at
you
this
did say
stage
that
preclude the
it's
issuance of the
specific
requested
enough,
subpoena.
But I don't think specific
The issuance
yung
of subpoena is
all
merely a
other
preliminary
relevant.
procedural
The test
step
of,
and does not by
if it's
itself
definite is
authorize
that
the
wala nang
disclosure,
iisipin yung
inspection,
pinadala
or
ng
admission of the
subpoena.
requested
So kung ano
tax
nirarate,
records
yun ang
into
kukunin.
evidence.
That is
In
a
fact,
common practice, perhaps,
this
used by
issuance
lawyers, but
is the
understanding
order
of the
that
court,
shall
and let
set,
this be part
if
of the
at
ruling
all
of the
things
court,
in
is
motion.
that only the documents
Upon
specifically
service, the
mentioned
BIR Commissioner
Thank you
may
for that.
refuse
Will not
compliance,
include
very
that
much like
catch-all
what they
phrase,
did to the
because
House,
I doubt to if the banks,
or
the
comply
BIR,
by
MLC,
invoking any of the
would be
exceptions
able to
under the
supply
NIRC
and
as
such
previously
others,
mentioned,
unless it was specified.
without
With the
a
permission of the
satisfactory
court, I'll
showing of
submit
faithful
my-
compliance.
where I agree
Permission,
with the-
permission
any of
granted
the
and any other
enumerated
senator
exceptions.
judge who wished to submit
This court shall
the
not
written
receive any
explanation,
subpoenaed records
in
to the
regard
BIR,
to the twin orders may do
similar
so.
to what was done when the sealed box
Senator
ordered by this court
Judge
to be returned
Marcos and
to them.
Legarda are both raising their hands, so
There
the
is
same
also a
applies to them.
precedent during the 2012 Corona impeachment trial.
Submit.
The Senate issued a subpoena and thereafter
Senator
awaited the
Judges,
return of the BIR
Marcos,
Commissioner.
Legarda, and
The
Villar
requested
Camille
records were produced only
are
after the requisite
manifesting that they will be
presidential
submitting,
authorization had
their,
been obtained. One of the recognized
manifestations
exceptions
in
under
regard to the
Section
twin rulings
71
of
of
the
the
court,
NIRC.
and the same is
The
allowed and will be
respondent,
made
however,
part
is
of the
not without
records.
recourse nor remedy. In the event the requested tax records are lawfully produced pursuant to any of the statutory exceptions,
For the information of the
respondent
court,
may at the appropriate
yes,
stage of the
Senator
proceedings
Judge
raise
Pia
any and all
Cayetano,
objections
exactly. What is your
concerning their
pleasure?
relevance, materiality,
Presiding Officer,
authenticity,
just make a short
admissibility,
manifestation
and
because
other
The lady may proceed.
evidentiary infirmities.
Alan's written
The issuance of
submission might
subpoena
be so long,
should
might
not be
just be
construed
easier
as a
for me to
ruling
make
on
my
the
own
admissibility of the
manifestation.
documents ultimately produced.
Para tumawa naman kayo, guys.
On this
Sobrang
basis,
seryoso natin.
the
But it is a
subpoena
serious
shall
topic.
therefore be
Very
issued,
simply,
and
Mr.
we shall
President,
await the return of the
personally,
BIR Commissioner,
on the
at
issue
which
of
time
the,
the court
dates,
shall
no,
take
for the
such action as may
submission
be
of the,
deemed necessary and appropriate. Accordingly, in view of the
what was it,
foregoing,
2007?
the request for the issuance of subpoena directed to Commissioner Carlito Martin R. Mendoza of the BIR is hereby granted. The request insofar as it seeks the records pertaining to JTC Group of Companies, Inc. and Pigimong Philippines Corporation is hereby denied for failure to satisfy the requirement of prima facie evidence. The Commissioner is directed to make the appropriate return to this court in accordance with the law on July 30, 2026 at 9 a.m. before the Clerk of Court. The court shall await the return before taking any further action as may be warranted. The parties are likewise directed to be represented by counsel on the aforementioned time and date for inspection, comparison, photocopying, and/or marking as the case may be.
Considering the rights
So ordered.
of the person under trial, we could have
Senator
considered
Judge,
starting at 2022, and if
Alan
there's more
Cayetano is
than
recognized.
kung dun pa lang,
We were seeking
it already
Commissioner
shows that
ruling,
unexplained
the
from
presiding
22 to
officer, I won't ask you
2026.
to repeat it.
There may be no reason to go back and at least respect that
Because you explained both in the
part of
caucus
the
and
record.
here
So
that
yun lang
there are
naman ang
only
sa
two
akin. Kasi hindi
motions.
naman mahirap na tingnan yung 2022
There are
to
parts,
2026.
I'm talking about myself
Hindi mo
first,
makita yung
but I
baseline
think
pero may
some
trend.
feel the
Then
same
dun
way.
saka tayo pupunta doon.
There are
But
some
that's our
parts that
way
we
of
agree, some
showing
parts we disagree.
respect
For
also
example,
for the
to
persons who
subpoena
are
the
brought here to trial. But
certain
anyway,
records
we
between
submit to the
2022
ruling.
to
I just wanted to
2026.
explain
In my
that
case,
that could have been
I agree with the know
middle
your
ground, Mr.
client
Presiding Officer. Thank you.
opening
Noted and well
balance.
taken, Senator Judge Pia
Just
Cayetano.
for reference. so that
Chair
we
would
have a
now like to
starting
take up
point.
some
So,
administrative matters. We are
may
in receipt of a
I
motion
suggest
to
that
set
instead
conference
of,
for the transfer of markings and
objecting, I don't
comparison
know
of
if I'm
video
alone or
exhibits
with
filed by
others,
the prosecution. Since this was received only last
we will-
Friday, the court was not
I
able
will
to
not
act on it
manifest anymore, but may I
on their
submit in
requested
writing,
dates. Court therefore
which
sets
parts
this
of the
to
ruling I disagree,
July
and if anyone
21
wants to either
tomorrow
manifest
at 9
or
a.m.
submit in writing.
Due
But I do
notice
have
is
one
given to
question
both
to the
parties
presiding
for
officer. So
this
you
purpose.
narrated everything.
Likewise, the court is in
In
receipt,
the page 2
the presiding
of,
officer rather,
the request
as well as
for
the Senate
subpoena
President, of a
for-
letter of manifestation signed by Senator Judge Marcoleta,
for
citing a Rule in the era of impeachment trial and
004,
wanting his vote to be
nakalagay,
considered,
all records filed
Chair,
with, submitted to, or
the presiding
maintained by the
officer,
BR
this
for
court
taxable year
will not
2007
act
to
on it at
25,
this time,
including
but
but
instead,
not
since we will be
limited to.
resuming next week,
So sinabi,
we'll be
1, 2,
referring this
3,
matter to the Senate as a
1 and 2,
legislative
pero
body,
not
given that
limited
it's
to.
the
The
Senate
other
that will
one,
be amending
4,
the rules to
Page
allow
4 of, the
participation
request number
through a
004,
vote,
2026.
because apparently,
Sorry,
as
that's the
pointed
case
out
number.
by Senator
So the
Judge
other one is to the-
Marcoleta, during the Estrada
This
impeachment
one's to the
trial,
anti-money
a
laundering.
rule was adopted,
Nakalagay po
which we
sa
are
page
confirming,
4 and all
that
all
allows
other
the Senate
relevant
President to
documents.
provide a
So I'd just
mechanism
like
by
to
which
ask,
a
was your
senator who
narration
cannot vote
exclusive? Because you did say
under
that
any
it's specific
unavoidable
enough, but I don't
circumstances to
think
cast his
specific
vote
yung
on any
all other
matter.
relevant.
But
The
since
test
this
of,
impinges upon the rules of
if
the
it's
impeachment
definite
court,
is that wala nang
this matter
iisipin
should
yung
properly be
pinadala mo
taken
ng
up by the Senate
subpoena.
as a
So kung anong
legislative
nire-rate, yun ang kukunin.
body.
That is a common practice perhaps used by lawyers,
And
but the
whatever
understanding of the
decision
court,
the Senate
and that is be part of the ruling of the court,
will
is
have
that
as a
only the
legislative body,
documents
the
specifically
court
mentioned
shall implement.
Thank you for that.
and will
But let
not
it be
include
placed on
that
record that
catch-all phrase,
personally,
because I doubt to if the banks, the BIR, or
once
AMLC
we are convened
would
as a
be able to
once
supply
we convene the
that
Senate
and
as
such
a
others,
legislative
unless
body,
it was specified.
I'm
With the
inclined to
permission
agree
of the
with the
court, I'll
suggestion of
submit
Senator
where I
Permission,
disagree.
permission granted,
for
and
as
any
long as
other
there's no
Senator Judge
suspension
who wish
according
to
to-
submit
Yes, Senator Judge
the
Gaynor.
written
I'll not
explanation
object to that at this point
in
in
regard
time.
to the
Just
twin
as an
orders may do
additional
so.
information. I think Senator Estrada
Senator
elevated to the
Judge
Supreme
Marcos
Court
and
the
Legarda
denial
are
of
both
the
raising their
Sandigan
hands, so the
Bayan
same applies to
to
them.
allow him to attend. But may you also
Submit.
refer my previous
Senator
manifestation
Judges
that,
Marcos,
as a
Legarda,
court,
and Villar
we can
Camille
also
are
communicate whether it's
manifesting
with
that
the
they will be
Sandigan Bayan or
submitting
the, but if you're going to say it's going to be to the rules, that's not in
manifestations
conflict.
in regard to the twin
But
rulings
maybe
of
we
the
can
court,
take it up
and
whether in
the same
caucus,
is allowed
once
and
the
will be
Senate
made part
convenes.
of the records. The point of Senator Judge Allen is well taken. We shall do so at the appropriate time. Now, on
For the
other
information
matter,
of the court, Senator Judge
Senator Judge
Padilla is
Pia
recognized.
Cayetano is recognized.
What is your pleasure, sir?
Mr. Presiding Officer, I'll just make a short
Mahal na
manifestation because
The lady may proceed.
Tagapamahalang hukom.
Alan's written
Patungkol
submission
po
might
dun
be
sa
so long, it might just be
nangyari
easier for
na
me to
ruling.
make my own
Nais ko
manifestation.
lang po sanang magmanifesto.
The
Para tumawa
gentleman
naman
may
kayo,
proceed.
guys. Sobrang seryoso natin. But it is a serious
Ginong,
topic. Very simply, Mr. President. Personally,
Tagapangulo.
on the issue of the dates
At mga
no, for the
kasama.
submission of the...
Matagal ko na pong isinusulong ang freedom of information.
what was it? 2007?
Dahil ito po ay bumagsak
2007
sa aking komite.
2026. And the term of the
Ito po
Vice
ay
President
tunay
in question is
na kailangan natin.
2020.
Sapagkat
2020
dito
to
po talaga
2026.
natin mapapatunayan
my,
yung sinasabi
my humble
nating
position
public trust.
is, and I'm cognizant of the case
Pero,
that was cited
meron din po kasing
by the
napakahalaga
prosecution.
yung
I also found
tinatawag
that
na
my own research,
equal protection
the
of
presiding
the
officer
laws.
used it in the
Sang-ayon po
justification of
sa
the decision,
Artikulo
says that
3,
you-
Section 1 ng ating Constitution, Bill of Rights, ang nagsasabing
you
hindi
go
dapat
back to
alisan
set that
ng
baseline.
buhay,
And I
kalayaan
understand
o
that.
ari-arian
Madali
ng
naman
sinumang
siyang
tao
intindihan. Sa akin lang
ng
naman,
hindi
in the interest
kaparaanan ng
also
batas.
of considering the rights
Ipagkaitan
of the
ang
person
sinumang
under
tao
trial, we could
ng
have
pantay na
considered
pangangalaga
starting at
ng
2022 and if there's more than kung dun pa
Ang mga
lang, it
pamantayang
already
ginagamit
shows that
natin ngayon ay
unexplained from
dapat
22 to
pareho ring
2026.
ipinatutupad
There
sa
may be no
lahat
reason to
ng
go back
impeachable
and at least
officials,
respect that,
anuman ang kanilang pangalan
part
o
of the
posisyon.
record. So yun lang naman ang sa akin kasi
Hindi
hindi
ko
naman
po
mahirap nating na yung 2022
makakalimutan
to 2026.
ang naging pahayag
Hindi mo makita yung baseline
ng
pero
dating
may trend.
Senadora
Then dun, saka tayo
Miriam
pupunta doon.
Santiago
Diba? That's
dito
our way of
mismo.
showing respect also for
Siya
the
po ay
persons
isang
who are
huwes
brought
at
here to trial.
ginagalang na
But
propesora
anyway,
ng
we submit
batas.
to the ruling.
Ang
I
sabi
just
niya,
wanted to explain
constitutional
that could have
analysis
been
is a
middle
technical
ground,
field.
Mr. Presiding
Ang
Officer.
pagsusuri sa
Noted and well taken,
konstitusyon
Senator Judge
ay
Pia
hindi
Cayetano.
isang sining.
Chair would
Isa
now like to
itong
take up some
technical na
administrative
larangan.
matters. We are in receipt of a
Hindi
motion
po
to set
dapat ito
conference for the transfer of
ini-interpret
markings and
ng
comparison of video exhibits
basta-basta
filed by the prosecution. Since this
Kailangan
was received
may due
only last
process.
Friday, the court was not able
Nung
to
una
act
ko
on it
pong narinig
on their
kanina,
requested dates.
na
Court
ipaliwanag
therefore
po
sets
ng ating
this
Senator
to
Judge
July
Alan
21
Peter
tomorrow at
Cayetano,
9 a.m.
tinanong
Due
sa
notice is given to
prosecution
both
kung
parties
ganito
for
rin
this
ba
purpose.
ang ginawa
Likewise,
nila
the court is in
noong
receipt.
may impeachment
The presiding officer, rather, rather,
kay
as well as the
Presidente
Senate
Bongbong
President, of a letter of manifestation
Napakalinaw
signed
po
by Senator
na ang sagot
Senator
nila ay
Judge
hindi naman sila
Marcoleta,
nagtanong.
citing a rule
Hindi sila
in the era of impeachment
nagtaliksik.
trial and
Kung
wanting his
paano
vote
ang ginagawa nila ngayon
to be considered.
sa pangalawang Pangulo.
Chair,
Ang
the
akin po
presiding
lamang,
officer in this court
will not act on
Makatarungan
it at
ba
this time,
na
but instead, since we will be resuming next week,
Hindi parehas
we'll
ang
be
trato
referring
natin
this
dito.
matter to the
Dapat
Senate
sana
as a
parehas.
legislative body, given that it's the
Kaya
Senate
po,
that
ang
will be
hinihiling
amending the
ko,
rules to allow
sa atin,
participation through
total
a
naman,
vote. Because
lahat naman
apparently,
kayo
as
ay
pointed out by
sumang-ayon na
Senator
sa
Judge
freedom of
Marcoleta,
information
during
bill
the
ko.
Estrada impeachment
Hindi pa nga lang
trial, a
nagsasubmit
rule was adopted,
ang
which we are confirming, that allows
House
the
of
Senate
Representatives.
President to provide a mechanism by
Bakit
which
kung ganito ang
a
pamantayan
senator
natin,
who
hindi buksan
cannot
na natin
vote
lahat ng bank records
under
natin.
any unavoidable
Lahat na.
circumstances to cast his
Tayong
vote
lahat
on any
ay
matter.
buksan na natin
But
lahat.
since this impinges upon
Para
the rules of the
mapakita
impeachment court, this matter
sa taong
should
bayan
properly
na
be
wala
taken
tayong
up by
kinikilingan
the
dito.
Senate as a legislative body.
Ito ay oras
And
na
whatever decision the Senate
para
will have as a
samantalahin
legislative
natin ang
body,
pagkakataong
the
ito
court
na
shall
ipasa yung
implement
FOI.
it. But let it be placed on record
Kasi
that
kung
personally,
ganito, na parang meron tayong
once we are
tinititigan sa
convened as a
tinitingnan,
once we convene the Senate as a legislative body,
Hindi maganda ito para sa
I'm
taong
inclined to
bayan.
agree with the suggestion
Tandaan
of
po
Senator
natin, pantay-pantay
Marcoleta,
tayo
for as long as
sa
there is no
harap
suspension
ng Diyos
according to
at ng
him. Yes,
batas.
Senator Judge Cayetano.
I'll not object to that
At
at this
hinihingi
point
ko
in
po sa
time.
inyo
Just as an additional
na ilagay sa
information,
record
I think
ang aking
Senator
pagtutol
Estrada elevated to the Supreme
sa
Court the
ruling na.
denial of the
Maraming
Sandigan
salamat.
Bayan
For
to
the
allow
record,
him to attend. But
there is a pending bill
may
as
you
well
also refer
requiring
my
all public
previous
officials filing a SAL-N
manifestation that
to execute
as a court,
waiver
we can
in favor
also
of
communicate
relevant
whether
government
it's with the
agencies
Sandigan Bayan or the,
together
but if
with
you're going to say
their
it's going to be
SAL-N.
to
On
the rules,
top,
that's
in
not in
addition of
conflict.
the FOI bill
But
filed
maybe we
by
can
the
take it up
Honorable
whether in
Padilla
caucus
na tinatalakay
once
din
the
po natin
Senate
sa ngayon.
convenes.
The
Before
point
proceeding,
of Senator Judge Allen is well
on
taken.
one more
We
matter,
shall
may I
do so at the
inquire from the
appropriate
lead
time.
prosecutor or someone from the
Now,
panel of
on other
prosecutors,
matter,
Senator
who
Judge
the intended
Padilla
witnesses
will be
recognized?
for tomorrow
What is your pleasure,
and
sir?
Tuesday.
Mahal na
Sorry, tomorrow and Wednesday.
Kapamahal
Forgive
ng
me.
hukom, patungkol po doon sa nangyaring ruling, nais ko lang po sanang
Your
magmanifesto.
Honor,
The
our
gentleman may
intended
proceed.
witness for tomorrow is Attorney
Yun ang,
Melvin Matibag, the NBI Director.
Tagapangulo.
And for Wednesday, Your Honor, it will be Marivic
At mga
Pareha
kasama.
of the Legislative
Matagal ko na
Archive
pong
Office of the House
isinusulong
of
ang
Representatives,
freedom
Your
of
Honor.
information.
And on Wednesday,
Dahil ito po ay bumagsak
the bank
sa
officials?
aking komite.
In addition,
Ito
Your
po ay
Honor, but
tunay
considering
na
that
kailangan natin.
we only have Tuesday and Wednesday for
Sapagkat
trial,
dito po
but
talaga
after
natin
Marivic
mapapatunayan
Pareha,
yung
we will
sinasabi
also be
nating public
presenting
trust.
the two land bank officials,
Pero,
Your Honor.
Yes, because we issued
Meron din po
we issued a
kasing
subpoena at
napakahalaga yung
testificandum
tinatawag na equal
against these two
protection
bank
of the
officials to
laws.
attend tomorrow and Wednesday.
Sang-ayon po sa
Yes,
Artikulo
Your Honor.
3, Section 1
So
ng
for the
ating
information
Constitution, Bill
of the two
Rights,
bank officials,
ang
if they
nagsasabing,
are listening,
hindi dapat alisan
they may simply attend
ng
the
buhay,
Wednesday
kalayaan o ari-arian
trial,
ng sinumang tao
not the
ng
trial
hindi
tomorrow. Although the subpoena
kaparaanan ng
indicates
batas.
tomorrow
Ni pagkaitan
and Wednesday.
ang sinumang
Would that
tao
be okay, Counsel for
Yes,
the
Your
ng
Honor.
Panel for
pantay na
Procedures? Lead proceed,
pangangalaga
rather?
ng batas.
Yes.
Ang mga
So, Attorney
pamantayang
Melvin Matibag
ginagamit natin
tomorrow,
ngayon
and
ay
if at
dapat
all, Ms.
pareho
Marivic
ring
Pareha and Ms.
ipinatutupad
Marivic
sa
Pareha, the two
lahat
bank
ng
officials on Wednesday.
impeachable officials.
Counsel for the respondent, ma'am?
Anuman ang kanilang
What is your pleasure,
pangalan
ma'am?
o
May I be
posisyon.
recognized, Your Honor?
Yes, ma'am.
Hindi ko po
This is regarding what matter, ma'am?
Just two
makakalimutan
administrative
ang naging
matters, Your
pahayag
Honor. The
Please,
first
ma'am.
one with
ng
respect to
dating
the
Senadora
motion to set
Miriam
conference for the
Santiago
transfer of
dito
marking
mismo.
and comparison of video exhibits.
Siya po ay isang buwes
We would
at
also
ginagalang na
like
propesora
to
ng
request
batas.
that the
Ang sabi
respondent
niya,
be allowed
constitutional
to also mark
analysis
additional
is a
documents
technical
at the
field.
appointed time.
Ang
tomorrow.
pagsusuri sa konstitusyon
In effect,
ay
we're
hindi
asking
Also
the
isang
same
sining.
latitude. Yes,
Isa
Your
itong
Honor.
technical na larangan.
In fact, some of the documents that we intend
Hindi
to mark
po
tomorrow
dapat
would be
ito
also our
ini-interpret
copies of
ng
some of the
basta-basta
listed
o
items in this motion, Your Honor.
Kailangan may due process.
Of course, that
Nung
motion
una ko
already
pong
made
narinig
by Counsel for
kanina,
Respondent is hereby
naipaliwanag
granted.
po ng ating Senator
The
Judge
respondent, in similar
Alan Peter
fashion to the
Cayetano,
prosecutor, may
tinanong
also
sa prosecution kung ganito
or
rin ba
change the markings or mark
ang
any
ginawa
pieces
nila
of evidence they wish to
nung
do
may
so
impeachment
in order to facilitate the
kay
trial.
Presidente Bongbong
Thank you, Your
Marcos.
Honor. And just to
Napakalinaw
place
po
on record
na ang
the
sagot
additional
nila
marking
ay hindi
of
naman sila
evidence and whatever transfer of
nagtanong.
markings that the prosecution
Hindi sila
will do tomorrow
nagsaliksik
is without prejudice
kung
to
paanong
Section 3
ginagawa nila
Administrative
ngayon
Matter number 2026
sa pangalawang Pangulo.
001 of this
Ang
impeachment
akin
court
po
with
lamang
respect to to the guidelines
Makatarungan
for the conduct of the
ba
pre-trial
na
conference. which
Hindi
explicitly
parehas ang
states
trato
that
natin dito.
the marking
Dapat sana
is without
parehas.
prejudice to any questions on
Kaya po, ang
admissibility,
hinihiling ko,
relevance,
sa atin,
etc., Your Honor.
That is the
total
understanding,
naman,
Counsel. Yes.
And
lahat
the second
naman
matter,
kayo
Your
ay
Honor.
sumang-ayon na
Second
sa
matter, Your Honor, with respect
freedom
to
of
the earlier
information
ruling given by this
bill ko.
court on
Hindi
the
pa nga lang
request for
nagsasubmit
subpoena, Your Honor, the
ang
defense request for certified true copy
House of
that ruling, Your
Representative.
Honor. Thank you.
Bakit
Chair will
kung
address
ganito ang
that. It will be
pamantayan natin,
included
hindi buksan
in
na
the
natin lahat
journal.
ng bank records
However,
natin.
the journal will have
Lahat
to
na.
await the manifestations
Tayong
to be
lahat
submitted
ay
by any
buksan
senator
na natin,
judge who may
lahat.
agree or disagree with the
Para
ruling.
mapakita
So we might not be able to approve
sa
the
taong
journal
bayan na
tomorrow,
wala
although we
tayong
will do as
kinikilingan
best
dito.
as we can. But as soon as the journal is approved, we shall
Ito ay oras
make
na
it available. But the TSN
para
can be made available
samantalahin
perhaps by
natin ang
tomorrow.
pagkakataong ito na ipasa yung FOI.
Your Honor, may I make a
Kasi kung
short
ganito,
manifestation with regards
na
to
parang
the
meron
order
tayong
of presentation,
tinititigan
Your
sa
Honor,
tinitingnan,
earlier mentioned by the prosecution?
Hindi maganda
Of
ito para
witnesses?
sa taong bayan.
Yes, Your Honor.
Tandaan po
Subject to
natin,
the limitation
pantay-pantay
mentioned by
tayo
Senator Judge Allen
sa harap
the other
ng Diyos at
week,
ng
if you
batas.
remember,
Yes, Your
Counsel.
Honor, I understand.
At hinihingi ko
Lady,
po
may
sa
proceed.
inyo
We are
na
maintaining
ilagay
the
sa record
presentation of
ang
NBI
aking
Director
pagtutol
tomorrow, that is Tuesday, July
sa ruling na
21.
ito.
And
Maraming
then
salamat.
following
For the record,
NBI Director, Your Honor, will
there
be
is
the
a pending
two
bill as well
land bank
requiring all public
managers
officials filing
in the
a
person
SAL-N
of Violeta
to
San
execute a
Constantino
waiver
of Shaw Branch,
in
Shaw
favor
Branch
of relevant
Manager,
government
and
agencies
Benita Camposano
together with their
of DepEd
SAL-N on
Branch
top
Manager.
and in addition of
As
the
to the
FOI bill
presentation of
filed by the
the
Honorable Padilla. na
Legislative
tinatalakay din po
Archive
natin sa
Officer,
ngayon.
we will be determining the
Before
appropriate
proceeding
time when to present
on
her,
one more
Your Honor.
matter,
So
may I
the
inquire
court,
from the lead prosecutor,
recalls or
someone from the
withdraws
panel
the
of
earlier
prosecutors,
statement
that the two bank
their
officials may
intended
appear on
witnesses
Wednesday.
will
The
be for
subpoena
tomorrow
stands therefore,
and Tuesday.
requiring their appearance to respond to the subpoena.
Tomorrow and Wednesday.
Tomorrow, forgive me, July 21 and July 22.
We confirm, Your Honor. Your
So
Honor,
noted.
our intended
Any other
witness
matters
for
that
tomorrow
any of the
is
parties wish to
Attorney
raise?
Melvin Matibag, the NBI Director. And for Wednesday, Your Honor,
There
it will
being
be
none,
Marivic Pareja of the Legislative Archive Office of the House
Since
of
we did not have a
Representatives, Your
break,
Honor.
and on Wednesday, trial is hereby adjourned
bank
until
officials?
July 21,
In addition, Your
Tuesday
Honor, but
at
considering that
2 p.m.
we only have Tuesday and Wednesday for trial, but after Marivic Pareja, we will also be presenting the two land bank officials, Your Honor.
Yes, because we issued a subpoena ad testificandum against these two bank officials to attend tomorrow and Wednesday.
Yes, Your Honor.
So for the information of the two bank officials, if they are listening, they may simply attend the Wednesday trial, not the trial tomorrow, although the subpoena indicates tomorrow and Wednesday. Would that be okay, Counsel for
Yes, Your Honor.
panel for prosecutors, lead prosecutor rather? Yes. So Attorney Melvin Matibag tomorrow, and if at all, Ms. Marivic Pareja and Ms. Marivic Pareja, the two bank officials on Wednesday. Counsel for the respondent, ma'am.
Good afternoon, Your
What is
Honor.
your pleasure, ma'am?
May I be recognized, Your Honor?
Yes, ma'am. This is regarding what matter, ma'am?
Just two administrative matters, Your Honor. The
Please,
first
ma'am.
one with respect to the motion to set conference for the transfer of marking and comparison of video exhibits. We would also like to request that the respondent be allowed to also mark additional documents at the appointed time tomorrow. In effect, we're asking
Also
for the
at 9
same
o'clock.
latitude. Yes, Your Honor. In fact, some of the documents that we intend to mark tomorrow would be also our copies of some of the listed items in this motion, Your Honor.
Of course, that motion orally made by counsel for respondent is hereby granted. The respondent, in similar fashion to the prosecutor, may also mark or change the markings or mark any pieces of evidence they wish to do so in order to facilitate the trial. So ordered.
Thank you, Your Honor. And just to place on record the additional marking of evidence and whatever transfer of markings that the prosecution will do tomorrow is without prejudice to Section 3, Administrative Matter Number 2026-001 of this impeachment court with respect to the guidelines for the conduct of the pretrial conference, which explicitly states that the marking is without prejudice to any questions on admissibility, relevance, etc., Your Honor. Honor.
That is the understanding, Counsel, yes.
And the second
The
matter,
Chair
Your
confirms that.
Second matter, Your Honor, with respect to the earlier ruling given by this court on the two requests for subpoena, Your Honor, the defense request for certified true copy of that ruling, Your Honor. Thank you.
Chair will address that. It will be included in the journal. However, the journal will have to await the manifestations to be submitted by any senator judge who may agree or disagree with the ruling. So we might not be able to approve the journal tomorrow, although we will do as best as we can. But as soon as the journal is approved, we shall make it available. But the TSN can be made available perhaps by tomorrow.
Thank you, Your Honor. That's all, Your Honor.
Your Honor, may I make a short manifestation with regards to the order of presentation, Your Honor, earlier mentioned by the prosecution?
Of witnesses?
Yes, Your Honor.
Subject to the limitation mentioned by Senator Judge Allen the other week, if you remember.
Yes, Your
Counsel?
Honor, I understand.
The lady may proceed.
We are maintaining the presentation of NBI Director tomorrow, that is Tuesday, July 21. And then following the NBI Director, Your Honor, will be the two land bank managers in the person of Violeta San Constantino of Shaw Branch Manager and Denita Camposano of DepEd Branch Manager. As to the presentation of the Legislative Archive Officer, we will be determining the appropriate time when to present her, Your Honor.
So the court recalls or withdraws the earlier statement that the two bank officials may appear on Wednesday. The subpoena stands, therefore, requiring their appearance to respond to the subpoena ad testificandum tomorrow, July 21 and July 22.
We confirm, Your Honor.
So noted. Any other matters that any of the parties wish to raise? There being none, since we did not have a break, trial is hereby adjourned until July 21, Tuesday at 2 p.m. Pero umaasa ako.
Kita ni Jesucristo, amin. Sa ngalan ng Ama at ng Anak, ng Espiritu Santo, amin.
Swagat.
The Senate President, the presiding officer of the impeachment court, and the senator judges.
The clerk of court will now call the roll.
Roll call of members. The Honorable Senator Judge Aquino, Senator Judge Cayetano Alan, Senator Judge Cayetano Pia, Senator Judge De La Rosa, Senator Judge Ejercito, Senator Judge Estrada, Senator Judge Go, Senator Judge Ontiveros, Senator Judge Lacson, Senator Judge Lapid, Senator Judge Legarda, Senator Judge Marcoleta, Senator Judge Marcos, Senator Judge Padilla, Senator Judge Pangilinan, Senator Judge Soto III, Senator Judge Tulfo Erwin,
The
Senator
Sergeant
Judge
at Arms is
Tulfo
directed
Rafi,
to make a proclamation.
Senator Judge Villanueva, Senator Judge
All
Villar
persons are
Camilo,
commanded to keep silent
Senator Judge Villar
under pain
Mark,
of penalty while
Senator
the
Judge
impeachment
Zubiri.
court is in session
The presiding officer,
for the
Senator
trial
Judge
of
Escudero.
Vice President
Senate
Sara
President
Zimmerman
Gatchalian.
Duterte.
With 20 senators present, the chair declares the presence of a quorum. In accordance with the rules of procedure on impeachment trials, the chair now recognizes the duly elected presiding officer to preside over the proceedings of the impeachment court.
We shall be led in
Thank
prayer
you,
by
Mr.
Senator Judge
Senate President.
Christopher Bongo.
Before recognizing Senator Judge Padilla, Chair would first like to dispense with the journal. If there are no objections, we dispense with the reading
Almighty
of the journal
and
of
loving
July
God,
15,
O Allah,
2026.
We come before you
Of
today
the Senate
with
sitting as an
humility,
impeachment court, and
mindful
shall
of the
consider the
solemn
same
duty
as
entrusted to
approved.
us and the weight of the decisions that lie ahead.
The clerk of court will please call the
Grant
matter
us
before the
wisdom
impeachment court.
to discern
Case number
what is right,
004-2026 in the
courage
matter
to
of
uphold the
impeachment
truth
trial of Vice
and
President
fairness
Sara
in every
Zimmerman
judgment
Duterte.
we make.
Appearances for the parties.
Keep us from prejudice, anger,
Appearances for the prosecution.
personal interest, and political pressure. Help us listen with patience, speak with honesty,
Good
and
afternoon,
act
Your
according
Honors.
to
Same
conscience,
appearance for the prosecution. We are ready, Your
and the
Honor.
welfare of the Filipino
Appearances for
people.
the respondent.
Good afternoon,
Gabayan
Your
ninyo
Honor.
kaming
Same
lahat
appearance for the
ng may
respondent accused.
tungkulin
Thank you,
sa
Your
mga
Honor.
pagdinig na ito.
Noted. Senator Judge Padilla,
ang
sir,
bawat
what is your
panig
pleasure?
ay mabigyan ng pagkakataong marinig, ang bawat
Maraming salamat
ebidensya
po
ay
sa ating
mapag-aralang mabuti, ang
tagapamahalang
bawat
hukom
pasya
at
ay
sa ating
nakabatay
pong
sa
Ginoong Pangulo.
katotohanan,
Nais ko lamang
katarungan,
pong basahin
at
ng
tamang
napakaiksing
proseso.
manifestasyon po.
Remind
gentleman
us
may
that
proceed with his
public
manifestation.
office is a
Maraming
sacred
salamat po.
trust. May
A'udhu
we
billahi minash
never
shaitanir
lose
rajim.
sight of the
Bismillahirrahmanirrahim.
people whose lives are
Alhamdulillah rabbil
affected
alamin.
by our words,
Ah,
our actions, and our
Aming mga
decisions. Let the
kasama,
pursuit of
ako
truth
po'y humihingi
strengthen
ng
our
paumanhin
institutions
sapagkat
and deepen our commitment to
ito
serve with
pong nakaraang
integrity
linggo,
and
lumabas
compassion.
po sa mga
Lord,
balita na
Bring healing to our nation.
may
Where
aligasyon
there is division,
na ako daw po
grant us
ay
understanding,
hindi sumusunod
patience,
sa
and
batas.
unity. Where there is
Ito po
distrust,
ay
restore faith.
nakalulungkot
Where there
para
is
sa
fear and
isang
anger,
senador,
give us calmness
sa isang
and restraint.
senator judge ang masabihan
When these proceedings
na
are
hindi
concluded,
sumusunod sa batas.
help us move forward
Samantalang nung
together.
tayo po ay
Naway
merong
makabalik na kami sa aming pangunahing tungkulin,
mahal na
ang
saksi dito.
magserbisyo at maglingkod sa ating mga
Pinaalala po
kababayan.
natin sa kanya na
Naway
harapin
maituon naming
ang
muli
batas.
ang aming buong pansin
Noong
sa
nakaraang
paglilingkod
linggo, ang
sa ating
ating
mga
pong
kababayan,
kaibigan na ombudsman,
lalo na sa mga higit na nangangailangan.
Ang sinabi po ng
Lastly,
mahal na ombudsman
may the
na
Philippine
ako daw
Senate
po
remain united
ay
in fulfilling its
hindi
role
sumunod
as
sa
the
kanilang
last
pasabi
bastion of
na
democracy.
mag-file
Within these halls,
ng aking
may truth
counter
prevail
affidavit.
and the true voice of the
Nakakalungkot po ito
Filipinos be heard.
sapagkat hindi po ito
May
totoo.
compassion for others be a
Inaamin ko
steadfast
po sa inyo
virtue
kung ICC lang,
we live by in our words
hindi po talaga
and
ako
in
susunod.
our actions. And may we, your senator
Hindi ako
judges,
magpapasakop sa
be
ICC.
instruments of
Pero
your
dahil
grace
ginagalang
in the
ko
pursuit
po ang
of peace,
ombudsman,
justice, and
dahil
the
siya
common
po
good.
ay aking kaibigan,
All this we
na
ask
itinuturing,
in your holy name. Amen.
dahil nagkaroon na po kami ng napakahabang kwentuhan sa aking opisina
Roll
nung
call of
siya po
members.
ay kalihim
Senator Judge
ng
Aquino.
hustisya.
Senator Judge Cayetano Alan.
Nag-file po kami.
Senator Judge Cayetano Pia.
Ito po, hawak ko po
Senator
ang
Judge De La
original.
Rosa. Senator Judge
Dahil sa
Ejercito.
akin po,
Senator Judge
importante
Estrada.
ang original.
Senator Judge Go. Senator Judge
Ito po ang
Ontiveros.
original, nakalagay
Senator
po
Judge
dito.
Lacson.
Nag-file ako.
Senator Judge Lapid. Senator Judge
Nakalulungkot
Legarda.
po
Senator
na
Judge
pati
Marcoleta.
ang media
Senator Judge Marcos.
ay nakikisama
Senator Judge
sa ganitong
Padilla.
klaseng
Senator Judge Pangilinan.
propaganda
Senator Judge Soto III.
na ang
Senator
isang
Judge
senador ay hindi
Tulfo
sumusunod
Erwin. Senator
sa
Judge
batas.
Tulfo Rafi.
Isang senator
Senator
judge.
Judge Villanueva.
Ito po,
Senator Judge
maaari ko po
Villar
kayong
Camilo.
bigyan ng
Senator Judge Villar
kopya,
Mark.
mga mahal kong
Senator
kasama,
Judge
para
Zubiri.
mapatunayan
The presiding
na hindi ko
officer,
po
Senator
kayo
Judge Escudero.
ilalagay sa
Senate
kahihiyan.
President Gatchalian.
Ako po ay nag-submit ng aking counter
I don't know, but
affidavit.
he literally uses
At
Excel.
ganun din po, humihiling din po ako sa aking mga
You
kasama,
must be the new analyst.
lalong-lalo na po sa aking kaibigang
Sixth floor,
Ginoong Pangulo,
the team is quite
na
dynamic.
sa mga ganitong pagkakataon, hinihingi ko po na tulungan din po ninyo
10 years in the industry, different
na
company.
maipaliwanag din po namin
Excel,
sa media
PowerPoint, the usual.
na meron din po kami
There's an analysis. Full
mga
debt, client ready by
pagkakataon na
Friday.
ipagtanggol din ang aming
what's your
sarili
approach to
at
client
kami wag
analysis?
husgahang
I start with
kagad
the data, build the model,
na kami hindi
cross-reference.
How long
sumusunod
does that
sa
take
batas.
3 days
Yun
for
lamang
something
po,
thorough.
Diana,
Ginoong Pangulo
how long
at
for you? 4 hours.
tagapangulong
We'll talk after the meeting.
hukom. Maraming salamat.
Senators
I'm going to be
Erwin
honest with you.
Tulfo, Senator
Your
Judge
experience is
Alan
real,
Cayetano,
but the
thereafter
way you
Senator
work is 10
Judge
years behind.
Tito
AI
Soto
tools, this team
are
operates
recognized. What is your
differently.
pleasure,
Automation,
Senator
speed.
Judge Erwin
I can
Tulfo?
learn.
You have 2 weeks to
Mr.
show
Presiding
me.
Officer,
I'd hate
Senate
to let
President,
someone with your background
ladies
go,
and gentlemen,
but I will.
this
First week?
impeachment court
That obvious?
was established
I've seen that
to
look
try
before.
the Vice
Caroline
President of
gave
the
you the 2-week
Republic.
speech. Was I that loud?
Ang punto ko
Walls
po
are thin.
rito,
10 years of experience and I'm 3 times slower
kasi
than a 30-year-old.
napapansin
Not
ko po
slower.
ilang araw na nagagamit po
tools.
natin
Same thing.
ang
No, it's
impeachment
not.
court.
I was
Ang
exactly where
oras
you are
po
2
ng
years ago.
impeachment court
Same speech
sa
from Caroline,
pagpapaliwanag.
same feeling.
Naintindihan
What
ko
did
po
you
ang
do?
posisyon ng
Found
aking
this app.
kaibigan, si Senador Robin
Coursive.
Padilla.
AI
Yung kanya
tools, right
pong
tool for each task.
ika nga,
28 days,
frustrations.
15 minutes a day. My output tripled. Caroline
Pero
hasn't mentioned the
gusto ko lang
2-week
po sa
speech since.
ipaalala sa ating presiding
here.
officer, sa ating
I'm
pong
still
Senate
here.
President.
You have 10 years they don't
Matanong,
have.
ano po ba ang
Add the
ating
right tools.
ginagamit
Nobody in
na
that room
rules
touches
ngayon?
you.
O pwede po ba yung mga problema po
Ang karunungan.
The Sergeant at Arms is directed to make a proclamation.
All persons are commanded to keep silent under pain of penalty while the impeachment court is in session for the trial of Vice President Sara Zimmerman Duterte.
The impeachment trial of Vice President Sara Zimmerman Duterte is hereby called to order. We shall be led in prayer by Senator Judge Risa Hontiveros.
Sa ngalan ng Ama, ng Anak, ng Espiritu Santo. Amen. Ama naming Diyos, pinupuri ka namin, Panginoon ng langit at lupa, ang pinagmumula ng lahat ng karunungan, katotohanan at hustisya. Sa Ebanghelyo ngayong araw, ipinaalala sa atin ni Jesus na ang tunay na karunungan ay ipinagkakaloob sa mga may mapagpakumbabang puso. Sa pagpapatuloy ng mga pagdinig o paglilitis na ito, hinihiling namin ang iyong gabay. Pagkaloob niyo sa amin, ang mga senator judges, ang karunungan na matukoy ang katotohanan, pagpapakumbaba na makinig ng may bukas na isip, at lakas ng loob na gawin kung ano ang tama ayon sa aming konsensya at ang rule of law. Palayain niyo kami sa pagmamayabang, prejudice, at lahat ng klaseng impluensya na maaaring pagpalabo sa aming paghuhusga. Naway manaig ang katotohanan, katarungan, at ang kabutihang panlahat sa bawat desisyong aming gagawin. Naway ang inyong espiritu ay gumabay sa amin na maglingkod ng may integridad, katapatan, at pagmamalasakit, laging sinasaisip na ang pinakamataas naming responsibilidad ay sa sambayan ng Pilipino at sa katotohanan. Hinihiling namin ang lahat ng ito sa pamamagitan ni Jesucristo. Amen. Sa ngalan ng Ama at ng Anak, ng Espiritu Santo. Amen.
The Clerk of Court will now call the roll.
Roll call of members. The Honorable Senator Judge Aquino. Senator Judge Cayetano Alan. Senator Judge Cayetano Pia, Senator Judge De La Rosa, Senator Judge Ejercito, Senator Judge Estrada, Senator Judge Go, Senator Judge Ontiveros, Senator Judge Lacson, Senator Judge Lapid, Senator Judge Legarda, Senator Judge Marcoleta, Senator Judge Marcos, Senator Judge Padilla, Senator Judge Pangilinan, Senator Judge Soto III, Senator Judge Tulfo Erwin, Senator Judge Tulfo Rafi, Senator Judge Villanueva, Senator Judge Villar Camille, Senator Judge Villar Mark, Senator Judge Zubiri, the presiding officer, Senator Judge Escudero, Senate President Gatchalian.
With 20 senators present, the chair declares the presence of a quorum. In accordance with the rules of procedure on impeachment trials, the chair now recognizes the duly elected presiding officer to preside over the proceedings of the impeachment court.
Thank you, Mr. Senate President. Before recognizing Senator Judge Padilla, Chair would first like to dispense with the journal. If there are no objections, we dispense with the reading of the journal of July 15, 2026 of the Senate sitting as an impeachment court and shall consider the same as approved. The clerk of court will please call the matter before the impeachment court.
Case number 004-2026 in the matter of impeachment trial of Vice President Sara Zimmerman Duterte.
Appearances for the parties. Appearances for the prosecution.
Good afternoon, Your Honors. Same appearance for the prosecution. We are ready, Your Honor.
Appearances for the respondent.
Good afternoon, Your Honors. Same appearance for the respondent accused. Thank you, Your Honor.
Noted. Senator Judge Padilla, sir, what is your pleasure?
Maraming salamat po sa ating tagapamahalang hukom at sa ating pong ginoong Pangulo. Nais ko lamang pong basahin ng napakaigsing manifestasyon po.
The gentleman may proceed with his manifestation.
Maraming salamat po. A'udhu billahi minash shaitanir rajim. Bismillahirrahmanirrahim. Alhamdulillah rabbil alamin. Aming mga kasama, ako po'y humihingi ng paumanhin sapagkat dito pong nakaraang linggo, lumabas po sa mga balita na may aligasyon na ako daw po ay hindi sumusunod sa batas. Ito po ay nakalulungkot para sa isang senador, sa isang senator judge, ang masabihan na hindi sumusunod sa batas. Samantalang nung tayo po ay merong mahal na saksi dito, pinaalala po natin sa kanya na harapin ang batas. Noong nakaraang linggo, ang atin pong kaibigan na ombudsman, ang sinabi po ng mahal na ombudsman na ako daw po ay hindi sumunod sa kanilang pasabi na mag-file ng aking counter affidavit. Nakakalungkot po ito sapagkat hindi po ito totoo. Inaamin ko po sa inyo kung ICC lang, hindi po talaga ako susunod. Hindi ako magpapasakop sa ICC. Pero dahil ginagalang ko po ang ombudsman, dahil siya po ay aking kaibigan na itinuturing, dahil nagkaroon na po kami ng napakahabang kwentuhan sa aking opisina nung siya po ay kalihim ng hustisya, nag-file po kami. Ito po, hawak ko po ang original. Dahil sa akin po, importante ang original. Ito po ang original, nakalagay po dito. Nag-file ako. Nakalulungkot po na pati ang media ay nakikisama sa ganitong klasing propaganda na ang isang senador ay hindi sumusunod sa batas. Isang senator judge. Ito po, maaari ko po kayong bigyan ng kopya, mga mahal kong kasama, para mapatunayan na hindi ko po kayo ilalagay sa kahihiyan. Ako po ay nag-submit ng aking counter affidavit. At ganun din po Humihiling din po ako sa aking mga kasama, lalong-lalo na po sa aking kaibigan, Ginoong Pangulo, na sa mga ganitong pagkakataon, hinihingi ko po na tulungan din po ninyo kami. Na maipaliwanag din po namin sa media na meron din po kaming mga pagkakataon na ipagtanggol din ang aming sarili at kami wag husgahang kaagad na kami hindi sumusunod sa batas. Yun lamang po, Ginoong Pangulo at tagapangulong hukom. Maraming salamat.
Senators Erwin Tulfo, Senator Judge Alan Cayetano, thereafter Senator Judge Tito Soto are recognized. What is your pleasure, Senator Judge Erwin Tulfo?
Mr. Presiding Officer, Senate President, ladies and gentlemen, this impeachment court was established to try the Vice President of the Republic. Ang punto ko po rito, kasi napapansin ko po ilang araw na nagagamit po natin ang impeachment court, ang oras po ng impeachment court sa pagpapaliwanag. Naintindihan ko po ang posisyon ng aking kaibigan, si Senador Robin Padilla, yung kanya pong frustrations. Pero gusto ko lang po sana ipaalala sa ating presiding officer, sa ating pong Senate President, at matanong ano po ba ang ating ginagamit na rules ngayon? Pwede po ba yung mga problema po labas sa impeachment court na ito o labas sa kaso ng Vice President ay dadalhin natin dito? Di po ba ang korte na ito na itatag para po sana kay Vice President at kay Vice President lamang? Mga ebidensya, mga testimonya, mga pahayag patungkol lamang po sana sa impeachment ng Vice President. Kasi dito pong mga nagdaang araw, Mr. Presiding Officer, Senate President, mga kasama, napansin ko po na nagagamit ang oras po ng impeachment court sa pagtatanggol po ng mga nakaraang araw ng sarili ng ilan sa mga kasamahan natin sa mga akusasyon. This is not the right forum and the right venue and not the right time to explain your situation. Kung gusto po ninyong mag-eksplika ng inyong mga saloobin, problema, maaari naman po ninyong gawin yan sa labas po ng oras ng impeachment court. Maaari pong sa press conference, nandyan naman po ang Senate media. Anytime po, nandoon sila sa Senate briefing room, press briefing room. Maaari din po sa Facebook o sa YouTube magpaliwanag. Huwag po nating gamitin ang oras ng impeachment court sa pagpapaliwanag o sa pagtatanggol ng ating mga sarili simula pa po noong nakaraang linggo. Because the time we waste here to defend ourselves, defend what we believe or what have you, is an injustice to the Vice President. Yung oras po na ito dapat ilaan natin sa pakikinig sa depensa ng Vice Presidente, sa mga akusasyon laban sa Vice Presidente, hindi po pagdidepensa sa mga sarili natin kung tayo inaakusahan ng kung anong mga ahensya, kung tayo po ay may mga kaso, may mga investigasyon. This is not the right forum, Mr. Presiding Officer, Mr. President, Senate President. This is not the right place. This court was established, was created, the impeachment court, for the Vice President and Vice President only. This should be her time. This should be her forum, not our forum here, na ilabas natin ang saloobin natin, mga sagot natin sa mga akusasyon, mga kaso laban sa atin. And this is not also the time, Mr. President, Mr. Presiding Officer, na hanapin yung mga kasama nating nawawala, nakakulong, dapat po doon sa Senado natin, sa sesyon natin, and not here in this court, Mr. Presiding Officer, Mr. Senate President. Kaya pakiusap ko lamang po sana, sa ating mahal na presiding officer and Senate President, let us follow the rules. May rules po tayo. Kung hindi naman ho patungkol sa Vice President na sasabihin natin, hindi naman po patungkol sa depensa o prosekusyon ng Vice Presidente natin, then wag na ho natin payagan na magsalita pa po dito because nasasayang. Because every minute, every hour that we waste away from the defense or from the prosecution of the case of the Vice President, it is injustice. It is called injustice to the Vice President, to her family, yung anguish, yung kanyang sama ng loob, yung oras na nakabinbin ng kaso na ito. Let us do this impeachment trial as quickly as possible. If we have to clear the Vice President, then let's clear her. If we have to prosecute, then prosecute her with the evidence kung meron. Not waste our time kung ano-ano sinasabi natin dito to protect ourselves, to defend ourselves. This is not the right forum, Mr. Presiding Officer.
Kindly wind up,
Mr.
Senator
Senate
Judge
President.
Erwin Tulfo.
This is not the right forum for us to defend ourselves. Bring it somewhere else. Bring it to the press. Bring it to the social media, but not here. Thank you, Mr. President.
The remarks of the gentleman are noted. Earlier, Senator Judge Allen asked to be recognized. Are you yielding in favor of Senator Judge Padilla? And thereafter, Senator Judge Soto. Thereafter, Senator Judge Padilla, before the chair makes a ruling on the matter. Yes, Senator Judge Allen Cayetano is recognized.
Thank you. I'm happy.
You may proceed, sir.
I'm happy I finally heard Senator Judge Erwin Tulfo is concerned about the justice or injustice to Vice President Sara. That's good news. Regarding the waste of time here, sabi ni Senator Joker Arroyo, it is useless to argue a legal point with a non-lawyer. When Senator Marcoleta brought that up here, nagkaroon ng commotion. Senator Miriam stood up here many times and said, kaya ka nga nagpo 4 years na law school at nagbabar. So let me give my own interpretation. The impeachment court is formed with lawyers and non-lawyers. And we interact, and it's for everyone, and we're equal. But if there's an engineer here or a doctor, and they talk about medical principles, I have to either study and argue on medical principles. Hindi ko pwedeng sabihin, hindi, ganito lang yan, logic lang yan, etc. Diba? So, ang legal principle natin today is simple, integrity ng court. So, allow me to mention that to the people and help educate my colleague here. The integrity of the court and the justices or judges is always relevant. So if the Supreme Court or COMELEC, Court of Tax Appeals, Sandigan Bayan is being heard, and the judges are being threatened, you give them time. So we cannot take the impeachment out of context. May nangyayaring flood control scandal, may nangyayaring gulo sa Team Unity na hindi na united ngayon. We consider Senator Marcoleta and Senator Jinggoy political prisoners. Weaponized yung Blue Ribbon Committee at weaponized yung ano. So Mr. President, hindi tama na sabihin na I wasn't, after we brought up the problem with NBI, they doubled down, naggumawa pa ng task force. I mentioned 2 colleagues sa Salian, I didn't accuse them. Sabi ko lang, just like Vice President Sara, just because tumaas ang Salian, can we already ask for the BIR, for the AMLA and the bank accounts. So sabi ko, yan ang i-discuss namin sa Monday. Nag-react na, nag-accuse. I did not take up your accusations here today. Si Secretary Vince Dizon, 3 beses na nag-verify sa Taguig. Sinabi na 3 beses na walang ghost. Ngayon, i-verify ulit. I wasn't going to bring that up, but then i-question ninyo si Senator Padilla. It was all over the news na hindi niya inintindi or he snubbed the ombudsman. I was going to stand up before Senator Erwin stood up just to say, may registered mail. So nung una pa lang, 5 minutes si Senator Tulfo. So I'll take the 5 minutes also if you don't mind.
The gentleman may proceed and kindly be mindful of the time.
Yes, I will now. So I'm just saying, Senator Padilla just stood up to say, sumusunod siya sa batas. Tapos, kaya humaba to, Dahil nga, hindi importante ata dito yung integrity ng judge. Lastly, kaya sinabi kong it's useless to argue a legal point. Ilang beses ko na narinig dito. It's our job to clear or prosecute the Vice President. Hindi po. It's our job to try and to decide. It's the prosecution's job to try to prosecute, and it's the defense job to convince us na wala. Our job is to try and to decide. And when you decide, you acquit or you convict. Why is that important? These are legal terms. Hindi pwedeng yung nanonood na law student ngayon sasabihin, trabaho pala ng judge to clear or to prosecute. Thank you, Mr. Presiding Officer, Mr. Senate President.
Thank you, Senator Judge Alan Cayetano. His remarks are noted. Senator Judge Soto, thereafter, Senator Judge Padilla, thereafter, the presiding officer shall make a ruling. You may proceed, sir. You have 2 minutes.
Yeah, thank you, Mr. President, the presiding officer. I do not have 4 years of law, but I have 29 years of lawmaking. And I move that the